Hey y'all, I'm AdaKay, and I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Good morning, everybody. I hope this finds you well. I hope you rested. Oh my gosh, I did. I didn't even get home until after midnight, close to 1 o'clock in the morning. But boy, did I sleep. It was awesome. Awesome, y'all. I mean, awesome. I had the best sleep I've had in ages. Well, good morning. With that, I am having a specialty coffee today. Yep. It's forgot what they call it. I have an espresso machine back there. Well, we have a wonderful day ahead of us. In about 2 hours, we're going to join the Idaho student murders, Idaho versus Brian Kohlberger, for their hearing. And then we will be, but in the meantime, we have closing arguments for the burned alive murder trial for Craig Lewis. And that we're going to hop into when they go live in about 8 minutes. So with that, we are just getting ready to start our day. I hope y'all are doing well. I hope today is a good day for all of y'all. I got my Raised on Dolly hat. I got my Service Dogs t-shirt on. I am comfortable. I am cozy. And I am happy because while I was here until almost 1 o'clock in the morning, I have a boo-boo. I got all my college work done for the week. And I'm like, yes, I'm early. So I don't have to worry about them for the rest of the week. I am so happy. I am happy. Okay, somebody wants to know what the Kohlberg hearing is about. And it's basically about his death sentence. The Kohlberger legal team has filed a motion seeking to strike the death penalty from his case, citing concerns of the Idaho statutory rights and rights to a speedy trial. That is what this morning is going to be about with Kohlberger. Oh, itchy nose. I can't believe I feel so good this morning. It's awesome. If you're joining me for the first time, thank you so much. Please subscribe. Doesn't hurt. It's not painful. Just take your little mouse cursor, go over to the subscribe and click. That's all you got to do. For those of you who don't know a whole lot about the Craig Lewis trial, he is being accused of unaliving his wife, but in a very slow way. The testimony, basically, in a nutshell, is they got in a disagreement. Supposedly, it's alleged that they were going to get a divorce. He got angry. He over a period of days abused. Hello, it's Britt. Abused her over a couple of days. Long story short, he took a cloth of some kind, a washcloth, or a little towel, something, and lit it ablaze with, I guess, lighter fluid, and threw it on her, and her clothes caught on fire. Thank you. This is what happens when you wake up and feel good, get a great night's sleep, can function, can hold a makeup brush in the morning. Hello, Green Eyes. How are you? Yes, I had a good night's sleep, the best night's sleep I've had in a while. Apparently, um, I don't remember. I vaguely remember falling asleep hugging my doggy, and that's the way it went. That's where we are, and I'm going to stick with that. And slept well. I also made me a specialty coffee here. Um, I have an espresso machine, a really nice one. Um, and haven't had milk at the shop for a while. I keep forgetting to bring it or have it. So I made me a special coffee this morning. Mm. I will be having a regular coffee too, but this one's going to get me a little wired because it's pretty potent. So anyway, back to the Craig Lewis trial. He caught his wife on fire, and then this is what makes me cringe, and it makes me cringe big time because I've been burned. I've had a 3rd-degree burn on my leg. I know how bad that little area compared to hers. Mine was a total area skin about this much. And to think that after being burned, that somebody would take my clothes off of me or make me take them off and change into new clothing and then be driven in a car, put in a wheelchair, and rolled into the emergency room with that new, fresh clothing rubbing on those fresh burns. Oh. And he made it worse because if he had called an ambulance, the ambulance immediately would have started cooling those burns down. And that's not what happened. So they continued to cook until they got to the ER. So it's not a good thing for her. She did live for 10 months and finally succumbed to her injuries. One of the things about people like her who became immobile and her front of her chest was burned. She was scarred from the burns in the front. She also had multiple skin grafts. And you want to talk about pain? Skin grafts suck. They literally just peel the skin off your thighs, your buttocks, sometimes your shin area, sometimes your arms and your back, and then they put it on the burn. So they create a wound to protect another wound. It is brutal. And unfortunately, because of her inability to really move around a whole lot, she got pneumonia and passed away. Yeah, the skin may have peeled off when the clothes were removed. One reason medical professional needs to remove them, and that is so true. But the thing is that people say, well, pneumonia killed her, not him. Well, his burning her caused her to be in the state to which the pneumonia and her weakened lungs. The defense brought up that she had some health issues, some possible damage to her lungs. She had no, um, um, can't say the word, uppers, headlights, because she had the C word. See, you can see cancer, but you can't say headlight cancer. Um, Go figure. But she did have some cancer, and things were removed. And they're saying that radiation caused damage to the lungs. That is most likely not going to be the case. Um, it could happen, but for what she had and how she was treated, it is not a possibility, really. It's a low possibility. But the thing is that we have all been fussing about has been the attorney. Oh, we do not like this attorney at all. We don't like her. She is full of it. Um, okay, I'm going to read you this description. Closing arguments in the case against Craig Lewis, who stands trial after nearly 6 years since he allegedly beat his wife, severely burned his wife. Victim Terry Lewis survived her injuries and lived for 10 months before dying from the complications of those burns. So, yuppers, that is what we're at. So, for those of you who caught Sneaky last night on the live, she did fabulously. And I so adore and love you, girlfriend. And I think that you are going to be very, very well. Um, I love the way you think. I love the way you present yourself, and I really appreciate you. And I was so glad to hop on and support you. Mm, that was a good live. Appreciated it and enjoyed it. So good luck to your YouTube future. Um, we will start putting her link up as soon as I get it. I'm kind of looking for it, guys. Sorry. I'm currently looking for the link. I am going to let's see if they put it in there. There it is. Click on it. I'm getting ready to put it up there. I think that's it. Let me double check. This is super new. So I'm so happy. Happy. This is probably a better link. Nope, it's the same link. Okay. So here is her. Go and hop on with her. So sorry, I'm making sure I get all that right. So go and visit her. She only has 2 videos, but subscribe and like. You will adore her. I'm trying to get to anyway, there we go. It is correct. Okay. So she has 2 videos now. So go hop on over there. She's one of our mods, and I totally adore her. All right, we're waiting for trial. Let me get it up. Add to stage. I hate that it defaults to this screen. I apologize. Trying to find a way to have a little more control over my streams. A little more control. That is my goal. And that rhymed. I'm so sorry. I didn't know I was a poet and didn't know it. I know a young lady who can rhyme so good, but gosh, it's a hard thing to do. Somebody asked, why was I putting my streams a little higher? Because when I pop on a comment, I don't want it covering the stream. That's why. That'd be why. And I don't want, I guess that'll be okay. I missed it last night, but I'll watch it, the replay. Yes, go watch the replay. And she's going to talk more about music and things happening in the culture. And she's going to be probably talking about the trial. I am not. Um, there are very few trials that I will stay away from, and this is one. Um, yeah, just too close to home for me. Okay, we're good to go. Why is it when I do this, it shouldn't do that when I do it? Well, I guess that's it. I guess it's going to. My bad, y'all. And I'm so excited because today I can sit here and I don't have to do homework while I'm watching live. Yay, yes. I'm popping out my chat. I forgot to do it. Okay, there we go. Um, for those of you who don't know, I am a college student at the age of 53. Itchy nose today. And I am getting a degree in criminal justice with focus on law. Um, I know it's late in age, but you know what? That's okay. We can do this. Oh, but these whippersnappers, man, they're killing me. Mm, we're getting close to closing arguments. For those of you who are on, hello, Brit, and can I call you just Green Eyes? Um, is it Bama with a A? Bama? Bama? I dyslexia kills me with some words, and that be one of them. But anyway, do you think he's guilty? I really got a little flustered with the testimony of the daughter because they really attacked her and her credibility. They attacked the fact that she did have a financial, uh, yeah, from Alabama, so it's Bama. Okay, or Linda. Okay, I got it. Bama Green Eyes, we got you. Now I won't forget. Um, they really attacked the daughter because she did uh, take money out of the mother's account while she was hospitalized. But apparently, she was in the process of trying to leave um, Mr. Lewis, and the daughter had loaned her some money, and the mother um, needed to pay her back. But the problem was she needed to have hotel and travel expenses because she was coming to stay with her mother while she was hospitalized, and that is expensive. Um, she wasn't gonna stay in the home with the husband who allegedly did this. So, she used her mother's credit card and, uh, paid herself back and used that money to support herself while in the situation of caring for the mother. So, that to me doesn't bother me at all. That's reasonable. And if I'm in the hospital and I have a child that come in from out of town and staying to help take care of me, and I have money, I'm gonna say, "Hey, here's the card, pay the bill." That is something a parent would do. So, I'm a little bit perplexed as to why the defense tried to make her out to be the bad guy, when in fact she's not brought up on charges. There was some arguing with the estate. They had some issues. Something happened. She was relieved of executor of the estate, but that's family drama. That has nothing to do with whether or not this man unalived the woman. Yeah, the daughter may get 40, $50,000 from this, but to pay her attorney's fees and everything else, that's going to be gone. Just saying. Just saying. I want to thank Court TV for the freedom to allow people like myself to use their feeds. You are absolutely fabulous. We adore you. And I also want to thank you for making it accessible to the hard of hearing and deaf community. It is amazing. And we really appreciate that because let me tell you, it's hard to find trials where you can have that kind of access. That's a good comment. I think she'd rather have her mom than the money. I don't disagree with you in the least. In the least. Uh, yep. Mm-mm. Don't disagree at all. Where are the comments? Oh, there it is. Open. Why can't I open comments? It will not allow me to open. There it is. I am thanking Trial TV Live. Come on. Wow. There we go. That's what I wanted. Okay, let's put that over here. Yay, good morning, Miss Ronnie and Missy Morales. So, guilty or not guilty? I was giving a thank you over to Trial TV Live. I mean, Court TV. I got to get my brain engaged. He's guilty. Daughter has to make. Yep. Yep. And the age difference. Huge. Well, huge. It was like 18 years. Yay. Well, we need some rain. I can only hope that we're going to get some rain. Um, I'm guilty, guilty, guilty. Yeah. Mm. Definitely. Definitely. Well, it is a big age gap, and she was older. And the bomb yesterday was supposedly before he connected with her. He had a relationship with her daughter who was on the stand, and they accused her of becoming with child and then getting a removal of said child prior to birth. And oh my gosh, the defense attacked this woman like you would not believe. Just flat out attacked her. And what's this? Yeah, I'm gonna put that down. I got a lot of windows open. I got to clean it up. But finally the judge said, "Yeah, this is a little much, my dear." Finally, I thought that poor girl was attacked unnecessarily. They were trying to impeach her and attack her credibility. But I don't think it worked. I think it just made them look like bullies. We all have done and made decisions in our lives that we wished we hadn't have. And in that being said, I just felt that their attack was just uncomfortably too much, way too much. Y'all like my Miss Dolly cap that I hand beaded? I did that. Y'all, I am making these for Christmases. So if anybody is interested in a cap for a loved one for Christmas, my viewers get a discount. It's a reversed age gap. She was a cougar for sure. And usually you see the girl being the girl being the younger one. Not to say that they don't work out, but dang.
Good morning, y'all. Be seated. Thank you.
Good morning.
What kind of water?
I gotta move that. Judge has arrived.
Oh yeah. Did we end up printing the copies? Okay, great. So we've got enough for Rita.
Okay.
One for me.
But you're not on the live medium either.
And then one to go back to the jury, right?
And he was having an affair on her.
Okay.
He had girlfriends. I mean, he's just what gets me, look at this dude. He's no Don Juan. He ain't Fabio. He ain't, he's kind of.
Oh, okay.
He does. He sits there with his lip like this.
Nevertheless, we'll just unless you want to.
Eyebrows up. Eyebrows up. Eyes squinch. Mouth down. Just like that.
Go ahead.
No.
I just want to make sure they're for you to read and they're not going to go back to the jury.
What do you mean, the response?
The charges.
The charges?
Yes.
And we're still kind of off the record talking, but.
Yes.
Yeah, you're off the record. You need to mute. Be mute. Yep, this is him. Right away. Okay. Now we're going back to the clock. Yeah, he definitely isn't a looker and definitely is not someone that you would think would be a woman's man. The only thing I can think of is pretending to have more finances that he did, and he was buying them, not paying for the act, but putting himself off to have money and to be able to wine and dine these women when in fact he didn't. It was her. I'm trying to get the mic in a comfortable position today. Sometimes it just, I need to get a different mic stand is what I need to do. But that will have to wait. Yep. He's using what little money that he and his wife had to get the women. I don't disagree with that at all. You can be the ugliest man in the world and have money, and the most beautiful women will just fall all over you till the money's gone. And when the money's gone, they gone, honey boo boo. I don't get that. I don't get how, and it's not just men, but it's primarily men, can have beer bellies, going bald, have hair coming out their nose and ears, the middle-aged to older, and they want a freaking Barbie doll.
Are you all set? Good morning, then. We're back on
Yeah,
the record.
they ain't after you for your heart. They're after you for your money. You want a woman after you for your heart? Look at the officer.
Counsel and had a preliminary
Okay.
discussion with regard
Oh,
to
here we
the
go.
charges for the jury. There were several issues
Trying to place this.
left unsettled and undecided. And Ms. Bright Matthews, I am happy to hear from you on those.
Judge, Mr. Murdoch will argue that motion.
You know, you just told me that. I'm sorry, Mr. Murdoch. I'm happy to hear
Mr.
from you.
Murdoch, are you related
Please, go
to
ahead.
the
Your Honor,
Murdoch?
as you stated yesterday, the
Yes, he is. Look at the hair.
as well as the state had
Yes, he
conversations
is.
to a spoliation
Red
charge.
hair.
If I may approach, I have some case law.
He must be a nephew or a cousin. Look at the hair. It's red.
Your Honor, I'm going to reference back to the Stokes case.
Excuse me.
I believe it's the third page, Your Honor. In the second paragraph here is where the Supreme Court has held that jury charges which advises the jury when evidence is lost or destroyed, a party may, by a party, an inference may be drawn by the jury that the evidence was lost or destroyed by that party would be adverse to that party. And it cites the Kershaw County Board of Education versus Gibson, I believe that's how that's pronounced. Your Honor, the
Problems
the
pronouncing.
spoliation
Don't
charge
matter.
we seek to submit to the jury comes straight from this case, Your Honor. And the state has, in response from yesterday, handed to us a case, State v. Cheeseboro. Your Honor, I believe the state handed you a copy as well. This case, referencing preservation of evidence, is specifically tailored towards establishing a due process violation. Here, we're not arguing that there is any due process violation. We're simply seeking a jury charge to the jury as to spoliation of evidence due to the fact that there was no 911 call preserved in this case. There's been testimony in the case that officers arrived on scene, failed to provide any type of report that could have had any type of evidence, could have been beneficial or exculpatory for a defendant. There also, Your Honor, also handed you another case, which is going to be the Pringle case. If you could reference to the last page of the Pringle case, the Supreme Court's also upheld jury charges when the evidence is lost or destroyed by a party, which is essentially quoting the Gibson case, that a party would have been able to have been which is lost or destroyed, a party would have been able to been adverse to that party. As an initial matter, parties seeking the inference must be prepared to make a showing that the document or evidence might reasonably have supported the presumption being requested by the fact finder. Here, the defense has argued that the only evidence that has allegedly incriminated our client was a 911 phone call from the hospital. There has been no showing of any other evidence that has led to or transpired this entire case other than the 911 phone call. And we believe that it's showing that the 911 call was never preserved would have reasonably supported our presumption that to the jury that that's the only evidence to establish any wrongdoing on behalf of our client. And for those reasons, Your Honor, we think a spoliation charge to the jury would be appropriate.
Let me make sure I'm clear on the motion. The evidence that you're referring to is the audio version of the 911 call. Is that
Yes, Your Honor.
correct? And you're not asserting any bad faith on behalf on the part of the state. Is that correct?
No, Your Honor. The case law specifically says that you do not need to establish any bad faith. Simply that it's been lost or destroyed. There's that or in there. Loss could have several different terms, Your Honor, and I believe as testimony provided that a 911 phone call would be preserved for 3 years. The state's failure to preserve the 911 phone call within the 3-year time period with a case of circumstances as such we have here, would be able to draw, as referring back to the Pringle case, that we could make a showing that the evidence might have reasonably supported our presumption that there is no evidence other than a 911 phone call that the state has relied on in this entire case has transpired. And for that reason, we think the spoliation charge would be appropriate, Your Honor.
Thank you so much. I'm happy to hear from you.
Thank you, Your Honor. I think it's extremely disingenuous to assert that the 911 phone call is the only evidence against Mr. Lewis. However, let's talk about the 911 phone call. The 911 phone call was third-hand information from a staff member at the hospital. That is who called 911 to relay concerns that Leanne had relayed to a staff nurse, to the shift nurse. Leanne testified. She was cross-examined. So there is nothing in that 911 phone call that has not come out. It has come out in extreme detail through Leanne Kellum's testimony.
No problem,
Secondly,
Bama Green Eyes.
the state did hand the court and the defense State versus Cheeseboro, which is a Supreme Court case dealing with a criminal case. Neither one of these appellate court cases deal with a criminal case. And as established in Cheeseboro, there is a specific rule regarding spoliation. The burden is on the defense to demonstrate a due process violation. They're saying, oh, well, we're not asserting a due process violation, but that's the test for a spoliation charge, because they have to show that the state destroyed evidence in bad faith, or that that evidence possessed some sort of exculpatory value before it was destroyed. And there's no way the defendant can obtain evidence that's comparable. Well, the direct evidence from the information
Thank you, Swamp
contained in that
Girl.
911
Thanks
phone
for
call
lurking.
would be Leanne's testimony, because those are the concerns that are being relayed. It's
Keep going. You're not objecting, you're just standing, is that? Okay, all right, go ahead, please.
He was about ready to.
the information that is being relayed to the nurse and that the nurse relays to law enforcement is a concern that the husband may be involved, because Leanne brought that to the hospital's attention. Leanne has testified. She has put all those concerns on the record. She has been cross-examined about those concerns. And the
Boy, was she.
events of the night previous, where there was a violent domestic incident that she witnessed. Again,
Oh.
the defense has not shown any bad faith. There was absolutely no testimony that there was bad faith. We have more reliable evidence in the record than third-hand information that was received from 911. And I will say the information received from that call is contained in the CAD report that was turned over. The only thing that is missing, and it's just because it wasn't preserved, is the voice of the nurse saying, hey, we're calling law enforcement because the daughter of the victim has concerns that husband may have been involved. Thank you.
Thank you. Any
Your Honor,
quick
reply.
final thoughts? Go ahead.
The state's assertion that there's direct evidence for testimony from Mrs. Cronkey on the stand. Mrs. Cronkey never made the phone call. There is no direct evidence that she was the one who made the 911 phone call. And further, if you're inclined to accept the state position on establishing this violation, the second part is, or that the evidence possessed an exculpatory value apparent before the evidence was destroyed, or the defendant, and the defendant cannot obtain other evidence of comparable value. There's only one 911 phone call, Your Honor. There's no way that the defense can obtain any other evidence of any comparable means of the original 911 phone call. There is no other phone call. That was it. And as stated earlier,
Why would there be a 911 phone call?
evidence in this case that this entire case has transpired. There is no direct evidence that this case has transpired. And for those reasons, we believe that the spoliation charge is appropriate.
Thank you so much. Oh, go ahead, please.
Just briefly, the CAD report and the information in that CAD report is comparable evidence. Thank you.
Thank you. I am happy to hear your second motion.
Interesting.
Was there not a second one? There is
No,
a second.
that was it.
That was it. Okay.
Oh, he's like,
All
hallelujah.
right. I had an opportunity to research this issue last night and read some case law about it. And I'm inclined to respectfully deny the motion to add the spoliation charge to the balance of the charges. With regard to the balance of the charges, I've been handed a copy of what I understand is what was, except for what was just stated, what has been agreed to. Have all council had an opportunity to review it?
Yes, I have. I think I sent a couple of changes. I haven't looked at it since then. It was just typographical.
Okay.
And I just have the clerk print that for me, I'll be able to replace it. So it was just some typos.
All right. So
Basically, one word in one place and changing the spelling on another place. But that was only on the arson.
did you send that to council? So we're all,
I sent it to reply all.
all right. Well, I guess, I don't know if we need then to run, a whole tree worth of copies for everything, unless if you can make the one sheet, I'll read from it, and then so the jury doesn't believe that we're all bad spellers, I'll use the one that I'm reading from that'll have the clarifications for the jury. Anything else then before, how long will that be?
She's getting it right
Okay, and you're going to take it apart and reassemble it?
now. Yes.
Okay, fantastic.
And I'll just put it in there.
And the charge will go to the jury, the paper charge. Everyone is in agreement on that?
Yes, sir.
Okay. Anything else then before we bring in the juror?
Nothing from the state.
Did y'all work out where the easel was going to stand?
I'm not using it, and so I think once I'm finished, if Ms. Bright Matthews can have a moment to set up her situation.
As long as you need, yeah, so.
Thank you.
Oh,
No,
I forgot.
he's
Did y'all
out
have an
on
opportunity to
a
read the verdict form?
$100,000 bail.
Yes, sir. No
Everyone in
objection.
agreement
Bonding
on the-
agency, so he had to pay 10 grand. Wonder where he got it. Hmm.
Well, I can't print it that way, so. All right, but thank you. All right, this will be the official verdict form then. All right, sir, can you please bring the jury in?
You may bring the jury.
I love that. I miss you, Dawn, but thanks for communicating with me earlier. Believe it or not, guys, we do end up missing y'all when y'all aren't here. Hi, Kristen. Oh, I have been thinking, and that's dangerous. Like I need anything else to do. I've got something I'm going to start doing in the spring. This is the guy. Uh-oh. He don't look very good. Don't say it. I'm going to be a good girl. I'm going to be a good girl. I'm a good girl. What was that from? Burlesque. From Burlesque. I loved that show. It's a little out of my wheelhouse normally, but I'm not into that kind of show. But wow. What is her name? Is it Christina? Cher and the lead actress and singer. I got her face in front of me. Did a fabulous job. The whole cast. It was a great show.
Good morning.
I'm gonna watch Chicago again.
Hope everyone had a good evening.
Thank you. You may proceed.
Did everyone follow the instructions with regard to speaking with anyone about the case, doing any research, all of that?
Good morning.
Great. Did anyone try to contact any of you with regard to the case? All right then. let's go ahead and begin. Ladies and gentlemen, the parties have presented their evidence in the case. It is now time for the attorneys to make their closing arguments. The arguments of the attorneys are not evidence in this case. Their statements and arguments are meant to help you understand the evidence and apply the law to the evidence. You should disregard any remark, statement, or argument which is not supported by the evidence presented during the trial or the law that I will explain to you after the arguments. Does everyone understand that? All right, then. I'm happy to hear from you, ma'am.
Thank you, Your Honor. May it please the court. Terry Lewis was a survivor of domestic violence, but not for long. Craig made sure of that. And unfortunately, she's not here to tell her story. We hope that his actions and the truth that Leanne spoke to you resonates, and that it's enough for you to hold this man accountable for such a heinous murder. There is no dispute that Craig Lewis was at Wade Hampton when Terry Lewis was set on fire. He places himself.
Oh, my Lord, y'all. I apologize.
The only thing in question is whether this was some terrible accident or if it was an intentional criminal act. I don't want you to get bogged down by all of these peripheral issues that the defense has brought up, these probate court matters, Terry's health issues from 2012 and 2014. She had tremors. She had a balance issue years before. Craig says she lit herself on fire, lighting the same fireplace that she had been lighting for 25 years. None of those issues lend any insight to whether or not Craig set Terry on fire or whether it was an accident. But you know what does? Craig and his actions, as well as the scene. Craig lends us a bunch of insight. The night before he claims Terry lit herself on fire using the same fireplace that she has forever, he gets into a violent domestic with her. Terry, hysterical, calls her daughter, Dianne, 2:00 in the morning to come get her. She's outside with what she could grab. They head on down the road. They have to turn around about half a mile because Terry realizes she doesn't have the keys to the Wade Hampton house. She goes back. She bangs on the door. Craig opens the door, slams it in her face, slams her hand in the door, throws things at her, pushes her down the wheelchair ramp in the back of the trailer. Eventually, he screams at Leanne to take her away before he hurts her. He screams that he has given her everything, but she is cheating on him, and now she gets nothing. Well, how does one ensure that one gets nothing? That sounds like a threat. That sounds like he wants her dead.
Can't do anything about it.
Leanne takes Terry to the Wade Hampton residence, situates her there with her daughter's phone so she can get in touch if anything happens, if anything's going on. She checks on her the next morning. Everything seems fine. When she's at work, she starts getting hang-ups at about 10 a.m. Is that Terry calling for help? That makes sense. Craig's back. Leanne thinks nothing of it until after she's burned on 38% of her body, after she's at the hospital, and then she relays those concerns to the nurse. We don't know how long she was burning while Craig cleaned up. And when he realized she was not dying, he finally decided to take her to the hospital. But what he didn't do was call for any help. Let's talk for a minute about Leanne. She's an only child. She's an only daughter. She's extremely close with her mother. She's a devoted daughter. She was Terry's biggest advocate during her life and during her death. A daughter that would love nothing more than to get her mother back. She got on this stand and told you that Craig was not always bad. Things were not always bad between Craig and Terry. They had a long relationship, but things got bad at the end. The fact that the fact that Leanne does not think that her mother's murderer should benefit financially from the murder of his wife makes sense. It does not make her a dishonest person or a greedy person. In fact, it seems logical, and Leanne simply wants justice for her mother. She has waited 6 long years. This family has suffered. When the defense tried to cross her on her prior statements, it was, how many times did Craig slam her hand in the door? 5? Oh no, I think you said 3. No, was it 4? Okay. That just means she wasn't practicing her testimony. It's not inconsistent with the facts. She told nurses at the ER when she got to the hospital about the domestic because she was concerned that it may not be an accident and wanted police to look into it. So let's talk about when law enforcement was dispatched to make contact with Craig. What was he doing? He was in the carport, hosing down what appeared to be fire debris, cleaning up. When police told him he was being detained, he goes straight to his SUV, starts up the car, and tries to leave. He failed to respond to commands to get out of the vehicle. Several officers had to pull him out of the car. Craig Lewis, if you haven't noticed, is quite a large man. I believe David Long even said he looked like he had lost some weight. So he's far bigger than any of the officers that took the stand. So it did take several of them to pull him out of the car. It's also kind of an awkward thing to do. Regardless, he was eventually detained. But why was he trying to leave? And why did he not call 911? Why is he cleaning up? Why is there a couch missing from the living room that's burned up and thrown in the woods?
Good point.
Why was he clean as a whistle at the hospital? No soot, no burn debris on him, nothing. Terry's clothes aren't burned. Where are Terry's burned clothes? Probably in a smoking fire pit at the Kansas City residence. Why can Craig not answer any questions at the scene after Deputy Mullen gave him Miranda about what happened and how he tried to put the fire out? What do you mean? Because he didn't try and put the fire out. He didn't try to help her. He didn't call for help. The scene tells us a lot, so pay attention to those pictures. We have a wood-burning stove that Craig claims Terry was lighting and it blew back on her. Now, we don't even have any evidence that these doors were open. These doors, as testified to by the crime scene folks, had what appeared to be some of that fire debris residue on the outside, not on the inside. The doors were closed, okay? You can't light a fire with the doors closed. Also, if you look inside the fireplace and around the fireplace, there's cigarette butts, there are things that are flammable, paper over here, there's a chair over here. Nothing is singed around this fireplace. There is no damage to anything around this fireplace. Those cigarette butts are intact except for the part that was smoked. Those cotton ends are not singed. What is singed is a couch that's halfway across the room in the place that Terry would always sit. She always
Yep.
sat to the left, exactly where the couch is burned. That is then located in the woods off Risher Mountain Road. We also have bloody footprints traipsing about the house that come back to Terry from before Craig made her clean up, change clothes, what have you. He obviously wiped her feet off before taking her to the hospital, but DNA doesn't lie. It's Terry's blood in the house of horrors. The other expert testimony we heard about was regarding ignitable fluids. Maybe they were used, maybe they weren't. You heard that they could be present, they can be burned off during a fire, they can evaporate. However, everyone knows that a couch can go up in flames like this. You don't need an accelerant to light a couch on fire or light someone on fire on the couch. Light the couch on fire to light someone on fire. People fall asleep with burning cigarettes and burn their house down. But that's not what's alleged here, because the story that Craig tells is far different, and it has nothing to do with the couch. Terry's burns are not indicative of some sort of blowback from a fireplace accident. A burst of flames from a fireplace would not set her entire body on fire. Her entire front body is on fire. What makes sense?
I just cringe. I just cringe
Craig's
thinking about it.
pins found in the house. They're in evidence. He didn't go to the hospital in these. He wasn't in a big hurry. He was going to clean up. What I found interesting was when the defense was accusing Sergeant Barnadoe of not calling the fire department when he arrived on scene at 3 in the afternoon. We've got Craig with his wife burning to death, not calling the fire department. That's who should have called the fire department when Terry was engulfed in flames. You all have common sense as jurors, and you get to use that in determining the truth. That is your job here. But for Terry being lit on fire, she would not have been bedridden for months. She would not have suffered for months and months and months before contracting pneumonia, to compromise lungs, compromised because she breathed in fire. The ER doctor, Dr. Fisher, told you about the soot and burns that he saw in her mouth. The pathologist, Dr. Beaver, concluded that her death was the result of complications from thermal burns, injuries that she sustained on January 17th of 2019. I'm not asking you to make large leaps in judgment. I'm not asking you to use your imagination. I'm asking you to use your common sense. The circumstances and facts that surround Terry's death point conclusively to Craig being the perpetrator. Things got bad because he was convinced that Terry was cheating on him. Terry got away from Craig that night, but he made sure she wasn't going to get away from him again. He also made sure that she was not going to be able to refute his story, and he stuck around the ER long enough to make sure that she couldn't tell a different one. She was a woman who had been beaten the night before. Her abuser takes her to the hospital and stands watch while she's intubated and goes unconscious. He decided what to tell the hospital and what to tell Leanne. Recall that both the nurse and the ER doctor did not know whether Terry was actually verbal at that stage, and she was intubated within minutes. Dr. Fisher told you that when he reports patient stated X, Y, and Z, it's a whole summary of information that has been relayed in a high stress situation. Their concentration was on treating their patient. Remember that this is a court of record. If there's something I say that doesn't make sense, that is not how you recall the testimony, or something the defense says that is not how you recall the testimony, you can listen to it again. You can request to hear it. Don't necessarily take our words for what was testified to if that's not what you remember. Judge Dukes will charge you on the law. He is the sole judge of the law. I will point out that he will tell you that the state can rely on circumstantial evidence so long as it points conclusively to the defendant. He will also instruct you that you must be convinced beyond a reasonable doubt. And what that means is that you should be firmly convinced of the defendant's guilt to find him guilty. The state need not overcome every single doubt, because that would be impossible, and the doubt must be reasonable. So at this point, Ms. Bright Matthews will get a chance to give you her closing statement, and I will get a chance to briefly respond to any new argument that she brings up. But in the meantime, I really appreciate your attention and time. In this case, it's extremely important to all parties here, in particular, Leanne and her family. Thank you so much.
Ms. Bright Matthews, I understand you need a minute to arrange your
I
exhibits.
think I'll be okay with that.
All right, please proceed then.
Good morning. Thank you for your service. I know a lot of times people don't understand how appreciative I am, the court is, the state, and the defendant is for you giving us your time. It is an important civil duty to serve on a jury. You've been here for 4 days, and on this rainy day, hopefully, this will be the last day you're here for the week. I want to express my thanks to the state, Ms. Swanson, for trying a good case.
That I've never seen before.
She can only try the case with the facts and the evidence that's given to her by the sheriff's department.
But she
You've done a good
wrong,
job
honey.
trying to try this case. I want to thank the court for giving my client, Craig, his day in court, a fair trial.
Oh,
My
God.
team,
You
my
guys?
supporting team.
You guys, do you know what she just did? Anybody want to tell me what she just did? I would love to hear from y'all. What did this woman just do? What did she just do? She just set it up to harm his appeal because she just stated it was a fair trial. She shouldn't have said that at all.
I want to thank Brian Murdoch. This is his first, and he's sitting with me, and I think he's done a fine job. I want to thank Teresa McDonald from my office for helping out with trial. And most importantly, I want to thank my client, Craig Lewis, for putting his life in my hands, for trusting me to zealously advocate for him. And in that regard, I want to say this. If something I personally did that you didn't approve of, Don't take it out on my client. Take it out on me.
I've,
At
I've
the
heard
beginning
that
of
before.
trial, I told you there were some things you would not hear and some evidence you would not see. I told you that there is a lot going on in this case that will require your independent life experiences, your knowledge of Walterboro, your knowledge of the people here. That's invaluable. I did not tell you the story of Terry Lewis, Craig Lewis, and Leanne because I wanted you to hear that story as it developed from the witness stand. What have you heard? Leanne and Craig knew each other first since high school. They're only months apart in age. He would hang out at their house. Craig dropped out of school and moved into the house with Terry and Leanne. Leanne went to college. Craig and Terry fell in love. They began a relationship. He continued to live with Terry for years until 27 when he married the love of his life, who was 23 years older at 49. And Leanne told you that she didn't stay much at the house since then. It may not be pretty. You may not approve, but that's the story. Now let's get to why we're here. We're here because Craig is charged with a horrendous crime, murder and arson. Craig represents the antithesis of why I still practice criminal law, because everyone is presumed innocent. They deserve a fair shot at life. They deserve to be treated fairly. They deserve representations that is guaranteed to them under our Constitution. They deserve to not have trash thrown at them and then wanting to turn it into evidence. They deserve not to be kicked. They deserve not to be boxed. They deserve not to be lied upon. January 17th, Craig rushes his wife to the hospital with serious burn injuries. This is where your common sense as a Walterboro citizen. Everybody knows that Longleaf is where an Academy Road and all of that area near Colleton Prep is very close to the hospital. The hospital's on Robertson Boulevard. What would you do if your spouse is burning? Would you sit there and wait 5 to 10 minutes for the ambulance that's further away? Or would you jump, clothe your wife, since she's burnt her clothes, clothe her and get her to the hospital as quick as possible? That argument about him cleaning up, that doesn't make any sense. And I'll explain to you that further. They arrived at the hospital, from what Dr. Fisher says, uncontroverted by the state. Dr. Fisher says 12:14 is their arrival time. He doesn't say anything about that it looked to be old burn wounds, but yet they want to make it seem like Craig sat there for a long time. He says chief complaint, smoke inhalation, thermal burn. Then he says occurred just, not late, or appeared to be old. He said occurred just prior to arrival. Doesn't get any plainer than that. Then he says, it says her progression is unchanged, but this is the most important part. Context of onset of her injuries. She's painful. It doesn't radiate into her extremities, which means she doesn't have body injuries. Severe pain. Nothing wrong with her eyes. Patient denies any other symptoms. Now, why are we here when we have this statement? And I want you to take this back and read it. 63-year-old female with history of diabetes mellitus, hyperlipidemia, hypertension, thyroid disease, presents to emergency department, complaining of burns onset, once again, to refute what the state has said, just prior to arrival. It doesn't get any simpler than that. Patient states, the patient trying to start a fire in the fireplace with the lighter fluid. Patient states, not husband, patient states the flame shot backwards and caught the patient and her clothes on fire. Patient admits diffuse pain. Patient denies eye pain or vision changes. There are no other complaints at this time. That's real simple. I don't understand why we're here with this statement. Why didn't the sheriff's department read this statement or ask to talk to the doctor? Then there was much ado about what happened after the doctor. At one point, one of the detectives even testified that, oh, he left the hospital quickly. Well, then we refuted that. I had to pull it out of Nurse Bishop, but she finally admitted that because I showed her where she is the one that witnessed at 1431 Craig Lewis's signature. Nurse Bishop is the one. So after the sheriff's department, if they wanted to investigate, saw that, this case should have been over. He didn't just leave as if he was hiding something. He stayed there. As a matter of fact, I was able to get it out of Leanne that he called her a couple of times, said, you need to hurry up, get here. Dr. Fisher talked about how he counseled. He read it to you. I counseled with husband and wife. He told you that after he counseled with them, wife agreed for her intubation. It was to protect her airways, and husband was agreeable to the intubation. Dr. Fisher testified that at 12:27, he intubated her, and it went well. He said after that, all he wanted to do was make sure she got to the Augusta Burn Center. That was the plan. And that's what Craig called and told Leanne. Leanne kept talking about Atlanta at that point, but it was an hour or so later when they had to change the plan because they got a call back from the Augusta Burn Center that, guess what? Unfortunately, the Burn Center in Augusta didn't have a bed. So then they changed course and had to fly her to Atlanta. With this written proof of accidental burn, and with Leanne getting there about 3 hours late after this, that's the first time. And after Craig left, we hear anything about this was not an accident. Well, the problem I have with that is that she didn't go to the doctor. She went to the nurse. Now let's talk about how and I made sure Dr. Fisher got into this because the state on opening, and you rely upon your memory, the state on opening said that Terry Lewis, I remember the state getting up and saying, Terry Lewis on the whole front of her body had third-degree burns. Dr. Fisher explains that third degree is the worst type. First degree is like a sunburn. Second degree is less severe. It wasn't until we got up that we find the consistency to prove accidental. He says she had the worst burns down here. Those with third degree, that's the only place she had third degree. And it wasn't on her foot. No burns on her foot. That wasn't wrapped. And the reason why I'm bending down is because what happens if you're burned on your foot or on your, excuse me, not on your foot. What happens if you get fire caught right here?
I had to stop. What happens when you're sitting on a couch and something is thrown on you like that? You go like this and it falls in your lap and on your legs. And then you bend over to get it off. Honey boo boo, there's more than one way to do this. Sorry.
You bend over and you're trying to get the object off of you. And then what happens is, now this is where common sense comes in. Fire comes up.
I'll be right back.
It doesn't go down. Fire rises. She's bending down, trying to remove the article. And that's when she gets burned up here. That's when the soot moves up. The state would have you think that lighter fluid doesn't cause fire to blow back. But I see commercials on that all the time. I've lit fires myself. It doesn't add up. It makes no sense. I've asked myself 5 years later, why are we still here with the evidence? The only credible, written, unbiased evidence was done by the doctor. One thing I will give Leanne credit for is that she says that when she was in the room with Craig, some 3 hours later, he was sitting in the corner, couldn't talk because he was so distraught. She finally admitted that he was distraught. But the state won't bring that up to you. During the 3 hours, while they're waiting, during the 3 hours, not one nurse, not one PA, not Dr. Fisher detects that there's been anything but a horrific accident. In fact, when Leanne arrives, she describes, after she talks about my client being distraught, he tells her once again, your mom was messing around with the fire. I think he said playing around with the fire. And it went back on her. As they continue to wait in the room, Leanne concocts her own theory. By theory, she described from the witness stand, I was thinking it was a possibility. Well, we can't prove a case on possibility. I was thinking it was a possibility of what happened. She then goes and questions the nurse, and the next thing we know, law enforcement gets called. Things for Craig Lewis changed drastically. First to the hospital comes Shauna Tozier. She talks to Leanne, looks at Terry Lewis's feet, saw that they were clean and untouched, does not talk to the doctor. Wow. Does not secure the video from the hospital. Wow. Does not even interview the nurse or the PA who called. Wow, wow. Then Sheriff Andy Strickland immediately puts out a be on the lookout for Craig Lewis driving a black SUV. They go straight to his house within minutes. Brian Vonnerdo, who went to school with Craig, has known Craig all of their life. Along with David Long, Craig let them in the house. They walk in the house and talk to him. And the next thing I know, they want to know why you didn't call them. Why would you, if your loved one has caught themselves on fire, you're going to protect them and get them to the emergency room. You're not going to sit and call the police department for a fire. After they got their explanation from Craig, he goes to get in his SUV. They told him he could go. He went to get in his SUV. As he's getting in the SUV, he puts in the keys, turns it on, and they swarm on him. And Angela Stallings testified, finally I got it out of that now Craig is as big as he is. She leans into that SUV and leans over him, grabs the key. You ain't going nowhere. It makes sense. Get him out of the car. Well, why not just say, Craig, you need to get out of the car. We need to talk to you some more. No, get him out of the car. You ain't going anywhere. They swarm the back of the house. Within seconds, 12 deputies are there. When Angela gives the command, when she gives the man command, they go to take this 6'6" man down any way they can, but they were trying to slam him next to his truck on the concrete. Craig wouldn't let them. He sidestepped and went down on the grass, and because he took those 2 steps to keep himself from being injured, they kick him and they box him. You know how you can tell he was boxed?
Yes, ma'am.
This little
This is the defenses.
state finally gave us that. That shows what happened. They had no information about what happened, and they did that to a person, a citizen in Colleton County. Then
Y'all, I like
after that
the
happened,
dramatization. It's entertaining.
remember David Long in his testimony? Very evasive. He's the first one in the house. As long as it's Brian Varner on himself, him and Craig can talk very easily. There's no problem. It wasn't until he missed that first swing that he was and gave Craig that he became evasive. He says during the takedown that he didn't want to show me his fist, but I finally got it out of him that he injured that. Angela Stallings told you Craig received a
You
minor
asked,
laceration.
it showed. What are you talking about? There was no resistance. You got injured in the takedown.
Report what that Craig had to
Didn't
be
say Craig
x-rayed
did it.
at the hospital and checked out for the bruises and the kicks that because of what happened to his back and his ribs. Right is right and wrong is wrong. A lie is a lie, no matter what car
I don't
it
know if they
travels in.
drugged him up. Is he
They
under?
should tell
Is
the
he
whole
under
truth.
the
They had
influence
the
of
medical records. You
medication?
know why? Because when you're in custody at the Colleton County, when you're in police custody, they take you to the emergency room. They get your medical records because the county has to pay for it. Because they kicked on him, because they hit on him, the county had to pay for that service. It doesn't make sense. And
He
she calls it,
resisted.
oh, he just got a Band-Aid. You have to look at the demeanor of all, and your jury charge is going to tell you that. Look at the demeanor of all of their testimony. Not one was consistent. David Long says, I gave him his Miranda. Then I believe Kelly Padgett came and said she gave him the Miranda. I don't know who gave him the Miranda. Nobody had a written Miranda form to get it signed out of their car, out of all of those cars. What I find most interesting out of this is Stallings says that she was over dispatch, but yet she did not preserve the 911 recording. Don't you think you would have needed that? They charged this man with murder and arson and didn't listen to the dispatch recording? Oh, come on. And she's the supervisor. She was trained and she didn't think it was necessary to write a report for you? And 5 years later, we got to get her to think about what she said or create a story. She is the lead investigator. She didn't even go back to the hospital. not even 2 miles away from this house. She didn't go to the hospital and even talk to the nurse, talk to the PA, talk to the doctor. No, she didn't. And let me ask you this. From the witness stand, can you tell who was actually in charge of this investigation? I saw a lot of this. No, he was in charge. Jason Chapman said, no, she was in charge. I don't think they know who was in charge. You know why? Because they know they were dropping the ball.
They did
How about
drop
this?
some balls. But
We wouldn't even be here today.
no one's perfect.
If I am to believe 1/10 of what Leanne says from the stand, she says her mama was lucid, I think was the word she used, that after her mama stayed in the hospital in Atlanta and was transferred in May to the Charleston Hospital for rehab, she said her mama was lucid. Well, let's look at that. If her mama was lucid, and if the sheriff department wanted to get to the truth in this case,
Ooh, look
shouldn't
at that look.
one of those investigators have gone to Charleston? It ain't that far away.
Objection, Your Honor. May we approach?
Yes. Let's go.
Why? Creating reasonable doubt. She's like, this B, look at her. She's not happy. And I wouldn't be either. I wouldn't be either. What this woman is doing is throwing her under the bus. Been there, been in that boat. Trying to accuse her to get him out of it. If I was this woman, I would leave the courtroom because I would not sit there and listen to that. I think she's one of the legal people assisting the DA. But I didn't catch everything because she doesn't move her lips. But she said, but this is not something. So what's wrong here? That's what she said. So what's wrong here? Look at the smirk. She won. Wish my hair looked that cute. It never does.
Angela Stallings and Jason Chapman are sitting there pointing their fingers at who's in charge. Craig Lewis sat in jail from the 17th.
I'm sorry, can you rule on that? Was that sustained?
We probably ought to do that outside of the presence of the jury if we're going to actually do that. Did you
Okay,
want to-
this
I
woman,
want to proceed.
Okay, all right.
this
As-
woman, I
and
love
will
it,
start again.
argues like she's a
As
judge.
Angela Stallings and Jason Chapman sat there pointing fingers at who should be in charge of the investigation, my client, Craig Lewis, sat in jail
That's awesome,
from
Chris.
January 17th to February 19th. He, if I go by what has been testified to, had already been Mirandized by 2 officers. Both Jason Chapman, after a little bit of prodding, finally admitted that they never even went over and talked to Craig Lewis to get his story. Perhaps the reason why Chapman and Stallings, as witnesses, were so defensive, at least appearing to me, is because they knew they dropped the ball. Let's look at Kelly Pageant and David Long. Their reports, too, are inconsistent. Does it make sense that both of them would have read Miranda rights? No. Sheriff Anley Strickland goes to the hospital, talks to Craig, and finds the couch that he instructed someone to take to the dump, that Craig had previously had someone to take to the dump on the side of the road. Does this sound like Craig not cooperating? No. They confiscated Craig's phone. Did they bring you the evidence of what they confiscated? Because if so, then they would have been able to go in the phone, dump it, get the information, and back trace on who Craig called to move the sofa as he's sitting there with his wife. We have to think of common sense. They could have found out, they would have found the text and everything. But we don't have that. I don't have the burden of proving anything. He went from the couch and helping them find the couch to lock up. There has been much ado about this burnt couch. Why is the couch so important? I don't know. Who would keep a burning couch or a
Hello,
couch
Dianne.
that has been burnt in their house if they know they're going to be in Atlanta with their wife for fear that it will reignite and burn your whole house down? Doesn't it make sense that he's trying to get ready to head to the burn center in Atlanta? Who carried the burn sofa away? Sheriff's Department had the ability
Dylan,
to have that person here.
I just
And why they put it where they put it, why they put it, it has nothing to do with this case. They confiscated not only Craig's phone, they confiscated his wife's phone. But yet they didn't put any of that in the evidence. And coincidentally, when you became jurors in this case, that's why I asked, do any of you look at crime shows?
you wouldn't want me on
31
here.
days and lockup. Many officers involved in this case. Crickets. Now, you've seen a lot of evidence. All of this evidence here. Look at the sofa. Look at the sofa. Look at the one they got off the side of the road. Look at the blanket that has the smothering burn on it. They didn't test any of that stuff. They knew they had the burden of proof. This sofa has not even been tested to see if it had lighter fluid on it.
What?
Who
Did I miss
would
that?
burn their wife
What?
sitting on a sofa and throw it on their legs first?
Bro.
That's the only part of the sofa that's messed up.
Bruh.
That
I
ain't
heard
good.
some talk
I'll say
of
that.
the door
Good.
to
Good point. You want a
the
point?
fireplace being closed. I didn't enter this in the evidence. They did. They collected the sofa
Hello, Carmen Sponavej.
inserts off the side of the road in the blanket.
I
You
love it.
remember,
Bruh.
Officer Chapman, I had to get him to admit, oh, there's white cotton that look, and if you look a little bit closer, you'll see the singe marks. Did they test that?
Nope.
Now, the other much ado in this case, I will admit, I was like, where would blood come from?
We're doing fabulous today compared to yesterday.
Then
Good sleep.
it made
We had
sense.
3 hours sleep the night before.
Dr. Fisher said, no, you don't find a lot of blood
Yeah, they didn't do the best of investigation
burn.
on this one.
because it cauterizes. So,
Y'all leave some
but they
DNA,
test the
please.
blood prints,
Not
bloody
right.
footprints. Doesn't have anybody here to tell us how
Get a
old those
subscription
bloody
to-
footprints were. Of course, it's her
One
blood.
that's going out
She
the
lives
window.
in the house. She has a lot of medical issues. They don't say when they occurred or how they occurred. They just want you to live on probably, maybe, this how I think it happened. That's not enough. And you know, they talk about this case being an old case. Yeah. Well, it took me asking Miss Lacey or Lacey, I'm not sure how to pronounce her name, that did the DNA. They took the swabs of her, Miss Lewis's DNA when she died on November the 3rd at MUSC. That's when the pathologist collected it. You know when Miss Lacey said she got the swabs to do the comparison? In 2022. All while Craig is languishing. They didn't worry about it. Somebody dropped that ball too. They didn't realize, I believe, that Dr. Fisher would talk about the cauterization of blood. They didn't realize that Shauna Tosia went to the hospital and saw a clean, untouched foot. They don't realize that that the burden is on them to bring a nurse here or bring a doctor here that says, I cleaned off her foot. I cleaned blood off of it. They could have gotten the nurse's notes. They didn't realize you understand when they clean your foot or they clean blood off you, it's usually some type of iodine that will leave a color. She said clean, untouched foot. The wood burning stove. Let me show you what I put into evidence. This is really crazy. Here is the picture. That's defense exhibit number 5. The door is clearly open. There is clearly a lighter fluid can on top of the stove. And yet, no one testified from that witness stand. And it's sort of embarrassing to me. Do you mean to tell me, Colleton County, no one out of those 12 people that came to the scene doing investigations, nobody knows how to lift fingerprints? They didn't even bother to lift fingerprints off of this lighter fluid can. I could bet you if Craig's fingerprints were on there, you would have been presented with that evidence. That's just unbelievable. And yet they come here and try to show you pictures of a closed door with some debris as old as this house looks and as old as this stove looks. They can't tell you when that debris was put there or what happened. They didn't even bother make an attempt to bring you a cause and origin expert. The burden is on the state. They didn't even bother to get someone from the fire department to come and say, hey, this is my specialty. This is what I do. I determine fires. This looks like it's been set this long ago. No. They just want to call Craig a murderer. Then they said, oh, we felt the log. What? You felt the log? And you couldn't get in the house until 5:30, pursuant to the search warrant. If all the fire blew out, there's none going to be in the fire. There's much ado about residue from the house. They didn't even test it, so I don't know why they testified to it. I saw even one that looked like there was dog urine. They talked about that on the floor. I don't understand. You have here some bags. You got a bag which appears to be jeans. They just threw it in to evidence. Didn't test that either. Another bag which appears to be jeans. And she says the reason why she put this in is there was debris on the bottom of the pants leg. So which one was he wearing? They hadn't tested that either. But yet they talk about burn pits he had at his other house. Perhaps it came from that. And wouldn't you expect stuff at somebody's house? They want you to figure out which one is real evidence, because we know he wasn't wearing 2 jeans. We don't even know what he was wearing. Why are we here? The only written evidence we have that an accident happened came from Terry Lewis's own statement to medical experts. This is an accidental burn. This is not an arson. This is not a murder. We're here only because of speculation and possibility. Leanne is the real reason why we're here. No one has shown you how Terry was burned or when Terry was burned. No one has shown when Craig got to the house. Just that he got there in time to save his wife. In order to get to why Leanne made these allegations and why after 5 years Craig is still facing arson and murder charges, I had to go where they say you have to go sometime. I had to follow the money. Follow the money, sometimes you'll find people's motives. The check.
That is true.
I know we live in a digital age, and I know most people don't get their checks. But we have a check here that is Exhibit 6. Says January 15th is the date of the check. It's written to Leanne Kellum, $1,200 for a scribbly signature of Leanne's mother, Terry Lewis, signing it. The same mother who Dr. Rankin said had tremors. In November, she had tremors.
Sometimes they're strong, sometimes they're not.
I submit to you to think about this. This check is on the 15th. Leanne says she was there to their house on Kansas City on the 16th. Everything's copacetic because she's needing money and wanting $25,000 and wanting him to put the house in her name, in his name. Why then would that little story she told about why she wrote this check the day before and that her mama was planning on leaving Craig, why would they do this on Tuesday? She go to the house, this check it would be on Tuesday, January the 15th. She goes to the house on Wednesday. She's texting back and forth, and she's trying to say her mother did this on Tuesday, knowing that she was leaving for Leanne to get her some money so that she could help her mama get out of the marriage. But yet, this is what's telling. Leanne does not cash this check until January 23rd. That tells me that she predated a check to make it look good, but she didn't realize she would have to testify to being up there and up there at the house the day before. Makes no sense whatsoever. Follow the money. I wouldn't blame the state. I wouldn't blame them not wanting me to get into the fact that Leanne, within days of her mama's burning, accidental burning, froze, attempted to freeze Craig's assets. She knew that Craig had inherited cash and that it was in a safety deposit box. She had it frozen by the court when she did her conservatorship. They didn't want me to get into it. Here's the order. It's for you to read. The order is real clear. While she was conservator over her mama's estate, $4,454.90 in expenditures she couldn't account for, and $1,832 of expenditures went to other people, not Terry Lewis. Even though she says she's got reasons why she did it, now she says her mama wanted her to do those things. Who thinks of doing a GoFundMe 4 days after something horrific like this?
A lot of people do, my dear. You'd be surprised how many
thinks of that?
GoFundMes go up
Here's
and
that.
how quickly they go up.
She got the money from that, but because it was in reference to a crime that she was alleging, I wonder why she had to take it down. What's disturbing to me is when asked about the life insurance policy, the life insurance policy was paid for from their joint account, Terry and
He
Craig's
is a
joint
bubba.
account. She tells us that her mother was lucid enough to tell her in May of 2019 that, yes, Leanne, you deserve that money. Go and change that $25,000 life insurance policy to yourself. And you saw her expression. That's when she crossed her legs and says, yes, mom told me to change me, move Craig as beneficiary and put myself as beneficiary. Shortly after us, May, the same May that the life insurance beneficiary was changed, the do not resuscitate was signed by Leanne. And then she starts talking about how mom lost the will to live, would not get out of bed, stopped getting out of the bed, developed pneumonia and bed sores. She says big enough where you could put a fist in. Had to be sent back to Augusta Nursing Home by November 1st. Craig's wife that he took care of. He took care of her through bipolar, dementia, tremors,
Who had the power of
double
attorney?
mastectomy. He stood by her. Craig's wife. He wasn't able to see her from the time he left Colleton Medical.
You know what, guys? This is really driving me crazy. And I'm going to take a break because I can. Number one, she is trying to convict and try Leanne and not focusing on saving her own clients. But I think her focus is off here. I understand she's trying to create the reasonable doubt, but there's a better way to do it. That said, how many people have a second marriage or a first marriage, but the person you're married to is not the parent of your child biologically? Okay. I know many people in that situation who have DNRs that they have asked for a child or blood child and not the current spouse to have the permission or consent or control over. That is not unusual. But yet she's throwing it up there like it's never done. If this woman is in the process of trying to get a divorce, she is a woman who is being battered and is trying to get out of that relationship. She's not going to give him the power to unalive her. So I have no problem with this.
Medical. He has never seen his wife again. Never. His life was forever changed. That was a 25-year investment.
I'm not saying
Perhaps
no,
she
he did it or
didn't
not.
want
I just don't like the
Craig
way this is
to
going.
be with her mother, but that's who he chose. She died, never seen her husband. Perhaps she would have been able to thrive if she had him.
She wanted to leave him.
Because she, from the
Oh,
witness
my
stand, said that her mother got better from the burns. So if her mother got better from the burns, why are we here on murder? Doesn't make any sense. Her mother got better from the burns. She went back to have a neck adjustment. Allegations of the abuse the night before. Let's unpack that bag. What daughter would allow their mother to be treated in the way she described without defending her and, more importantly, calling the police? That is the craziest allegation I've ever heard. Here's the abuse if I listen to what she says. Mom is waiting outside of a dark trailer at 2 o'clock in the morning. I had to elicit from her that mom was actually sitting. Where are the 3 dogs? She doesn't talk about that. She arrives, takes her away, and turns around to get her keys and wallet. First, she said keys and medicine. And then after I asked her about her statement, then she says keys and wallet because she needed to buy cigarettes. But before she said she usually buys her mama her cigarettes. Mom beats on the door and Craig comes to the door, slings the door open, pushes mom down this long ramp, the ramp he made for her because she was falling a lot. You see how long that ramp is? Mom lands on the dirt, which means he would have had to push her with such violent force that she would have tumbled over or whatever. There is no way that you can even buy her story because that is a long ramp. When I asked, where were you parked when you saw it? Because she says it was dark.
Sorry.
Oh, yeah, I guess around here.
Phone call.
Okay. I drove around there. Well, here's what you do. You look at what her vantage point is. Then when she realized where the next question was, she said she got out. What daughter would stand there and let somebody slam their mama's hand in the door one time? What daughter would stand there and let somebody grab their mama's face and slam down into a grill?
She's in fear she's going to be next.
If you look
I
at the
don't know.
picture, if you got the door open, you can't get to the grill.
Interesting. Y'all, I'm trying to drink a whole lot more water. Can't get it all in a day. Ma'am, your time is up. Tick, 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 tick. Is your time up? That young guy is a Murdaugh. He's rated, he's probably, and it's in that same county. He's probably related to Alec Murdaugh. I would have changed my name. Murdaugh is no longer a good name. If I was attorney and my name was Murdaugh, I'd be changing it. At least doing business as somebody else. Y'all. What are you doing? What are you looking for? Communicate with the court, please.
Finds me States Exhibit 48. I want you to look at that and tell me, imagine this at 2:00 in the morning in her story she gave. First, the other thing she said on direct examination, and I want you to remember her body language. I made note of the fact that at that point, her legs were crossed. Her body language changed. I asked her, how many times was this? How many times was the fall? He pushed her down 3 times and you didn't grab your mama who was apparently having a manic or some type of problem?
Sorry. She was not
I'm
ever
totally
fully
befuddled
healed
by
from
it.
those burns. She was not fully healed.
I want you to
Sometimes
look at the grill.
you don't. And burns on the esophagus, the lungs, sometimes. She had to be in a care facility. She had not gone home. She was still
When I
in the
asked
medical care.
Dianne about the falls, she said it was 3. She said he pushed her down. And I said, well, where did she land? Because I wanted to know, he built this ramp for her because of her problems. I wanted to know, where did she fall? On the dirt. Well, look at how long that is. Then he supposedly, and Leanne says she was there. I don't know whether she was on the ramp or there, but I don't have the burden. There's a grill right there. She says that Craig slung open this door. If you sling open the door, oh, come on.
Oh,
Who's gonna stand
objection,
there and
Your
let
Honor.
him? He can't. He would have to put her head around the door in order to slam it. Don't let anybody insult your intelligence. This makes no sense. No
That's
police
your
report.
comment. I'll
What
make it.
daughter is going to allow their mother, who is frail, who has all of these problems, to be attacked? And just hours before you were there asking for $25,000. and a house to be put in Craig's name. I don't know. What daughter wouldn't take their mom, who's such a frail person, to an emergency room? You know she's got problem with instability. You know she has like 9 different chronic health conditions. She's 63 years old. Her head has just, if I go with you, has been slammed into a grill. What daughter would not take their mama to the emergency room? Come on. Was the money more important than mama? Let's talk about Terry's medical condition. Leanne sat right there and said, oh, the tremors had resolved. Well, Dr. Rinkin said in November, she still had the same medical problems. Falls, tremors, dementia. She had the 2014 incident was where she had lithium toxicity and was in the hospital also with falling. Then he said she has a chronic condition of hyperthyroidism. That causes you to be laggy and it causes you to fall sometimes. But most importantly, Dr. Rinkin, who has been treating her since 2010, says that she had never, he said that Terry reported when she had to stay in the hospital on the 4th floor and have the psychological eval, the report that he got, they asked that specific question of any of their patients. And he said the report that he got said Terry had never reported any form of abuse. If the state wanted to give you the truth, wouldn't they have found, before I believe in believing in my client, it helps me fight harder for them. First thing I did was subpoena the sheriff's department and the police department ad infinitum. I want any allegations of abuse. Show me all incident reports coming out of Terry Lewis, Leanne, and Craig. We found reports of other stuff, nothing regarding any criminal domestic violence. And he's not charged and never been charged with criminal domestic violence, nor has Terry been charged with criminal domestic violence.
Objection, Your Honor, arguing facts that are not within the record.
Let's come around here.
As all of the officers came here to testify, not a one testified that Craig Lewis, prior to January 17th, 2019, had ever had a criminal domestic violence. Same thing for Terry. So why are we to believe Leanne? Do you believe Dr. Rinkin on her medical condition or Leanne? Do you believe what Leanne said about Craig's infidelity? Wouldn't Leanne know best whether that story is true? One thing is certain, her relationship with Craig and her thirst for money gives her the motive to lie and concoct a crazy story that we've heard and get him arrested with hopes of him going away and her getting the money. Follow the money. In closing, think of this. There is no way this 6'6" man would burn his wife on her legs to kill her. all those medications she was under, there are many, many ways he could have done that. Why would he kill her? I don't know whether you heard it or not, but when they were talking about the clothes that was taken off Miss Terry, they had to cut her clothes off her. And Terry was so sick, she was wearing Depends. Why come in here and say this was all third-degree burns when you know with a little bit of checking that the worst burns were down bottom? What makes sense? How can he would have had to get on his knee for 6'6"? He would have had to get on the floor to throw something on her or set her on fire. She says, "Oh, Terry always sat in that chair." They got 3 dogs. Look at the chair. Look at the pictures of the chair. And then she said, "I don't go over to the house that much." So how can she testify to that? Where Terry sat? It makes no sense. It makes sense what Terry said. The records don't lie. When she bent over trying to get her clothes off, the fire spread to her face.
Sorry, guys, I have a deaf
Ran
client that's
around
got some
freaking out.
issues
It makes
that I have
sense
to help deal
that
with.
she having tremors, smoking
I gotta go
cigarettes,
interpret.
she's shaking. Some of the lighter fluid got on her pants leg, and then when she lit the fire, it blew back on her. Common sense. And she can't get around that well, so she probably stumbled over to the couch. What does make sense, though, is that Terry Lewis loved Craig, and Craig loved Terry. He loved her so much, she burnt her clothes off. He made sure that she was covered enough and got her into that hospital. Do we have an arson? Do we have a murder? We have only an accident and a miscarriage of justice to my client, Craig Lewis. His wife is gone. And all they seem to care about is getting a pound of flesh.
This
He's
is no
done.
love story, as the defense would have you believe. It simply is not. It is a nightmare. Being burned alive is a complete nightmare. What would you do if your spouse is burning? Not change clothes before going to the hospital. Maybe call someone with some medical training so that they can remove the clothing
Yeah.
from burning flesh. That's why the hospital cut the clothing off of Terry that she came in with, the non-burned clothing, because they didn't want to further injure her. Let's see. Reports don't testify, okay? Doctors and nurses testify. You listened to them testify. Whether or not police talk to those nurses or doctors, they talk to you, so you have that information. Does this look like a stove that flames just came out of? No, it doesn't. And why wasn't this fingerprinted? Why wasn't that fingerprinted? Why wasn't DNA done on this? Because this is in Terry and Craig's home, where their fingerprints would be all over, where their DNA would be all over, because they lived there. DNA, fingerprints would prove nothing, because you can't tell when DNA was placed there, nor when a fingerprint was placed there. Ms. Bright Matthews wants to argue that Craig was distraught. Well, I think Leanne also described the word panicked when she described what he was like, when his demeanor was like. Panicked, because he knew, oh boy, this does not look good for me. let me make some arrangements to get that couch out of here because that doesn't look good. Also, let's talk about the grill. Seems to me, unlike what Miss Matthews told you, that you can actually open the door and get to the grill. So you make that determination. She talked a lot about how Craig was the victim of a police beating. There is no evidence of that. None of these officers testified that they kicked or punched him. He was failing to follow their commands to get out of the car. He was being detained. He did not want to be detained. He is a huge man. They got him out of the car. They took him to the ER. Dr. Fisher told you that he had a scrape on his face, that he complained about possible internal injuries. They x-rayed him. The x-rays were clear. They sent him on to the jail with a couple Advil. He was fine. He is not the victim in this case. I believe Ms. Bright Matthews mentioned that residue from the house that was on the floor was not tested. It was. It's in these cans. Agent Tang testified to it. Unfortunately, it just didn't tell us very much because if there was any ignitable fluid, it could have been evaporated. But we talked about that already, and use your common sense. She wants you to follow the money. Well, if you listen to her version, it sounds like Leanne should be on trial for murder. That she was so greedy that all she wanted from her mom was money, money, money. Craig is on trial for murder.
Why was she allowed to have access to a stove?
Follow the money. Craig screamed at Terry the night before he burned her alive. You are a cheater. You will get nothing. So, let's follow.
He's
the
falling
money.
asleep.
I'm asking you to return a guilty
He's falling
verdict
asleep,
for
y'all.
arson and murder against Craig Lewis. Thank you.
Okay, guys, how long is this verdict going to be?
Thank you so much. We're going to take up a brief matter of law outside of your presence, and then I'll bring you back in for the charge. So if you would take
Have a nice
back.
break before you go deliberate. But y'all, what do you think? This guy has a problem staying away. He may have narcolepsy or something. For those of you who have followed the Delphi trial, their closings are happening today. We are going to have a special guest for our Sunday Night Live. I'm excited, and I'll be looking forward to that. We are having the alternate juror come. Oh, I'm so excited.
Thank you. We had 2 objections during closing in both of those cases. I think the timing of the objection and Ms. Bright Matthews stopping with the comments at that moment may very well have cured it. I'm concerned if I give a curative instruction with regard to those 2 things to the jury, that it'll be more confusing than helpful. Anything from the state on that?
I don't want to draw any more attention to it. I just do want to say that that was completely improper for the defense to ask the jury to consider why police didn't go interview the victim when they actually did, and that was not admissible because it was hearsay.
Look how he's
and the
sitting.
defense did not want
Right.
that in,
Well,
and then they want to argue
let's do
that
this.
that
Wait,
statement
hold
is
on,
not
hold on
in.
1 second. I ruled in your favor on the exclusion of it, and again, I think we stopped it in a timely fashion. So I think that probably handles it because again, I think you.
I don't think you want to draw too much attention to it.
confuse the jury.
Thank you, Your Honor.
Thank you. Ms. Bright Matthews, anything on that subject?
Nothing other than what, in essence, we discussed in sidebar. The issue of lucidity was elicited from the stand by Leanne Kellum, and the issue regarding the interview that she.
It's real
referred
soft.
to
I'm
does
trying to
not
raise
relate
it.
To any officers with Colleton County or that have jurisdiction here.
Okay, thank you for your comments. And let's see, now that this has been handed back to me, has there been a change or?
It was just the formatting. It's.
Oh,
it
the
was just
formatting.
correction that we.
Okay, so I've been handed what I believe is the
Correct.
jury charge that everyone agrees on. Again, I understand the spoliation motion from earlier, which is on the record, my denying the defendant's request for that. So I think we are probably ready. Anything before we bring the jury back in for the charge?
No, Your Honor.
All right, can you bring them back in,
From the
please?
defense, I just said nothing.
Okay. Yes.
Funny how he has glasses around his neck and on his desk. I'm sorry. I'm just maybe one's stronger, one's for distance, and maybe he just forgot. I don't know. But I hope y'all join us on Sunday because it's going to be a good live. It's really going to be a good live. We're going to be diving in to the newest of new information on Sarah Boone. And then we're going to be talking about the Delphi trial by someone who's followed it intensely. And I'm going to let her give us the lowdown. We are also during break here going to be watching the interview of Court TV with the attorneys for Melody Ferris. I watched it last night. We'll be watching that today. So we got some things to do. So, yippers, as my kin would say, yippers. Yeah, if she really was mentally that incapacitated with dementia or tremors, as they're claiming, I mean, you can have tremors that go and come and go. Some tremors are just like this, but when you put a pen and weight in the hand, they can still sign. Just depends on the phase of they're in on the tremors, what's causing the tremors. I know someone that has tremors. If they have nothing in their hands, they tremor, but the moment they hold something, the tremor stops. So, well, I have it on and it says 43 minutes. What channel are you seeing it on? Let me try to find it because the stream that I have up says that it will be streamed in a while. So let me look. Can you tell me who's feeding that trial right now live? I thought we still had almost an hour. Hello? Master Cullen? Yes.
Okay, get comfortable. This may take a few minutes. I'm now going to read you the charge.
448.
Ladies and gentlemen, it is now my duty as the trial judge under the Constitution of this state to charge and instruct you on the law applicable to this case.
Street.
It is your duty as jurors to accept and apply the law as I will now state it to you.
You can
Furthermore,
appreciate
it is your exclusive duty to decide all of the issues of
Suite
fact in this
101.
case and to determine the effect, value, and weight of the evidence. Both the state and the defendant have a right to expect that you will carefully consider and evaluate the evidence and apply the law of this case to it so that in the end, both the state of South Carolina and the defendant will receive a fair and impartial trial. I want you to understand that when I use the word defendant, I refer to Mr. Craig Anthony Lewis. Furthermore, it is important to understand the state of South Carolina charges the defendant with the offenses known as arson first degree and murder.
Got a seatbelt.
To this charge, the defendant has entered a plea of not guilty.
and this is my
To
first.
these charges, the defendant has
I'm not
entered a plea of not guilty. The plea of not guilty places the burden of proof on the state to prove the guilt of the defendant to you, the jury, beyond a reasonable doubt. I remind you that the fact that the defendant was arrested, charged, and indicted in this case is not evidence in this case and cannot be considered by you as evidence of guilt in this case, nor does it create
Is there
any
any way y'all can
presumption
overnight
or
this?
inference
Because
of
I
guilt.
was supposed to be going to
The
a
indictment is
conference
simply the formal written instrument
this
which
weekend.
contains
I
the
have
charge
got
made
that in my
against the
car.
defendant. It is the
Alright,
formal
I have to
document
have
by
a
which
picture
this
of
case is brought into this court. Now, during this trial, you and I have separate duties to perform. As the
Alright.
trial judge, it is my responsibility to preside over
You can
this
text
trial,
me if you wish.
and I also have the duty to rule upon admissibility of the evidence offered during the process of
Thank
this
you.
trial. In that regard, you are to consider only the competent evidence before you and are to disregard from your mind any testimony ordered
soon as
stricken
they
from
go-
the record in this case during the progress.
As soon as this goes to um the jury, we're gonna watch the Brian Kohlberger. I'm not muted. Can you hear me? Test, test. I see I have Mike. And I wonder if he's drugged. If he's taking anti-anxiety meds. That's what he looks like. Okay, let's get this going.
Of the trial, if there was any. And you are to consider only the testimony which has been presented from this witness stand, together with any exhibits admitted into the record of this case and any stipulations of counsel made into the record if there were any. Furthermore, I have the additional duty to charge you on the applicable law of this case, and in that regard, I am the sole judge of the law of the case. It is your duty to accept and apply the law as I state it to you. If you have any preconceived ideas of what the law is or what the law ought to be, and it does not agree with what I tell you the law is, you're obligated under your oath to abandon these preconceptions because you are sworn
I'm gonna zoom.
is outweighed by other evidence. You may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight
I thought I
than
did.
that of any other witness simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it is not contradicted.
I'm sorry.
It is vital to understand that the defendant is presumed under the law to be innocent of these charges. The defendant has no obligation to prove his innocence. It is a fundamental rule of our law that a defendant, irrespective of the seriousness of the charges against him, is always presumed innocent of the crimes for which he is charged, unless and until his guilt has been proven by evidence that satisfies you, the jury, beyond a reasonable doubt. The presumption of innocence is not a mere legal theory or legal phrase. The presumption of innocence is very important, and you need to understand that this presumption accompanies the defendant from the time of his arrest and appearance in this court and continues with the defendant even after you retire to the jury room to deliberate. In other words, the defendant receives the benefit of the presumption of innocence until the very end of this trial, when you, the jury, will deliberate upon the evidence and decide whether the state has proven his guilt beyond a reasonable doubt. Ladies and gentlemen, what is a reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. So even in criminal cases, the law does not require proof that overcomes every possible doubt. However, if based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. Jurors, please understand that reasonable doubt may arise from evidence which has been presented in the case or from lack of evidence in the case. It is your responsibility to determine whether or not reasonable doubt exists as to the guilt of this defendant. I charge you that the defendant is entitled to every reasonable doubt arising in the whole case. If upon any issue of fact essential to conviction and a verdict of guilty, you have a reasonable doubt as to how that issue should be resolved, it would be your duty to resolve that reasonable doubt in favor of the defendant. Thus, in summary, it is important to understand that a defendant is not required to prove his innocence. Instead, the state is required by law to prove every essential element of the offense charged against the defendant by evidence which satisfies you of his guilt beyond a reasonable doubt. Only then can you convict the defendant and find him guilty. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If the circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This burden rests with the state regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. I instruct you and emphasize that the fact the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration on the question of the guilt or innocence of the defendant. It must not be considered by you in any manner whatsoever. A defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberations. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact that the defendant in this case did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove his innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There is no way to prove intent to a mathematical certainty. There is no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be shown from the circumstances shown to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established in the same way as any other fact by taking into consideration the acts of the parties and all of the facts and circumstances in the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. The defendant is charged with arson. The state must prove 3 elements beyond a reasonable doubt to establish arson. Number 1, willful and malicious act. Willful means intentional, that it was not done by accident. A willful act is one done voluntarily and intentionally with the specific intent to do so. I will read that again because I made a mistake that I corrected, but I'll read it again just to make sure. Willful means intentional, that it was not done by accident. A willful act is one done voluntarily and intentionally with the specific intent to do so. Number 2, burning that results in damage to a building, structure, or any property specified, including personal property. The burning must result in damage to the building, structure, or property. It is not necessary that the building, structure, or property be consumed or destroyed, only that it be damaged. The burden is upon the state to prove this beyond a reasonable doubt. Number 3, death or serious bodily injury. The state must prove beyond a reasonable doubt that the death or serious bodily injury to a person resulted either directly or indirectly from the willful and malicious conduct. The defendant is charged with murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse and with an intent to inflict an injury. It is an evil intent. Malice is wrongful intent to injure another person. It indicates a wicked or depraved spirit intent on doing wrong. Malice is a legal term implying wickedness and excluding a just cause or excuse. The term malice indicates a formed purpose and design to do a wrongful act under the circumstances that excludes any legal right to do it. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be express or implied. These terms, express and implied, do not mean different kinds of malice, but merely the manner in which the malice may be shown to exist, either by direct evidence or by circumstantial evidence from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other act of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be shown from conduct showing a total disregard for human life. Ladies and gentlemen, I want you to clearly understand that you are not partisans or advocates for the state of South Carolina or the defendant. It is your duty, by your joint deliberations, to determine the facts in this case, giving the defendant the benefit of every reasonable doubt on each and every issue. Then, to the facts which you determine to be true, you should take and apply the law which has been given to you by this court, and thus arrive at a verdict in this case. Thus, when you have accomplished these responsibilities, you will have satisfied your oath as jurors, and you will have discharged your duty to this court. Once you retire to the jury room, the bailiff will give the verdict form to the foreperson. When you, the jury, arrive at a verdict as to the offenses charged in this case, the foreperson will select the verdict as to that offense on the verdict form. If the state has failed to prove the guilt of the defendant beyond a reasonable doubt, your verdict will be not guilty. Likewise, if the state has proven the guilt of the defendant beyond a reasonable doubt, your verdict will be guilty. Once a decision has been made, the foreperson will check whichever choice is the verdict of the jury as to the offenses charged. The verdict that you render in this case must be the verdict of each and every juror. It must be your unanimous verdict. All 12 jurors must agree on the verdict which you authorize the foreperson to write for the jury. Ladies and gentlemen, I want you to further understand that the order in which the choices of the verdict appear on the verdict form are not suggestive of any verdict on part of this court. The verdict in this case is to be determined by you, the jury, not the court. Furthermore, ladies and gentlemen, please understand that even though we'll give the verdict form to the foreperson, it is not her verdict alone. It is the verdict of all 12 of you. And I emphasize again, it must be unanimous. You must consider the instructions as a whole and not follow some and ignore others. I now ask you to please retire to the jury room, but do not begin your deliberations until you are told to do so. The law requires that I now consult with the attorneys to make sure that I have not left anything out of these instructions. After I have checked with the attorneys, the bailiff will bring in the verdict form and instruct you to begin your deliberations. Also, should you have any question during your deliberations, you must put them in writing and send them to me by the bailiff. The court bailiff will be placed immediately outside of the jury room during your deliberations. If you have questions, please do not write the breakdown of your vote on the paper that you give the bailiff. Once you have reached your verdict, please knock on the jury room door and ask the bailiff to advise the court that you have reached a verdict, and we will return to the courtroom as promptly as possible. We will return you to the courtroom as promptly as possible. Thank you, ladies and gentlemen. You may now retire to the jury room, but again, do not begin your deliberations until you have been advised to do so.
Into this, I'll be right back.
Thank you. Bailiff, would you please separate the alternates into a separate room than the jury room at this time? All right. Other than the spoliation issue that we took up later, which I think is on the record, any comments?
No exceptions to the charge or the jury verdict.
Thank you.
None from the state, thank you.
All right, the charge that I was going to send back with them, when I read, sometimes I draw. So I'm going to get a clean one. We have a clean one? All right, I'm not going to send this one with blue marks that may indicate one part's more important than another. That's just my doodling as I draw. You've got a clean one, right?
I do. It's the format's a little messed up on this one, but it's the exact same thing. As well.
Okay, the format is slightly different on this one. Same words, though. Any objection?
No objection.
Okay.
It's just got spaces.
Can I have a copy for my file, a hard copy for my file?
Yeah, let's do that right now. Let's make a
Of what's
couple
going back.
of what's going back.
I've got
See how many
something
parts
going
there
on.
is.
I'm noticing
Maybe I can just take one of your pages.
in one of, I'm having a Discord glitch, I think.
Yeah,
I think it was mainly,
just take your pen.
you know what, do you have page 19? If we can replace page 19.
That's the one we just printed, yeah, okay.
I'm having a glitch, I think.
Yes, now, because it goes over to the next one. Here you go.
Frustrating.
I can just have it printed real quick. Can you? You also need the parties to agree on that.
Right, thank you. So do we have a 19?
I'm gonna print it for you.
Okay.
We usually get together the exhibits. This time, I think because there's pants and different things, we might need to send back gloves.
Gloves, that's a good thought, thank you. By the way, what we're going to do is not use the bad format one. I'm just going to get a new 19, which is really, I thought I had marked up more than this, but I didn't.
Okay.
And I just made a little squiggle right there. But nevertheless, I'm going to take it out. We'll replace the page 19 with an unmarked page.
I don't know what
And
happened.
then the one that will go back to the jury will be exactly what you all already have. Save us from printing 100 copies here.
Okay, so what we're going to do is let this run. I'm going to mute it. We're going to bring this onto screen, embiggen it, and we are going to now go into the Kohlberger hearing.
Information from security and from Ada County Transport regarding security measures that would need to be taken had the court allowed Mr. Kohlberger to appear in civilian clothes. The state did not object to Mr. Kohlberger appearing with civilian clothes. The court has employed security measures and is comfortable in terms of the security and flight risk related to Mr. Kohlberger with those measures, and therefore has granted the defense motion to allow him to appear in civilian clothes. The first matter we have to take up this morning is the objection to the testimony of Dr. Barbara Wolf related to the method of execution. So let's proceed with that. The state can be heard.
Your Honor, would you like me to
At the
address?
podium, please.
Thank you, Your Honor. Our objection on this witness is really just the rightness issue. We think that this claim is quite clearly several decades early at this point in time, and that's assuming that there's a conviction and imposition of the death penalty. And so we're just trying to save everyone time and would ask that the court find this issue is not right before we have an evidentiary hearing.
All right.
We are now in verdict watch.
Ms. Taylor?
Thank you, Your Honor. Your Honor, Dr. Wolf's proposed testimony is important for the court to hear and to think about the larger issue, and that is Idaho's inability to execute somebody at the given time. And there's a constitutional issue with having somebody sit on death row when there's no meaningful way for them to be executed. And Dr. Wolf's testimony will highlight for the court some information that may come up if Mr. Koberger's ever convicted, and if there's a death penalty, and if he faces firing squad as one of the options.
Well, I also am not particularly convinced about your, well, I'm going to save that till we get to the merits of it. Let's talk about whether we need to hear from Dr. Wolf first, so I can continue.
Your Honor, I think that Dr. Wolf's testimony would provide the court with information about conscious pain and suffering, awareness of that pain and suffering, which matters for the Eighth Amendment, as well as why that information is known by her now. It's more recent information. It's after Idaho's history of having the firing squad and then removing it in light of the Bayes decision, and then in 2023, instituting it again. But this information about consciousness of pain and suffering happens in that window between 2009 and 2023. And I think the court should consider that and have that information. We also need to make a record in the event that there was ever a conviction in this case.
Thank you. Any rebuttal?
Very briefly, Your Honor. I would just note that the defense did submit an affidavit. The court can review that. It clearly indicates what she would testify to if the court were to allow her to testify. So we don't really need to make a record because it already exists in the form of that affidavit. Thank you.
All right, thank you. All right. The court having reviewed the materials, believes that given the concerns about the current justiciability of the, or ripeness, if you will, of the issue, I do believe that the declaration is a sufficient proffer of what that general testimony would be that would allow us to discuss the issue. And so for the time being, I'm not going to hear from Ms. Wolf, or Dr. Wolf, I should say, her testimony. The declaration is an appropriate proffer. I will hear the merits of the motion based upon that proffer next. All right. So let's hear that from the defense.
Thank you, Your Honor. I would ask the court for leave to supplement that declaration, the information that is more recent between 2010 studies and a book that was published that is relied upon by Dr. Wolf. That's not contained in the declaration. And I would like to make that part of the record too from her. So if the court continues to have her testimony not be allowed, I would ask that I be allowed after the fact to make that part of the record.
You can submit that, and I will then hear any objections to that, and I will consider that.
Okay. Thank you, Your Honor. Then moving on to our argument, and I will largely not repeat what's in our brief since the court has had a chance to take a look at that. We think that the court ought to strike the death penalty in this case and not allow the case to go forward as a death penalty case because Idaho does not have a current means of executing anybody. When somebody sits on death row and there's no real means of executing them, that is dehumanizing to that person. That's similar.
Say there's no means under Idaho law, the method of execution is lethal injection, and if unavailable, then the firing squad. You rely significantly on the idea that lethal injection is not available based upon the quote-unquote botched execution of Mr. Creech. It seems to me that was a particularized incident wherein Mr. Creech, the execution really hadn't even begun yet in the sense that they couldn't locate a vein. I don't see how that issue is universal.
I would agree that Mr. Creech's, the situation that happened to him was unique to him. I don't think he's the only person that has ever had that happen. I'm not in the state of Idaho, but I think that that's happened before when the means of execution couldn't be employed at the time. But since we're talking about Idaho, I think we should look at what happened in the Pizzuto case too. And in that case, there was no ability to obtain the chemicals to kill him with. And so his execution, his death warrant expired without him being executed. After that happened, Idaho passed legislation that would allow the Department of Corrections to obtain the chemicals to kill somebody in secrecy. After that happened, there's still a lot of difficulty getting the chemicals because pharmaceutical companies don't like to have
They
their,
have obtained them twice now, since then.
they've obtained them twice for Creech, yes. Now, something has changed in the death chamber for how they will try to execute Creech. I don't know what that is. That's probably one of those things that we'll learn a little bit more about through Creech's.
Well, I think that they're going to utilize a central venous catheter. In other words, accessing a central vein rather than a peripheral vein. My understanding that there's federal law approving that procedure, as well as a recent decision by the district court approving that procedure. I think that's the difference.
And I think, looking forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his execution is moving forward as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm looking at when I'm standing before you representing Mr. Koberger and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston in our
They
briefing,
brought back the
is that it
firing
sat on
squad?
Idaho's books for years. And in
Oh.
2009, it came off in light of the Bays decision. When you think about it coming off in light of the Bays decision, and you look at what's happened since the Bays decision, and we're going to talk about that a little bit later today when we're talking about evolving standards of decency, we'll talk about how things have changed in this country since then. But for these purposes, when you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall from the media at least, that construction's actually underway, but I may be wrong about that.
Well, I haven't talked to the
Testing.
director of the Department of Corrections, and that's probably who
My
I would
mic is
take
giving me a
my
new
word
one.
from if that's actually happening right now. I think there's some additional problems with the firing squad, though. I think there's some problems with the way our statute lays it out, too. If you read our statute, and the court just...
Okay. How does this sound? Because my mic was giving me an error. So I wanted to come in here and kind of see how this sounded. I am shocked that we are sitting here right now talking about a firing squad. Really? A firing squad? Y'all, I sound a little more warm, don't I? Because I didn't like how my mic was a little bit high pitched. Does this sound a little more comfortable than before? Because what I'm getting in my ears, I'm kind of liking. I feel the lower. Hugs to you, Ada. I'm guessing you got head. What does that mean? You might want to clarify that, Haley Bass.
summarized it. It's lethal injection unless it's
No,
not
I had
available, and then it's going to be the firing squad. But the
No
way
headache,
that's
no
written
arthritis,
is that
nothing.
it's firing squad
feeling
unless the
great.
department, the director of the Department of Corrections says, I have the chemicals and we can do lethal injection. And I think there's 5 days that exist for the director of the Department of Corrections to say, no, we have the drugs, we can do lethal injection now. That is problematic. There's not a choice or an election, and other states have an election for the condemned person
Eddie,
to choose
you
from,
have
but
missed
Idaho's
you.
not allowing that. Additionally, the information that I think is really important
We
to
have
the
missed
court is
you
to
greatly.
understand things and advances that have happened in understanding conscious pain and suffering. If
No,
Dr.
we're
Wolf
not
had been
gonna go
allowed to
there.
testify,
Nope, not
she
gonna
would
do it.
tell you that she relies on studies
I
from
was just shocked
2010,
to hear
a working group from 2010, and a book that was
firing squad.
published later than that even, and that's post the Bayes decision. And that talks about understanding what a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist. Thank you, Your Honor.
Can I ask you, even if your motion were right, and even accepting as true that the current means of execution are either unavailable or
And a one
violate the Eighth Amendment as
match.
cruel and unusual, how do you get around Buckwell? You've not provided a alternate means of execution.
We're gonna pause for a second with that question. I want you to see this. We already have something going down in the court. Let's turn it on. I need to ask you a question because I can't hear it myself. Do I sound a little warmer in the tone? It feels different on the ear. Those meds are not easy. Oh, now I'm echoing in my own head. The meds are not easy to obtain. Look at this guy. Okay. You have this man who is supposed to protect the public, and he couldn't tie his own shoe. Look at this. How can he pass and get a weapon and have a badge? That's appalling. Is it bad? Or is it, to me, it just feels lower. My voice was, let's pause. One frustration I had with this mic, it felt very tinny on my ears. Let's go back. Let me see, because I had a mic reset. It sounds like I'm in a tunnel. Okay, let me go back and fix it. Testing. See what I mean? I cleared it. That ain't working at all. Broadcast. Okay. Is that better? I don't know why. Okay, let's get, I'm gonna testing. How about that? Let me get that back up. Let me do this. Testing. How does that sound? Is that better? Testing. 1, 2. Yeah. I'm going to keep talking for a minute. Is that better? The reason why it did a mic reset. I don't know why. Do I still sound like I'm in a tunnel? I think I do. Testing. 1, 2. Testing. Any feedback? Someone help me out. Testing. I'll just leave it here for now. Try to change it a little bit. It's clear to you. Okay. I'm going to gain a little. Is that better? Am I tunnely or is it clear? Perfect. Perfect. Okay. What had happened is it reset and then it gets a little high pitch. So I had to reset. We'll play more with it later. Let's see what this is.
I reviewed, all of the state's evidence was presented at trial.
All right. Good. First, is there any objection to releasing the alternates?
Testing.
No objection from the
Testing.
state.
I'm going to instruct the alternates that they're welcome to leave, and please not discuss the case with anyone until they have heard the verdict, which they're welcome to call back in, or if they would like to simply remain with us, they can sit in the back of the courtroom. Is that acceptable to all?
Yes, sir.
For the alternative.
Wait, say that again.
The jury.
The alternates have lunch coming for them, so I'm going to instruct them if they want to stick around for a few minutes, they can get their lunch, which they can eat somewhere in the courthouse if they want to stay, just not in here, and or they can get it to go.
What is
All right.
the problem about?
Let's see, could you bring the alternates in then, please? But not,
Okay. What is the issue? Yeah. Is this better? Testing. Sorry about that. I had a situation with, for some reason it decided to testing. Is this? No, don't like that. Testing. Okay. Okay. Is this better? Testing. Hey, Haley Mouse. Thank you for joining. Not sure because I'm not able to hear myself. I'm going there. Okay. We're going to leave it here. Okay. Got it. We're good. If there's any more changes, let me know. All right. Turning me down. There we go. All right. Back to this.
don't worry, they're going to bring your lunch to you. I think they're going to check and see if it's here already. You are free to leave, of course, and they'll put that lunch in a bag for you and you can go. If you would like to stay until the rest of this trial, you're welcome to do so. You can just sit in the back, and obviously, as any member of the public, don't say anything or do anything. I would ask you not to discuss anything about the trial until the verdict has come in. And then you are free to do so, like any member of the public, anyone that's been on the jury. The public, however, is not free to contact you if you do not want to be contacted. So if you have that problem, if people contact you and say, I really want to talk about this, and you say no, then, and it becomes a problem, please contact the local clerk of court here and they'll get in touch with me right away and we'll deal with it. No one should really know what your names are or addresses or anything because we've referred to you by community. So I'm sure there are people out there who would recognize you too as you wander down the street. Do you have any questions, either one of you?
No, sir.
Anything to add before I release them from counsel? Okay.
Nothing from the defense.
All right. We haven't found out about the lunch yet.
She just went down the check.
Where can these guys go to? Is there a way to go down that way? Okay. Maybe y'all could go down to the lobby and figure out what happened to lunch for you two. And again, don't bring the food back in here, but if you're welcome to come back in after you eat if you wanted to do that. All right. Thank you very much for your service this week.
So is my sound weird now? We'll have to work on that. I don't know how else to fix it.
Okay. As soon as they're clear, anything from counsel before we begin the deliberations?
No, Your Honor.
Not-
All right, as soon as they're gone, if y'all would please take the exhibits to the jury and the verdict form and the charge, which I think you have in your hand there, and ask them to please begin deliberations. All right, anything else for the record before we go off the record for now? All right, we'll be off the record. Thank you very much.
Okay, guys, I've discovered, and this still doesn't feel right, but we'll play with it in a little bit. Yeah, well, RA is real busy, so I'll text him. All right, we're gonna go back over to the brain. That's a good point.
Constitutional violation?
I definitely hear what the.
Sorry, I
court's
thought I
saying.
had it up. Okay.
I would come back to saying that we're not in the place where he's challenging the methods that's about to be employed. We are decades away from that, if that were to even happen. But what I'm saying is, I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years and years, when the way Idaho's doing it right now isn't really working. It's not a realistic option. I think to have him sit on death row and say, Idaho's going to figure out how to kill you at some point in the future in a way that isn't cruel and unusual and in violation of your rights, I just don't think that the constitutional protections allow that to happen. I think that
So you're saying the anxiety of not knowing is the constitutional violation?
I say that, and I believe that the Troop versus Doles was cited in the brief, and the comparison there is what I'm saying the Constitution doesn't allow. It is anxiety, it is fear, it is the not knowing.
I mean, to be fair, the Idaho Supreme Court just ruled that that anxiety and fear in the Creech case was not sufficient to preclude his execution just this week.
I read that opinion. And I read that, I guess, more particular to the botched execution attempt versus sitting there for decades and not knowing how and if it would happen.
No, but it was anxiety that was the underpinning.
And I don't mean to disrespect what Mr. Creech felt or went through, but you're talking about realistically from February 29th, if this was leap year, until now, and what you're talking about for Mr. Kohberger and what would happen if he were convicted and if he were sentenced to death would be decades. The court just acknowledged that it's decades to sit.
I'd say
And no
a
disrespect to
decade,
the anxiety Mr. Creech felt. I think that must have been horrible for him. But to sit for decades and wonder is a lot longer. And so I understand what the Supreme Court said. I did read that too. But I think it's different when you're just starting out here in this circumstance.
Thank you. Aye.
Your Honor. I'll try and keep this brief. I don't want to repeat much what's in my brief, and I think a lot has already been
I'm
discussed
guilty.
today, but I want to start by pointing out,
I don't
one of
like
the things that
working
Ms. Taylor just said was, looking forward, we
Fair.
don't have
I love
the
you,
answers to that
sir.
yet. Well, that's the whole point, is this just isn't right. We don't know what's going to be available decades from now, and it probably will be decades, plural. If you look at, Idaho's track record, Mr. Creech, Mr. Pizzuto, they were convicted back in the 80s.
Take as true, for the purposes of my question, that the state doesn't have a method. Should defendants be tried for and potentially sentenced to death when the state has no method of execution currently?
Yes, Your Honor, I don't see a problem with that, because deciding the method of execution is not deciding the sentence. The sentence is death. The method of execution is just how that's brought about. And so even the United States Supreme Court has recognized that someone who was convicted and sentenced to death, in that case, I believe it was hanging, and then after he was sentenced to death, the state passed a law, made it electrocution, and the U.S. Supreme Court said there's no ex post facto problem with that, because you're not changing the penalty. The penalty is death. And so even if you assume that Idaho cannot do
Very
lethal
good point.
injection, and even if you assume that the firing squad is unconstitutional, that's not to say that decades from now, there is not going to be a method by which the state could put him to death. And then, of course, I was accepting the hypothetical as proposed, but we would strongly push back on this idea that Idaho doesn't have a method of execution. There was a scheduled execution to take place on November 13th, just days from now, that was only stopped because the federal district court entered a stay so that it had time to consider some additional claims. But in that case, Director T. Walt put in an affidavit that said, we have the chemicals, we can do this. We've modified the procedure to address the individualized problem that came up with Mr. Creech before, and so we can execute Mr. Creech. So there really is just no evidence whatsoever to suggest that Idaho can't do this, and certainly not that it can't do this decades from now. And again, that gets back to the rightness issue. Is it may be lethal injection, it may not, it may be some other method, but we just don't know enough now, frankly, to spend the time and the effort debating what we don't know in the future. That's the entire reason the rightness doctrine exists. I also want to speak just briefly on the Bucklew point that the court brought up. You know, what I'm hearing from the defense is they just have this kind of like vague Eighth Amendment assertion of maybe it's kind of the anxiety, but kind of not knowing how you're going to be executed. Well, that's not how the law works. There's an established framework of how you can make an Eighth Amendment method of execution claim. And Bucklew, the court specifically said, I'm quoting here, identifying an available alternative is a requirement of all, and all is emphasized in the decision, all Eighth Amendment methods of execution claims. You can't get around that by just saying, well, but I'm making a slightly different kind of claim. It's not a method of execution claim, it's a means of execution claim. That just doesn't work. That's not how the law operates. And so they haven't even suggested, even today, an argument what a proper alternative would be, which also gets back to the ripeness issue, which is we don't know decades from now what an alternative might be. Maybe they'll have a better argument decades from now on the method of execution because maybe there will be a better method. And that gets to the final point I want to bring up, which is the remedy here. You know, they're asking that the death penalty be struck because these methods are unconstitutional, but that's not how it works. If you show that one method is unconstitutional, part of the reason you have to present a viable, readily implemented
There's
alternative
enough
is so that the
method.
state can then use that method for the execution.
Yep.
You don't get to, at the beginning, short circuit the whole thing and say death is off the table because the current method is unconstitutional. As I said before, the method could change. And so if they came in and they had evidence and they could show that there was another method that's not lethal injection, that's not firing squad, that severely or significantly reduces the pain, and it's readily implemented, the answer isn't to strike it, the death penalty completely. It's to say, okay, you can move forward with the trial. We can see if he's sentenced to death, but you can't use those two methods to do it. If the state wants to pass a law and do this other method that he's proposed, then you can do it that way. So for all those reasons, Your Honor, unless there's any further questions, we'd ask that the court deny the motion.
Thank you. Any rebuttal?
Just briefly, Your Honor. The distinction is not us being on death row with a death warrant that we're talking about. That's a different kind of conversation. We're well before looking at the overall picture and saying the Constitution protects somebody from sitting in prison when there's not a real means to execute.
Do you
I
have any
understand.
case that says that?
I'm making an analogy with the troop versus duels and the denaturalization with the dehumanization that happens if somebody sits on death row when there's not a realistic way to execute. I understand that lethal injection has not been overruled. I understand that. But when we're talking about the recent history of what's happened in Idaho, there are problems, and there are real problems. We talked about Pizzuto, we talked about Creech, we talked about two pieces of legislation to try to make this work, and it just doesn't work. So we're in a position where I'm not with a client that has a death warrant, and we're talking about whatever they'll probably talk about with Creech, with how they're going to do injection. We're not talking about the marksman involved in a firing squad. We're talking about way back here when we're sitting with constitutional protections, and Idaho's got all these problems with executing somebody. And how is that right, fair, any protection under the Constitution for somebody to have to sit there and just wait for Idaho to figure it out? That's the difference in our argument. That's it. Thank you.
Thank you.
Yeah. You just stay in for life until the means happens.
All right, court will take that
Death
issue under
penalty
advisement and issue a written
could
opinion
still be on the
with respect
table. It's
to,
just when.
its ruling. Next, I want to take up the objection to Professor Cover's testimony.
Why are you so soft-spoken, Your Honor?
Your Honor, as the state pointed out in its written objection,
Professor Cover's testimony is
Is it
largely,
cover or covert?
I believe, I'll defer to defense counsel. Is it?
It's covered.
Cover, thank you.
Thank you, counsel. Professor Cover's testimony in this case would largely center around a legal analysis that she conducted over several other murder cases throughout Idaho. Now, the first reason that this isn't appropriate is because legal conclusions are just not the appropriate subject of expert testimony. The state cited to Ybarra in its objection, and in Ybarra, the Idaho Supreme Court held that legal conclusions by an expert were not proper for consideration before the court. Now, that expert was allowed to testify as to factual conclusions, but the court struck legal conclusions from that expert's declaration. Additionally, as the state also pointed out in its written objection, the Idaho Supreme Court straight up rejected a similar attempt to do an analysis over first-degree murder cases in an attempt to argue that Idaho's statutory scheme doesn't accomplish narrowing. And so I think the court can look to the Hairston case where it was an almost identical argument, and the court found that it simply wasn't relevant, and also preclude Professor Cover from testifying on that basis as well. When the state received the PowerPoint that Professor Cover would be utilizing, many of these slides are simply excerpts from statutes. This PowerPoint itself is titled An Empirical and Constitutional Analysis, and that's largely what her testimony would be, which is a constitutional analysis leading to her conclusion that Idaho's statutory scheme just doesn't accomplish narrowing. This is a legal argument, and the state would ask the court to preclude her from testifying on that basis. Thank you, Your Honor.
Good morning, Your Honor. The first argument that I'd like to address relates to Hidalgo. And in the Hidalgo case, the state of Arizona had actually conceded that there were statutory problems. And when the Supreme Court took that into consideration, the reason that they did not issue a cert was that they wanted a robust discussion about gathered data, analysis, and have that come under the scrutiny of cross-examination. And so that's my first point to you today, is that the United States Supreme Court wants what we're wanting to accomplish here today with Professor Cover. They want that discussion to occur so that the data is and studies are scrutinized and discussed, and a trial court like you has the ability to make a full assessment. Reading a paper doesn't allow you to do that the way that the expert who did the study can explain it. The other point that I want to make is that as it relates to the Hairston case, I pulled the underlying briefing in that. So the underlying briefing in Hairston was a direct appeal and a post-conviction appeal, and they were consolidated. And the study that Dr. Jensen did was nowhere even close to what the study that Dr. Cover did.
But the court's thrust was that the legal analysis is not whether the statutory aggregators cumulatively narrow the class of first-degree murders eligible for the death penalty. That's not a relevant legal analysis. The legal analysis is whether an individual aggravator does so, that it excludes rationally first-degree from among first-degree murders within that particular aggravator. And as I understand Hairston, it's just not a relevant issue. It's not a legally, it's not an issue that upon which the question turns.
Well, Hairston was decided
That I'm a trial court and not the Supreme Court.
I know, I'm sorry I interrupted you.
No, that's
Hairston
okay.
was decided in 1999, which was a long time before Hidalgo was decided. And so the United States Supreme Court has absolutely made the issue ripe and said, we want to hear what the specific data is, and we extend the invitation for that to be done. The study in Hairston was framed as, did Idaho's method of compelling financially burdened counties to bear the cost of litigation in capital cases result in arbitrary and
That was
capricious
the claim of
application?
geographic discrimination.
Pardon?
Wasn't that the claim of geographic discrimination?
It was based on money and whether or not an urban
That's
versus a
different from
non-urban.
the issue of what the relevant legal framework is with respect to whether or not the aggravators are overbroad or over-inclusive.
I
as a
agree.
whole.
I agree. But before we get to even there, Judge, which would come under our motions to strike, the heinous, atrocious, and cruel, and utter disregard, and propensity, the other motions that we have before you, we first have to focus on the eligibility and looking at eligibility of the death penalty in the state of Idaho, which is a legislative function that looks at the statute and then the aggravators as a method of narrowing, and whether or not that results in arbitrary and capricious application for purposes of the Eighth Amendment. And that's what Professor Cover's study addresses.
Correct. It doesn't address whether an individual aggravator is itself overly inclusive. It doesn't do it based on, in fact, she generalizes the aggravators as quote unquote the fuzzy ones, I think is what she called it. And then the, I can't remember what the name.
Clear.
The clear ones
Right.
were.
Right. But it is her study is a good foundation when you're get into the next level of looking at those aggravators and the definition of fuzzy and what that really means in terms of the analysis to strike those individually. So we have to begin with looking at whether or not we should even be getting there in the selection process.
Right. But I guess my concern is that the Supreme Court, the outer Supreme Court has said that that's not the issue. When we look at whether the aggravators are unconstitutional as being not sufficiently narrowing of the class of persons or
Good
crimes
morning.
available for the death penalty, the Supreme Court specifically rejected a approach that is based on the cumulative effect of the aggravators together. It said you have to look at each individual
45 minutes.
and ask with respect to that aggravator, does it exclude sufficiently? Am I wrong about that?
You did great.
I don't disagree with what your statement is. I'm saying that we've got to start before that with the analysis of who is eligible
Right, but that's
to
the
be
point.
charged with the death penalty.
That's
But it begins, Judge, with the definition of first-degree murder. You start with the definition, which is very broad, of first-degree murder,
which is why the aggravators are required.
right? And then you look at what happens within those aggravators. And we are arguing about the individual nature of those aggravators in other motions. So, these are different arguments.
But you, in those other motions, didn't rely upon Dr. Cover's article.
No, that's true, but it still comes to the issue. You still have to look at the issue of eligibility before you get there.
But the aggravator is the eligibility.
It's a part of the analysis.
I mean, everyone agrees the statute itself as to first-degree murders that are eligible is, without more, unconstitutionally vague. That's why the court has, U.S. Supreme Court then later approved statutory aggravators, including with judicial gloss, right? And so then the question, the court has said, the Supreme Court of Idaho has said, and the Supreme Court of Arizona has said is, and other courts, not whether, when you look at all the aggravators together, cumulatively, do those sufficiently narrow? The question is, when you look at an individual aggravator, does it exclude first-degree murders from it? Does it narrow first-degree murders? And you look at those each individually and not cumulatively. My understanding is that Professor covers analysis is that taken as a whole, these don't accomplish that. Is that accurate?
I would yield to her to testify to that, Judge.
Well, I've read our law review article, and that's what she
That's the
says.
purpose of having her testify. I think that it comes in segments, and you have to begin with the definition, then you have to get to the aggravators, and then you have to look at what is the quantity of cases in Idaho that fall within both of those, pair it against what the result is for it being arbitrary and capricious. And when you're talking about our court, the Hidalgo case is from the United States Supreme Court, post-states what our court said in Hairston.
The other concern I have,
Multiple
I'll say
concerns.
that. I'm just now thinking about whether I need Dr. Cover. Why can't I rely on her law review article as a proffer of what her testimony would be?
Well, Judge, you are the trier of fact here, and it's important that you listen to, I believe, to make a reasoned decision, hear testimony, and hear that testimony be confronted and cross-examined.
Let me clarify, Carmen. I'm having AJ, alternate juror, on our live on Sunday. Yay! At 7:00 Central Time, and we're going to be talking about Boone, and she is also going to be talking about the Delphi trial. So yes, that will be Sunday at 7. Sorry.
And that's what the United States Supreme Court said. I mean, if the state were to stand up here right now and say, hey, we can see the statute's overbroad, the aggravators 11, everybody fits. What the United States Supreme Court has said is, we appreciate that concession, Arizona. It may genuinely exist, but we are a justice system where we want to hear that data talked about. We want to hear those issues confronted. We want to hear that debated. And so as a trial judge in this case, this is the appropriate time for you to hear that so that you can make a reasoned decision, not just based on her paper, but based on her explanation. One of the arguments that the state has made is that, we don't know what she's gathered, what her methods are. Well, she'll be able to testify to that, to explain that to the court, what her approach was. And it was different than what happened in Hairston years ago. And so for that reason, this court should hear that so that you can make a reasoned decision.
I thought she said SH. I thought we had a bad word. I was going to go, whoa.
Your Honor, I'd like to address the foundation issue, because even if this court were to use the denial of cert in the Hidalgo case as a basis to delve into this issue at this time, Professor Cover's data does not provide adequate foundation to be reliable enough for the court to do that. And what I mean by that is that if you look at the Excel spreadsheet that was provided as an exhibit, I would direct the court's attention to just 4 examples. Line 22, the Nuxall case, death notice was not filed in that case. And Professor Cover did a review of the documents that were available to her and labeled that case as clear hack. Now, the significance to her designation as clear hack is that elsewhere, when she designates cases as hack or utter disregard or propensity, which she describes as fuzzy aggravators, she doesn't designate everyone as a clear aggravator. She only designates this one in particular, and potentially others, as clear, which then calls into question, well, are the others not clear? And potentially did the prosecutors who were determining whether or not to file death perhaps have more information available to them that enabled them to determine that, in fact, that those aggravators did not apply? The next I would direct the court's attention to would be the Huntsman case, line 33 in that spreadsheet. That case was labeled utter disregard / propensity ? Again, if Professor Cover can't determine for sure whether or not these labels apply and has to place a question mark in there, and she's relying on the court record, not necessarily the entire body of evidence that the state would have had before it when it determined whether or not to file that notice, again, she isn't even sure herself, at least according to the spreadsheet, if those designations apply. Carlos Alonso Sandoval, line 44, her notes indicate possible hack. No death notice was filed, and according to that spreadsheet, it would have been included in her study. Yet she writes possible hack. And there was no clear aggravator in that case, I believe, Your Honor, which means that, again, we're including this case based on the fact that she's designating that it might apply, possible hack. Finally, I would point the court's attention to line 52, Angela Cervantes. The state did not file a notice of death in that case. Now, there was a clear aggravator, according to her, for kidnapping. But again, when she lists whether or not a fuzzy aggravator applies, she writes utter disregard with a question mark. Again, Dr. Cover is relying, according to her article, on documents she was able to obtain from transcripts from the state appellate public defender's office. She did not indicate in her article that she had, I don't think she even argues that she had the same body of evidence that the prosecutor would have had in each of those cases, making those determinations. So what's essentially happening, and this kind of brings us full circle to the legal analysis issue with all of this, is that she's reviewing court records, making a legal determination that's different than the prosecutor who made that determination whether or not to file a notice of death, intent to seek the death penalty. This is not a reliable body of evidence upon which the court could even make that determination, if the court even wants to consider it as evidence, which in the state's position, it's really just a legal analysis where Professor Cover is just reaching a different legal conclusion based on court records and providing a statutory analysis. And so the state would just argue that her article is a sufficient proffer. We would ask the court to grant the state's motion and to disallow her from testifying today. Thank you, Your Honor.
Thank you. Rebuttal? Oh, actually, that was the rebuttal.
Cameron, I'm
I
loving this.
will indulge you
Y'all,
for- My schedule is already shot to hell, but we'll indulge you.
Judge, we will be able to get through in one day. I think that what the argument that the state just made feeds my point, which is they're drawing conclusions off of the raw data without talking to the expert. You know, when an expert provides their spreadsheets and has notes without asking Professor Cover what a question mark means, what the exact records were, why she used those records, why the conclusions she drew were drawn. You have, first of all, you don't have the exhibit because it has not been admitted. It's been provided to them because they were raising issues about wanting to see the data. Where if she's allowed to testify, she can talk about that.
This is the data that she used with respect to her law review article.
Correct. To draw her conclusions and do her study. And so.
And that law review article was as of 2019?
Yes. Yeah. Yes. And so I think that the state just actually made the exact point that I'm trying to make to you. Thank you.
So since I have you, you brought up Hidalgo, and you talked about the Supreme Court doing this. My reading of Hidalgo is that cert was denied. A minority of justices issued their own statement in which they thought it would be important to gather additional information. The court itself did not. Am I correct about that?
Well, you're correct that cert was denied, but Hidalgo has been viewed across the United States as an invitation. It's not just Idaho that's done this done a study. Other states have done the same at the invitation of the Supreme Court.
An
because
invitation of 4 of 9 justices of the Supreme Court.
Correct. It's still an invitation, and it's been accepted as an invitation.
Thank you. So I don't find that the proffered testimony of Dr. Cover will be relevant or helpful to the court to decide this issue. I think that I can rely upon her law review article and the data that I understand that has been provided today as a proffer of what that testimony would be. Of course, the constitutionality of Idaho's capital sentencing scheme is a question of law. Whether to allow expert testimony is committed to this court's discretion, specifically the well-known 4-part My Fun Life standard. Opinions as to the law are generally not admissible by experts. The court is the determiner of questions of law and not what somebody else's opinion of what the law is. Opinions of what the law is are received by the court through counsel, not through expert witnesses. And so generally I would not have permitted expert conclusions about the law. And therefore her opinions are neither relevant nor helpful, and therefore not admissible. Importantly, of course, as we've talked about, Idaho has opted to satisfy the constitutional narrowing requirements from the U.S. Supreme Court through the adoption of statutory aggravators rather than through narrow definitions of capital offenses. The relevant, as I understand from reading her article, Professor Cover's analysis is offered to support the argument that collectively Idaho's statutory aggravators do not sufficiently narrow those first-degree murders, which would qualify for the death penalty. But that is not the question that the court must answer. The relevant question is whether a particular individual aggravator provides a principled basis for distinguishing between those who deserve the death penalty and those who do not. The Hairston case, I believe, makes that clear. The court is bound by binding precedent of the Idaho Supreme Court on this issue. And therefore, I don't feel the need to take Dr. Cover's testimony. I think the issue is sufficiently preserved through her law review article and the data that was provided. Now, if I look at this when I write this issue up, I certainly can invite counsel and Dr. Cover back at a later date to provide that information or to help clarify some of that information. So from that perspective, I don't think Dr. Cover's testimony is needed this morning. Now, I'm not going to preclude the argument on the merits using Dr. Cover's analysis, because certainly counsel has the right to make a record of their argument on that as well. And so I will hear argument on the merits of the motion to strike the aggravators writ whole. This is not the argument on the individual aggravators, but on the collective aggravators.
We are asking the court to strike the death penalty because in Idaho, there is no narrowing of eligibility, which results in arbitrary imposition of a death sentence. We are also asking the court to strike the death penalty as a violation of the Equal Protection Clause. I will argue narrowing first. When it comes to the determination of eligibility It begins with the definition of first-degree murder. And when the definition of first-degree murder is looked at, then the next thing that happens is looking at statutory aggravators. And the reason that those two things exist in Idaho and those steps in analysis exist in the United States is because of the Furman case. It's important to distinguish between eligibility to be charged and selection, which is at a post-conviction phase of a case. And so our argument and our focus for this issue is on the eligibility phase. What
Your argument
defendants-
doesn't consider the weighing of mitigators against the aggravators is what you're saying, and the appellate review available. You're simply focusing on whether collectively the statutory aggravators narrow the class.
Let me answer the mitigation question first. Mitigation is in the selection
Right.
phase.
That's what I'm saying.
So I'm not arguing about that. I'm going to step and grab my water.
Sure.
I want to be clear about the argument and eligibility, that I'm talking about the definition of first-degree murder and the aggravator statute, because our definition is so broad that there is no narrowing there. And so that is an important first step that the prosecutor in their discretion, they're looking at, and there's essentially no guidance with the first degree definition. And so you do get to the narrowing factors, which is the duty of the legislature that cannot be abrogated to any other branch to fix when there is no proper narrowing. Professor Cover concluded that when you analyze those things with the 195 cases that she reviewed and collected data on against the number of death verdicts, which is so low, that you end up with a statistic that is worse than the statistic that the Supreme Court struck down in Furman.
Well,
And
so the Furman's an interesting decision, right? Because while I recognize two of the justices talked about those specific statistics, I don't know that those specific statistics are in fact a binding opinion of the court. There's much more in Furman apart from the statistics that two justices relied on.
And I don't
I
disagree
am
with
enjoying
that,
your
but it's certainly
answers so
guidance for
much.
the court.
You
You know, if you're not, when you're not hearing testimony from the expert to explain everything that was taken into consideration in the conclusions that she drew, then what I'm going to do is take it at the high level that Furman is the guidance of those statistics. Her statistics show that Idaho's were vastly worse. And so it's certainly something that the court needs to take into consideration in terms of whether or not there is the ability to narrow in the state of Idaho. The conclusion from the expert who did the study here is that there is no narrowing.
And my question was more a legal one, which is the analysis by Dr. Cover in her extensive law review article takes as its starting point that you have to have a statistic below that identified by the two justices in Furman.
Your Honor, I guess I disagree that that's where she draws a hard line there. I think that it's guidance.
Okay.
And there were other states that she looked at that she could certainly, if she testified, explain what was going on in all of the things that were going on in her analysis. But I don't know that my interpretation is that there's this hard and fast line, but certainly we have a line that the United States Supreme Court looked at, and Idaho's is worse.
There you go.
So the problem when you have no narrowing is that instead of it being a situation where the worst of the worst are being charged with the death penalty, everyone falls within that category. And that cannot be remedied by anyone else other than the legislature, because that is their duty. And if there's no narrowing, then and it's arbitrary, then that's a basis for this court to strike the death penalty. There were, when Dr. Cover did her study, she looked at other states that did a better job of narrowing in statutory aggravating factors. And I want to give the court an example of what that looks like. In the state of Oregon, which actually is on pause with its death penalty right now, a narrowed statute there is the murder of two or more people or terrorism while in custody and after a previous homicide conviction, premeditation and against a child under 14 years of age, or premeditation and against a police officer or an other officer. So that's an example of how a legislature can certainly make an attempt at getting factors much more narrowed and tailored. Now, Oregon's hasn't been, as I understand it, has not been taken up on appeal, so it hasn't been analyzed at this level, and the death penalty is on pause there. But it is an example of a statute that can be narrowed. The other thing that I wanted to point out is that the state of California versus Tulipa, and I hope I'm saying that name right, has a statute for aggravators that in and of itself carries a whole bunch of mitigating factors for the state to actually take into consideration. So the state doesn't wait until it's very clear that the state is looking at what only happens in Idaho at the selection phase and not the eligibility phase. The other point that I want to make about our motion on this is the issue of geography. And I want to point out that we are arguing geography in the context of equal protection, which is a unique argument that has been made in Idaho and has not been addressed on appeal when it was being raised in Harrison over financial resources, and the point was geography. It was in the context of arbitrary and capricious, and not in the context of equal
But
protection.
as I understand your analysis, is that the geographic, there's a predilection for capital cases to come from geographic centers of large populations, correct?
Correct.
Client's case does not stem from one of those.
That's true, Judge, but this is not, we're not talking about the facts of our client's case right now. We are talking about Idaho's
Your claim
statutory
is
scheme.
on the whole, your claim is that it violates equal protection.
Correct. And not only on an Idaho level, but also on a national level, when you take into consideration how many states have stopped using the death penalty or paused using the death penalty. So it's geographical at a state level, and it's geographical at a national level.
Interesting. I think the last 3 or 4 death penalty cases have come from outside those
Ronnie?
geographic centers in Idaho.
In terms of the southeastern
That is
Idaho,
In
correct.
Southeast Idaho, and I recognize one was death penalty was taken off the table for reasons outside well, suppose not ultimately outside the control of the state, but because of the state's failure in discovery. This case, and then I believe there was another one up in the second district relatively recently that then was resolved.
And I can't dispute that. That still does not eliminate the fact that in Hairston, Dr. Jensen concluded that there was a geographical issue. And in Dr. Cover's study, she made observations about geography as well.
But even she confessed she couldn't make any conclusions based on that.
And that was why I used the word observation. And had she testified, she would have explained her observations regarding that. But it is instructive to see that a study that was conducted in 1995 in Hairston has the same results in 2019, even if it's just an observation about geography. One of the things that the Supreme Court mentioned in its decision in Hairston is that they really wanted more information about the data that had been gathered and the reasons that there was a determination by Dr. Jensen regarding that and more analysis. But nonetheless, that was Dr. Jensen's conclusion, and they are Professor Cover's observations. For those reasons, we are asking that you find, based on Professor Cover's study, taking it at face value with its conclusions and providing you with the data that we will look at and redact
If
names.
I go there, in other words, if I accept that there's an actual valid analysis to be done here, would you agree that I need to look at cases since 2019 as well?
I think, Judge, the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that on an individual basis.
Well, I can't take her opinion because it's a legal conclusion. Looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today and not as of 2019.
Yeah, I guess I'm not willing to concede that. And if it was something that, needed to be undertaken, I'd like to have the opportunity to have Professor Cover testify about
She's
her
got no
time
opinion
frame.
about that.
Pardon?
She's got no opinion ultimately about that. She has some data that she collected that she thought was interesting and might require some additional study. I guess the point is that if I were to engage in that, it seems to me relevant, at least as to the state claim for, claim that the state equal protection, not the state equal protection clause, but the equal protection as applied within Idaho geographically, would need to look at that as of the time frame now.
Well, it could certainly be instructive, Judge, but, if you're taking the data from Hairston, which was 1978 to 1995, and Professor's Covers from 2002 to 2019, the data, if it was analyzed, I'm quite certain would support both of their premises. I haven't analyzed it. We could have that study done, but I think that there's enough guidance with all of those years of data to be able to draw the conclusion that it's arbitrary and capricious today, because the statutory language is still, the definition is still the definition. The statutory aggravators are still the statutory aggravators.
I have a case that indicates that an equal protection analysis can be applied on its face as opposed to as applied, because my understanding is an equal protection clause has to be analyzed as applied.
Yeah, I'm not able to, I can't right in this moment give you that case. I'd be happy to look into that and submit it as a supplemental authority.
You would agree if it is as applied, that would put your client's claim, at least as it relates to within the state of Idaho, as not being problematic, given that he's from one of the smallest districts in the state.
Well, then I want to go back and talk to you, Judge, about the premise in Hairston, which was pre the Capital Defense Fund, which also has created, in time, another dynamic of whether or not someone's charged with the death penalty and those costs at the time that he was charged. I mean, now it's different. So yeah, I'm not going to concede that as applied, it just simply doesn't fit. I think that there are greater questions than that, but I don't have a case to point you to exactly. I don't think that has been, it hasn't been raised in Idaho. We're making the first equal protection. I mean, in other district court cases in North Idaho, Mr. Logston has raised this issue, so I don't want to say
And rejected
you're
in
the
those-
first.
in all of those.
Right, but it hasn't made it to the Idaho Supreme Court, to the appellate courts.
I just don't see how, as applied, you've provided the court any information where I could conclude that because your client is from one of the geographic districts you claim is the does not get its fair share of capital cases.
And we did not submit that argument in our brief.
All right, thank you. I think you've used your time.
Thank you, Judge. I'll try and keep this brief. I think there are two problems, independent problems, with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes from Hairston, where the court said this just isn't how you do the analysis. You don't cumulate them and then do
What's
the analysis.
intellectually wrong with that analysis, though?
With cumulating and then
I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is to make the death penalty less arbitrary,
correct.
Why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
So, Your Honor, I think to answer that question, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single factor and every single one you found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty. And so it's not an arbitrary and capricious system. It's not left to the whims of somebody.
But if you have so many aggravators that on the whole would essentially apply to any first degree murder, then isn't it just left essentially to the prosecutor as to which cases are or are not worthy to bring as a capital case?
So absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt. And if they can prove one of those aggravating factors beyond a reasonable doubt to the jury, and the jury finds that, then that person is now worthy of the death penalty. And again, when we instruct the jury, we don't instruct them to consider all of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. It can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And so I don't see a problem with that analysis that the Idaho Supreme Court said that that's not how you do this. And I would note, I think the court has mentioned this as well, it's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any jurisdiction, that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. So I think the court was right in Hairston. Clearly, it's binding precedent. You know, the defense in their reply brief, they tried to say their response to Hairston was, well, that was when judges were doing the determination. And I just don't see the relevance to that, logical or otherwise, how that would matter on the narrowing part. They point to Hidalgo, which they brought up multiple times today, which is a dissent. It has no binding authority. It has no effect whatsoever on the case. So they just can't point to anything to say that Hairston doesn't apply today. It does apply today. And the Idaho Supreme Court has rejected that approach. So that's the first reason why this fails. But then even independent of that, there's a second reason. And that is the defense is relying on this narrowing process that has been described by the United States Supreme Court. I believe the most recent case that they've kind of walked through that was the Tulipa case. And in Hall, our Idaho Supreme Court talked about Tulipa and exactly what that test requires. And they were in Hall, they were analyzing a single aggravator because that's how you do this. And it was, the court acknowledged that, yes, this would apply to many, many murders, but it doesn't apply to every murder. And that's all that Tulipa requires. So the way, even if it were appropriate to aggregate all of these circumstances, the appropriate narrowing question is, does it literally apply to every single murder? And even Professor Cover's analysis shows it doesn't. It's a high percentage, but it's not 100%. And so it would pass the narrowing requirements of Tulipa as interpreted by the Idaho Supreme Court, even if it were proper to aggregate these together. Your Honor, in terms of the equal protection claim on geography, I think, you know, here again, they run into a problem with the Idaho Supreme Court. A similar claim based on geography was raised in Hairston, and the court rejected it. The court not only rejected it, the court instructed future defendants, if you want to bring this claim, here's what we're going to need to see. And they said, in order to show that the imposition of the death penalty in Idaho is arbitrary and capricious, there must be some empirical evidence connecting the discrepancy that appears to be shown by Dr. Jensen's study and one or more impermissible factors. And the defense has been aware of that, and instead they bring a study where the person who conducted the study acknowledges, I can't show that. That it's just not sufficient. It's not sufficient to make any kind of, at best, they've shown a statistical discrepancy, and that is not sufficient to claim some kind of constitutional violation, any kind of constitutional violation. I want to end just by talking a little bit about the court's question on, would you have to look at the data up to today? I think the question, or the answer to that has to be yes, absolutely. There's no reason why the date Professor Cover conducted her study has any legal relevance or significance. It would be up through today. And I think this goes back to a problem of this whole accumulating the aggregating factors and then doing a mathematical study and finding a percentage, because let's say that courts engage in that conduct, and let's say that courts decide it's 50% is the magic number, and if you get above 50%, then your statutory scheme's unconstitutional. Well, what if Idaho is right at 50.5%, so it's unconstitutional, but then over the next year, a bunch of murders are committed and none of them satisfy the aggravating factors. So now we're at 49.5%. Now everyone in that year can be subject to the death penalty because the murderers that committed murders that year decided to do it in a way that didn't satisfy one of the aggravating factors. I don't think there's a logical basis for that. And I think that's why the Idaho Supreme Court has taken the approach they have, where this isn't a quantitative analysis, it's a qualitative one. Is there any narrowing that's being done? And if the answer is yes, then you've passed the test. That keeps things fair and uniform across the state and temporally across time. And so I think that's another reason why it wouldn't make sense to aggregate these. Unless there are any questions, we'd ask the court to.
You want to address the geography issue?
Yes, Your Honor, I addressed it briefly. I'm happy to talk about it more from the Hairston decision.
It's not necessarily a requirement you do, so I just wanted to know, you were fairly summary about it. And it seemed to me the defense had raised some issues that perhaps were a little more expansive than what they had argued in their brief. And so
I would certainly agree with that, Your Honor. So A couple things on that. First, the idea that it somehow violates equal protection for Idaho to apply the death penalty when other states do not on a national basis. I'm not aware of any case law that would support that. And in fact, it's directly contrary to the case law that we're going to talk about later on evolving standards of decency, where the U.S. Supreme Court has specifically acknowledged that, yes, there are some states that apply it and some states that do not. The conclusion from that isn't that just because there are some states that do not apply it, it's unconstitutional everywhere. So I don't think that that's an appropriate question. In terms of within the state of Idaho, I think to the court's point, with an equal protection analysis, really the first question you have to ask is, who are we talking about and what status do they have or what position do they hold? Because a critical part of the equal protection analysis is you have to treat people that are similarly situated the same. You don't have to treat people who are not similarly situated the same. So that initial determination of are they similarly situated requires a subject, a person. And so to the court's point, I think in the vast majority of cases, at least that I'm aware of, equal protection is raised as an as-applied challenge, as applied to the person bringing the challenge. And so in this case, where they're trying to argue that it's only the larger counties that seek these things, as the court pointed out, that's not true in recent Idaho history. And they, again, have not pointed to any study, Professor Covers or anywhere else, that shows that the reason why there are more death penalty cases brought in the larger counties is because of some unconstitutional reason, rather than, could it be explained by something else, like the fact that they are more appropriate in those areas. And frankly, the common sense understanding would be that you're probably going to see more death penalty cases in more populated areas, because just as a matter of statistics, there's probably going to be more first-degree murders committed there, and therefore probably more that are eligible for the death penalty. So certainly they would have to rebut that with some kind of evidence that shows, as the Idaho Supreme Court told them they had to in Hairston, that makes a direct connection between empirical evidence and some impermissible factor. And that's just missing here. Unless the court has any other questions. Thank you, Your Honor.
Rebuttal?
Judge, I just wanted to touch on the issue that he raised about Harrison and the timing of that, and the fact that at that time when that came down, judges were doing the imposition of death penalty sentencing. And that really is a very important distinction, because as you know, the arguments that are coming up in other motions, the difference in an experienced judge being able to get into all of these nuanced areas and apply beyond a reasonable doubt in the gateway phase, and then just mercy in the mitigation phase is very, very different than a jury's ability to do those things when it's the only case that they're looking at. So I do think it's important to take into consideration the timing of where we're at now with the jury decision. The other thing is, I just wanted to point out some of that mitigating language that I'd referenced in Tulepa that's in the statute that we don't have. Whether or not the offense was committed while the defendant was under the influence of extreme mental or emotional disturbance. Clearly not something that's in Idaho's aggravating statute to consider. Whether or not the victim was a participant in the defendant's homicidal conduct or consented to the homicidal act. Whether or not the offense was committed under circumstances which the defendant reasonably believed to a moral justification or extenuation for his conduct. A statute that, frankly, those types of terms in our statute would be very welcomed. And I wanted to also point out that the study dates amount to between 75 and 95, those years in Hairston, in 2002 and 2019 for Professor Covers. That's 37 years worth of data with the same definitions. So, instruction in a few more years of data, you've got 37 years to rely on, that there's no narrowing. Thank you.
You know what year the Capital Defense Fund was established?
It was after 95. And I think that Harrison may have been the impotence for that. If Mr. Logston was here, he'll be here later. I think he knows the exact year of that. But I don't. I just know it was
Has that
after
mitigated the
95.
issue in your mind?
Pardon?
Has that mitigated the issue in your mind?
No, I think that it has not. It has not. And I frankly think that the new system with the state public defense is going to make it worse. I think that there will be no reason for the state not to charge death in every first degree case, because our statute doesn't prevent them from. Everybody fits. Everybody fits.
Thank you. I will take the issue under advisement and issue a written opinion. It's 10:30. I'm going to take a 10-minute break, and we will adjourn after that.
All rise.
Okay, there you go. And we are still in this watch as well. So, yay. Yay. So, what do y'all think about all this mess? I'm not going to say whether or not I agree with the death penalty or not, but I will say that if someone should, if death penalty is on the board for someone, in my humble opinion, then I think that if for some reason right now they're not able to implement that penalty, they should still be able to, they just stay there for life. I don't think we should take it off the table, because if the death penalty is available and that is what is charged, and right now that state cannot get what it needs to implement the death penalty, I'm going to adjust this tonight when I'm off air. There we go. Then I think that they just sit there until they do. Now, if it's because they're no longer going to be doing the death penalty, then they do need to take it off the table. I know people may disagree with me, and that's fine. But, dude, death penalty is what you're being charged with. And right now, they're not conducting the death penalty sentencings. Count your lucky stars, you get to live longer. But as soon as they're back up and running, everybody's going to be on the list and they're going to go. I don't know. I think this is just a waste, but I don't default. I mean, I'm not mad that they're trying it. They're doing everything they can. Okay, here we go. So basically what I'm trying to say is death penalty is still an option. That's what that he's being charged with. That's what he gets. And when they implement it, it's up to them. Whether they do or don't, for whatever reason, he's there for life. There's some people that should be in there for life. And a lot of states do have a
All right, I think
Not
we
Texas.
are on now the
states
motion
have
to
like
strike
30 something
the
years.
individual statutory aggravators.
I didn't say that very eloquently.
Give
I'm getting
each
tired.
side 25 minutes and you can address them
I'm getting warm. Blanket.
in whatever
I
proportion.
gotta go at 4:30. I have a hard stop. I gotta go interpret.
Okay, Judge, I will be covering heinous, atrocious, and cruel utter disregard, and then I will do murders, and Ms. Taylor will do future dangerous. So I'll basically do the next three. And given the time that you've asked, I'm assuming there will be less questions.
I
maybe?
will try to restrain my curiosity.
Right. I'm happy to engage with you. I
If
want
I-
to
And
know
I, as you know, I gave you some additional time, and that says why.
that. Right,
why.
thank you. We are asking that the court strike the aggravator, especially heinous, atrocious, and cruel, manifesting extreme depravity. And I want to focus, I think I just want to start really focused on how this is different than Hall. You know, we're aware that Hall, Arabay versus Levitt, there's a lot of discussion about having addressed this aggravator before. We are framing it for you in our argument in a different way. And so what I want to show, or the distinctions, is that, you know, Hall was a decision was issued in 2018. So was Hidalgo. So when Hall issued their decision, the arguments hadn't been framed in light of what we just argued about Hidalgo and that eligibility narrowing. Also, there was no equal protection argument, no argument regarding Article 2, Section 1 of the Idaho Constitution. One of the cruxes of this argument is that what the Idaho Supreme Court and the Idaho courts do with this aggravator is they've created a jury instruction that is construction, also known as, and called in our briefing, judicial gloss. Our argument is that Osborne is from 1981. That's when the judicial gloss was applied, and then recently the Idaho Supreme Court adopted and adopted instructions related to this. But what happened in 2011 is that the Idaho Supreme Court issued the Verska versus St. Alphonsus decision, and in that decision, the court said, "This court has consistently adhered to the primary canon of statutory construction that where the language of the statute is unambiguous, the clear expressed intent of the legislature must be given effect, and there is no occasion for construction." And the courts have not taken that into consideration. So if the statute is unambiguous, then it should be given its direct meaning, which we quoted in our brief, would be heinous means utterly odious or wicked, atrocious means horrifying, wicked, and cruel means willfully causing pain or suffering to others or feeling no concern about it. And if it is ambiguous, then under Verska, the judicial gloss should not be allowed.
If it is ambiguous?
If it's unambiguous, then the judicial gloss should not be allowed. But what, you know, the state is arguing that it is, has not argued that it's an ambiguous statute, because that would give us grounds for the argument that it should be stricken from as an aggravator, as arbitrary and capricious. And so we are asking that you take into consideration the way that we are framing this argument, which is different than
Difference
it was
between
in Hall.
Ambiguous and vague.
Pardon?
Difference between ambiguous and vague.
I don't know that I can necessarily draw just a distinction there. I think that they're, you know, similar. Yeah.
Well, so let's do all of yours, and then we'll do all of theirs. I think it goes faster that way. If we do this back and forth, I think it takes longer. They can take notes.
So utter disregard falls under the same argument, the one thing that I want to point out about our utter disregard is that Idaho is the only state that
I
has
agree.
that as an
I agree
aggravator.
very much.
But when you look at other states, there's language
Sorry, I've
that is
argued.
found that is the same as heinous, atrocious, and cruel, which is interesting because it looks like almost we have the same aggravator labeled as two different things. And we also raise the argument there that it's a separation of powers violation when there is construction on that statute, and that violates VRSCA. The next one that I am going to cover is the multi-victims aggravator. Idaho is the only state that has both a multi-victim and propensity aggravator. A multi-victim aggravator is clear. We were having that discussion between clear and fuzzy. Multi-aggravator is clear, 1 + 1 = 2. The irony in some of that is that it seems to lessen the value of a single human life, but it still doesn't tell us anything about the culpability of the person who has been charged with the crime.
Well, isn't it more culpable to kill 2 people than 1?
I think that the issue is, the problem is that it is.
Isn't it a morally more problematic, the number of lives you take?
I think that it depends on, first of all, I want to start answering that question by saying any life taken.
I agree. And
Right.
Right. And the
but-
floor is pretty high. But what I'm saying, doesn't that bring you above the floor?
I think that it depends on the underlying facts of what is the result, what's the basis of how multiple occurs. And so, just to say that the number of people relates to culpability, I think that what the argument that we're making is that supports the other aggravator of propensity. And under Idaho's the method of selection with a jury and the rules about double counting, while the jury can take into consideration the same facts for multiple aggravators, there must be more than one fact per aggravator so that there's not double counting. And that is the problem when you've got a multi victim aggravator and you also have a propensity aggravator. And there's been, as we cited.
Is that a constitutional problem or an evidence problem?
It becomes a Eighth Amendment constitutional problem when a jury has an inability to properly distinguish between those issues in finding aggravators beyond a reasonable doubt.
I mean, as the gatekeeper, I assume that if the state hasn't provided additional evidence that would support propensity that is not included within the multiple murders, then that aggravator wouldn't go to the jury, right?
Well, I mean, we would hope that the gatekeeper would do that. Yes, Judge, we're asking you to be the gatekeeper now and prevent us from even getting to that question because of the problem that is identified. And we provided the court with law review articles where the issue has been studied about how impactful multi-victim facts are into the ultimate decision regarding aggravators. I also wanted to point out that there are multiple states with a multiple out of aggravate that have that multi-aggravator, but they don't have future dangerousness, which Ms. Taylor will talk about, and that is very related
Hello,
to
Gabby.
propensity. And those states are Alabama, California, Kansas, Montana, Tennessee, and Utah. And in fact, Texas is a good example of, it's a part of the definition of capital crime. And then the jury has to decide on the aggravator of propensity after that has been included as part of the narrowing in the Texas statute. So for those reasons, we'd ask that you strike the multiple aggravator as well.
Your Honor, we're asking the court to strike the aggravator of future dangerousness or propensity, whichever label we want to put on it, but it's found in subsection I of 1925-19, subsection 9. And I think when we're thinking about the constitutional way this is laid out to be protective of the Eighth Amendment, to have a true narrowing, and it can't be vague. We've been talking about that all day, so I won't go into that again. But with that in mind, I want to read the words of this aggravator for the court. That the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That language does nothing to narrow. That, I'll skip right to the vague part of the argument. We're asking the court to consider three things in striking this aggravator. It isn't narrow, it's very vague, and it doesn't go to the culpability of the crime that's been charged and, if this happens, convicted of. Your Honor, this language, I think, has been acknowledged by our Idaho Supreme Court as needing the gloss in Creech. And I would say that what's required is that the statute, which Idaho doesn't have, has to provide the narrowing, or the sentencing structure, and those things are legislative processes. And that hasn't happened. We have the gloss from the Supreme Court. The gloss that the Supreme Court has put on this, though, does not do anything but loop us back to the statutes that define murder and then exclude voluntary manslaughter. If truly we are to have an aggravator that selects out the worst of people who have been
Sorry, I don't
convicted
think
of
she's
murder,
still here, y'all.
this does not do that. The language in this aggravator is incredibly vague. When you think about really what is going to happen in front of a jury, they're going to get all this evidence that is supposed to be proven beyond a reasonable doubt. I trust the court will instruct them on that. But then they get this evidence that probably will make them believe that person's a future danger. The chance for a jury to misunderstand the call and the burden that needs to happen is really great by the language alone. And Creech really doesn't do anything to help. The gloss that gets put on, the jury instruction that gets put on, that doesn't help. That just says
Did
people.
Hall say that it was okay? I can't remember if they addressed that in Hall. I think they
I think
did.
Hall did say it was okay.
So what am I to do about that?
You are to listen to that, allow me to make my record, which I am, but you are to say nobody else has talked to me about the real language in here when it says probably. That is confusing to a jury. This isn't a judge's call any longer, but this is confusing to a jury to have those words in there. And the chance to find this aggravator, either based on one of the other aggravators, which we know cannot happen, or at a lesser burden because of the word probably, you're to find that is way too vague. And you should strike this aggravator because of that. Additionally, while we're talking about vague, there's a lot of potential for the jury to misuse mitigating factors and make them into future dangerousness aggravators. And I
Isn't
think
that the truth, the possibility always in sentencing? I mean, one man's aggravator is another man's mitigator. And I think you pointed it out well in your brief of mental health, right? But isn't that the nature of individualized sentencing and consideration of those factors?
I think it is a danger. And I can't square in my mind how I am to do my ethical duty to my client and to abide by the guidelines that are set forth in capital cases and do an investigation into mental health and then turn it over like Idaho says I must, and then subject my client to the state's expert to grill him for however long. I mean, I have this duty. My client has the right to present this. But now I have to do all of this and give all of that information up so the state can use it in an aggravator that says, just tell me that the person will probably be dangerous in the future. That is just terrible, Judge. And for that reason alone, you should strike this aggravator. The last comment I'll make is that future dangerousness doesn't go to the conduct, the culpability of the conduct that has happened. And
She's
that's
trying
really what
hard.
these
Give her
aggravators
that
need
much.
to do to narrow properly the scope of who's who. I can't tell you the number of times I've sat in court and listened to a prosecutor talk about at sentencing that my client or my client's acts are the worst they've ever seen. And that can't be true when you sit in court day after day after day and you hear that about person after person after person. This statute doesn't do anything to help a jury decide who's the worst of the worst. This aggravator absolutely has to be struck. It's a violation of the Eighth Amendment.
Thank you.
Your Honor, beginning with the heinous and atrocious and cruel,
This is
aggravator
interesting. I'm
specifically has
quiet
been
because
upheld
I'm really
by
trying
the
to
Idaho
listen.
Supreme Court, and
and read.
specifically the judicial gloss placed on this aggravator in Osborne.
Was
Now-
Hall a jury determination? Do you know?
I'm not
Supposed to
sure on
drink
that,
that
Your Honor,
much
off
a
the top
day.
of my head. I apologize.
Not that much.
I think it was, but I don't recall specifically. Notwithstanding the fact that I think that I'm the actual judge on the case now, I don't recall because that issue hasn't come up. But
Thank you, Your Honor. And I apologize. The defendant has raised this argument that in Verska, the Idaho Supreme Court's decision stating that the court would not rewrite or void an unambiguous statute is essentially the same thing as stating that the Idaho Supreme Court is saying that we can't put a gloss on a statute. But those two things are very different, because placing a gloss on a statute to ensure its constitutionality is not the same as rewriting or voiding a statute. If Verska is taken to that extreme, then courts can't interpret statutes at all. And that's not the holding of Verska. Verska simply stood for the proposition that the court was declining to rewrite or void a statute. And of course, the Idaho Supreme Court has never rewritten the heinous, atrocious, and cruel aggravator or the utter disregard aggravator or any of these aggravators. They've simply placed a judicial clause. As to the future dangerousness and propensity one, which was the most recently addressed, that too has been upheld by the Idaho Supreme Court in State versus Creech. The propriety of considering future dangerousness has been upheld by the United States Supreme Court in Juror versus Texas. In their propensity argument, their future dangerous argument, the defendant is essentially asking this court to start with a proposition that a jury is not going to be able to follow the court's instructions. And of course, we can't start with that proposition because juries are presumed under Idaho law to follow the instructions that they're given. And that is another issue. That issue is also true in the defense's multiple victims argument. Their argument with multiple victims really doesn't cite to any case law. It's simply based on the fact that they're assuming that a jury is unable to distinguish between propensity and multiple victims. And again, the court is being asked to start with the presumption that a jury won't be able to follow the law. And that's contrary to the state of the law. We can't presume that because juries are presumed to follow the law. Additionally, we also can't start with the presumption that the state is going to just put on the same evidence for all these aggravators. The court should also assume that the state will put on independent bases for each of these aggravators during the penalty phase. That's our legal obligation. And the jury will be instructed as to what the law is. They will be instructed that they can't double weigh or double count. That's very clear in the case law. The state would just ask that the court decline to presume that the state will present the evidence in a way that's contrary to law and that the jurors then won't follow the instructions. That can't be, Your Honor. So the state would ask the court to deny the defendant's motion as to these aggravators. All of these aggravators have been upheld, specifically the hack along with utter disregard and future dangerousness. There is case law directly on point that is binding on this court. We would ask the court to deny their motion.
Thank you.
Judge, to answer your question about Hall was originally sentenced by a judge, and then the sentencing was retried, and Mr. Chastain and Ms. Christensen handled that case.
My memory came back to me between then and now, so thank you for clarifying that.
I want to point out that Verska says, if it's socially or economically unsound, the power to correct is the legislatures, not the judiciaries. If it needs fixed with construction, as we argue that it does, it must be stricken. And I want to address the question that you asked about why not wait until the evidence comes in and I can strike the aggravator at that time. It goes to the point of why we are arguing all of these right now. There's a huge difference between picking a death qualified jury and a non-capital qualified jury.
Well, but that just went to my point of your argument presumes I would strike all of them. If, for example, I were just looking at multiple murders versus propensity, and those two so overlap that you can't have both. You could still have one, or you could have both. But if there's not evidence independent of one, then you would strike the one.
So you're correct that we are asking you to strike all of them so that we don't have to pick a death qualified jury, because death qualified juries are highly likely to convict in the guilt innocence phase. So we are very, very concerned about that, and the fact that that is so different in a death penalty case. But to the extent that you might strike some and save one, for example, the multi aggravator, there's a vast difference in what happens in front of the jury in the selection phase with that aggravator versus the others that we are asking you to strike. Thank you.
Thank you.
Your Honor, I certainly didn't mean to tell the court that I would presume whatever jury we end up with won't follow the law. What I'm saying is that that particular statute, the future dangerousness statute, is really tricky. It's tricky because of the use of the word probably. It's tricky with the rest of the wording too, and based on the information that will likely come in. I point out that when it was up to a judge to decide, I think a judge is well versed in what does beyond a reasonable doubt mean and what is a probability. The court looks at that all day, every day, and those are hard concepts for a judge.
Standard would be that the jury would have to be convinced beyond a reasonable doubt that it is probable that the defendant would be it's probable that they would kill again. I think is the way that that washes out.
I think that's the way it washes out too. And I think it's just a problem with the word probably in there. So for when a judge was doing this, it was less of a problem, but I still think there's issues with that particular aggravator. And I would point out that the higher courts in Idaho have recognized the problem. That's why the decision in Creech put a gloss on it. And I think when the courts recognize that that's a problem and there needs to be a gloss or a fix put to it, that's one thing for the court to consider. How the fix was done, I think, is a problem. It's a jury instruction, not by the legislature. But keep in mind, there's a problem with this instruction or with this aggravator. It needs to be fixed, but the fix is to loop back to statutes that already exist. And I don't really think that's a fix. And I'll stop there.
Zach fixes at all three. I am having tea from Ollie Tea, our new sponsor.
All right, I think the non-statutory aggravators is the next issue for our attention. So with that, I'll hear from defense.
Thank you, Judge. Your Honor, by way of housekeeping with the non-statutory aggravators, I understood the state's response briefing to say that they agree that they have to provide notice and any
Zach,
discovery
I could
about
go
non-statutory
somewhere.
aggravators as well.
They said that they
Zach, I could go somewhere real bad with that. No, not what you're thinking.
They had said they would.
Yes. So I think I don't have to argue about that. I think I'm limited to arguing about the burden of proof required for non-statutory aggravators.
Arguing for the defense, for the state on that issue.
Yeah, Your Honor, the state's position is that the statute clearly says that Rule 16 applies. We agree Rule 16 applies and we'll comply with Rule 16.
All right.
I'll limit my comments then to burden of proof. Your Honor, our position is that non-statutory aggravators need to be proven beyond a reasonable doubt as well. We know that the state can use non-statutory aggravators to help them establish aggravators beyond a reasonable doubt. And looking at the court's new jury instructions that just came out, beyond a reasonable doubt is all over those. When we're talking about aggravators, there's no question there. Those jury instructions are silent on non-statutory aggravators. So I can't lean on those to say that the court should find that these have to be proven beyond a reasonable doubt. But from a fairness standpoint and from a it just makes sense standpoint, you should say they have to be proven beyond a reasonable doubt. I'm thinking about this in the context of having a jury and having the prosecutor producing evidence and arguing beyond a reasonable doubt, but having these other non-statutory aggravators and say, these are things that we have that you should consider, but we don't have to prove these to you beyond a reasonable doubt. I think there's a real danger in a lack of confidence in the finding of an aggravator if you don't require them to prove the non-statutory aggravators beyond a reasonable doubt, just like their statutory aggravators. Capital cases are a really big deal. And if we're going to get all the way to the end of this, and that's where we're at, the court has to have confidence in what's presented to the jury. Mr. Koberger has a right, if that's where we end up in his case, to have a jury finding any single aggravator they might find beyond a reasonable doubt. And we think you should order the state to meet that burden if they're going to present non-statutory aggravators.
Thank you, Your Honor. I want to start by just, I tried to be very careful in my brief to refer to it as non-statutory aggravating evidence, because I'm not sure what a non-statutory aggravator is. I want to be clear, the state's under no impression that there's some shadow list of aggravators that it can prove one of those and that qualifies the defendant for the death penalty. We are, of course, required to prove beyond a reasonable doubt one of the statutory aggravators. And I think what we're talking about here is just non-statutory aggravating evidence. So evidence that may not be, and if I'm being,
So if you look at it like a scale, right? And defense puts on evidence of mitigation, and the state has to put on at a minimum evidence.
Welcome,
beyond a
Miss
reasonable doubt
Colleen
of the
Beeman.
statutory aggravating
Yeah.
evidence. When you go to weigh, does your non-statutory aggravating evidence go on the scale when that weighing is done?
yes, Your Honor. And I think that that's clear from the Hall decision when they talked about this. They talked about they talked about the Zant decision from the United States Supreme Court and how it's important that juries understand when they're making that, when we get to the individualized determination of is death appropriate in this case, it's important that the jury have a wide array of information. That's the purpose of the statute, is what the Idaho Supreme Court said. So yes, I think at that point, any aggravating evidence that has been presented goes on that scale. Now, to be candid with the court, in my mind, anything that's relevant to a statutory aggravating factor isn't non-statutory aggravating evidence because it's relevant to the aggravating factor. And just to be frank, I can't even come up with a good example of what the state would put on in this case that would qualify as not relevant to an aggravating circumstance, but relevant to the overall weighing process. I guess my point is I don't know that this is going to be an issue, given that we will, of course, comply with discovery. We will provide everything that they'll know what we're going to say before we say it. And if there's an issue, we can raise it at that time and discuss, is this actually relevant to a statutory aggravator or not? And if not, does it fit into what I consider to be a very narrow category of non-statutory aggravating evidence that is still somehow relevant to the overall decision, but not one of the
I
aggravators?
think the visual using my scale would be to get on the scale, the statutory aggravating evidence would have to have been proven beyond a reasonable doubt, right? That is, you have the existence of that aggravator would have to have been proven beyond a reasonable doubt. As I understand the non-statutory aggravating evidence, the existence of that evidence would need to be proven only by a preponderance of the evidence. Is that your understanding?
You know, I don't know that I would completely agree with that, because I don't know that that's laid out in the instructions that it's to any specific burden. I think if you look at the jury instruction 1722 on jury deliberation, it talks about finding the statutory aggravator beyond a reasonable doubt. And then when it gets to weighing, what it says is you must each decide for yourself whether all mitigating factors presented when weighed against each statutory aggravating circumstance proven by the state are sufficiently compelling to make the imposition of the death penalty unjust. You do not have to unanimously agree upon what mitigating circumstances exist. The existence of mitigating factors need not be proven beyond a reasonable doubt. You must each decide for yourself whether mitigating circumstances exist, and if so, then consider them in your individual weighing process.
Right, those are the mitigating.
Correct, but I think what I'm getting at is that's what we have in terms of the instructions of this weighing. Is it's saying to the jurors, you're going to conduct kind of an individual weighing process to decide whether it's just or unjust in this circumstance. And that's the point where these things would come on the scale, to use your analogy. And so I just don't know that there's a point where you would instruct the jury, you know, you heard from witness X, they said A, B, and C. You can only consider that if you find that A, B, and C is true beyond a reasonable doubt. I don't see an instruction for that anywhere. I don't think that's typically how you do sentencing. You know, they would put on their mitigation. Maybe we have some rebuttal to that mitigation.
Uh-oh, we're back. We got movement. Do we have a jury? And if we do, that jury was out for 2 hours and 8 minutes. Whoa, looks like they're moving. We have a jury. That's the first smile I've seen out of him. Not that I want to see a smile.
All right.
right, bring in the jury if you would, please.
Bring the jury. Okay, y'all, get your bids in. Guilty, not guilty. Yeah, he looks more energized.
Thank you. Madam Foreperson, do you have a verdict?
Yes, we do.
Could you please hand the verdict form to the bearer?
Guilty.
Thank you very much, sir.
Yes, Mary Kay.
Thank you. Madam
You have
Clerk,
to practice
can you
not
publish
reacting.
the verdict?
You know what I
Thank
mean?
you.
You got to practice. All right, read the verdict.
In the case, State of South Carolina versus Craig Anthony Lewis, indictment numbers 2019 GS 15 00138, charges arson in the first degree. Indictment 2019 GS 15 00129, the charge is murder. As to the charge of arson first degree, we, the jury, find the defendant, Craig Anthony Lewis, not guilty. As to the charge of murder,
Not guilty?
we, the jury, find the defendant, Craig Anthony Lewis, not guilty. And this was signed by the foreperson on today's date, November 7, 2020.
Not guilty.
Thank you.
I guess they believe.
Would either
Your
party
Honor,
like the jury to be polled?
No, Your Honor. No, Your Honor.
he's free.
All right.
What?
Thank you. Members of the jury, thank you very much for your service. Our entire judicial system could not function without people like you who are willing to give up your free time, your time from work and family,
not
to come
guilty.
in and make these difficult decisions. I thank you for your attention.
Everybody.
I thank you for your hard work. I know it was a difficult decision for all of you to sort through all of that information, all that you heard, all that you looked at, and come up with a verdict. And I appreciate it. If any of you want to discuss any of this with me, you're welcome to give me a call at some point. Can be found in the Beaufort Clerk of Court, through the Beaufort Clerk of Court. You are welcome now to go discuss this case with anyone that you would like. You're not required to, however. If anyone
have
begins to
questions.
bother you or harass you or anything about
Okay,
your
guys.
verdict, please
I'll read
contact
this
me through the
closer.
Colleton County Clerk of Court's office immediately, and we'll have it taken care of.
When the
Does anyone
is on.
have any questions? All right, then, I would thank you all for your verdict. Any objection to releasing this jury?
No, Your Honor.
None for the defense.
Thank you all very much.
Not guilty on everything, right? not guilty, case one, all count. I think that prosecution messed this up. Investigation messed it up. I think that as much as I don't like this attorney, I think she fought hard for her client and she created the doubt and the situation.
Anything
with
else
her
from the
daughter.
parties?
Yes, Your Honor.
That daughter is
Defense
upset.
would move to have the arrest warrants and all issues in reference to these indictments against this defendant expunged by the court.
Any objection from the state?
No, I believe there's a process for doing that.
No.
but- Okay.
If a case is tried, then the defendant has an opportunity to have it done. If we wait till a process, there's a cost.
Granted, I'll be happy if you'll get the forms to me to take care of it.
Second, Your Honor, the defendant has been on ankle monitoring under a bond since February 19,
There she goes,
2019.
devastated.
Defendant moves to have that
Everything.
ankle monitoring.
He is released from his bond and the requirements immediately.
Third, Your Honor, there is a number, quite a bit of personal property that was seized pursuant to these warrants and indictments. Defense moves to have an order from this court requiring the sheriff's department to return those items to the defendant.
The items
With
that
the-
I guess
They can have the sofa.
right. The trailer, I'm assuming is what you're
Yes,
talking
the
about.
trailer, even the pants, his, all of his personal property that don't relate to any arson, like the can, the lighter fluid cans. We don't want that, but the rest of his personal property, we believe he's entitled to.
Well, from what I saw, you're probably talking about the trailer, the 2 pairs of blue jeans, and what else? Was there
There
anything?
was a piece of a gun or some guns or something along those lines. But that's why I just said personal property, and we can work that out later. He wants his trailer for sure. He can do without the pants, but he wants his trailer.
Who, Madam Solicitor, would be contacted to?
You can contact Steve Basil with the sheriff's office. He is in charge of evidence, and he can wait around and we can give Ms. Matthews the 2 pairs of jeans that were in evidence. We don't need them. So,
Your Honor,
we'll have those slip jeans back.
I appreciate that from them. However, in the past, there's been some difficulty retrieving things. It takes, so unless we have an order from the court requiring that they return the trailer.
So Ms. Bright Matthews can submit an order with what she likes, and then she can take that to the Colleton County Sheriff's Office.
I'm sorry, Your Honor. I did not mean to interrupt Ms. Swanson. An order from this court can be by Form 4 and direct, just return his personal property, and that's all.
And that's fine. If you'll prepare that order, I'll be happy to. I'll be here doing pleas for a while, so
Thank
happy
you.
to do that. And if y'all run into difficulties next week, I'm easy to find, but I'm sure it'll all work out.
Thank you very
The
much.
trailer and the jeans. So anything else then?
That's what I'm saying.
All right. I thank all counsel for conducting a very professional
Ooh, they're
trial.
not, they lost.
I know it was difficult for everyone involved, and I thank you all for your professionalism.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Y'all get the evidence.
As much as that lady, that lawyer nerved me, she did fight well for her client. I kind of have to say, there's a lot of things I didn't like, but I love that. Excuse me, Your Honor, I did not mean to interrupt so-and-so when actually the other lady interrupted her. So, yeah, I don't want to go against that woman. He's going to go have a good meal. He's going to get that ankle monitor off right away. The court turned off sound, so I don't know what's happening. Another case is coming in. The first thing he's going to do is go get that ankle monitor off. He is a free man. Wow. Do I believe that I believe the prosecution did not do a good job. I believe Sledge, once again, Sledge, you suck. They do. They did not do a good job. That's the way I feel. So let's get back onto this. We're
They might
almost
consider
done.
Non-statutory
When this
aggravating.
is done, I think we'll be done
But then
today.
again, it
I gotta go
specifically tells the jury
to level my
you do
sister.
not have to find mitigating beyond a reasonable doubt. So my point is both in the mitigating evidence and in this non-statutory aggravating evidence, there isn't a standard that's given to the jury. And I think that is what was intended by the instructions. And we could debate whether that's the right call or not, but I think that's what the statute calls for. I think that's what the instructions call for. And I think that's the process that we should follow. Recognizing, of course, this
2 hours
court's
and
role
8
as a
minutes.
gatekeeper as to what gets heard at all. The fact that we'll be complying with the rules of discovery and they can bring up any objections that they want beforehand. I don't know that that this will be an issue in the case. Unless there are any other questions, we would ask that they deny the motion. Thank you, Your Honor.
Your Honor, I would start by saying I thought I heard the state get really close to saying they're not planning to produce any non-statutory aggravators or non-statutory aggravating evidence, whichever way you want to talk about that, which might be really good. It might save the court having to make the decision if they get all the way there. I would say, though, there's not a statutory list of non-statutory aggravators, but in Hall, it talked about, that decision talked about things in a person's background, if they had a prior criminal history, things about their character. And a prior criminal history, that's fairly definitive. Either you have one or you don't, right? But things about a person's background, that's where it gets really questionable. Are we talking about people's opinions, people that maybe would have an axe to bear with the person that they're talking about? So I think that when you consider what Hall talked about as a non-statutory aggravator, it becomes really important that the state have the burden of proof of beyond a reasonable doubt for those. I would just close by saying that Gardner versus Florida talked about why we have notice and that reliability matters, but it's the same thing on this kind of information, this kind of evidence, these kind of non-statutory aggravators that get produced. It has to be reliable, and the court has to be able to rely on what a jury comes up with. And Mr. Koberger has a right to have information come in fairly, to have notice of that information, and for the state to carry the burden. And they need to carry the burden if they want to present non-statutory aggravating evidence. Thank you.
Thank you. All right. You're okay with it. I'm going to swap 8 and 9, just because I could see 8 potentially going a little bit longer than 9. And so, well,
Your Honor,
Yeah.
can I help on that?
yeah.
If the court takes the first part of 9, the speedy trial issue, that's the one I'm handling. And I think we've got Jay that's ready on the rest of them. We can cover it, but he's really close.
So he's not here. All right. Well, let's start then with 8, contemporary standards of decency.
That's the one that Mr. Logston
Oh, he
would
is.
be here. I've got speedy.
Would you have, who has trifurcation?
Jay is the one that's the most prepared on trifurcation.
So you've got speedy. Let's start with that then.
I can do that. Thank you, Judge. Your Honor, we're asking the court to strike the death penalty in
Love this.
this case based on a conflict of constitutional rights and Mr. Koberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his 2 constitutional rights, and those were effective assistance of counsel or speedy trial. Mr. Logston wrote the brief on this, and he did a really good job with the history and why we should look at Idaho's speedy trial, constitutional guarantees of speedy trial in the same time frame that the statute 1935-01 says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into the history that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
I'm not sure I'm following what the court's asking me. I'm sorry.
So it seems that you're asking the court to equate what the statute said about speedy rights before the Constitution, Idaho Constitution provided for it, and treat that as the constitutional standard and grafting it into the constitutional standard.
I would say that it's there to provide guidance, because there was that the statute we have now is after the Constitution. The territorial statutes were before we had the Constitution. And when Idaho wrote its Constitution and said, we guarantee defendants a right to a speedy trial, there was that already in mind. I don't think our Constitution says it's 6 months to the day and it's over after that. I don't think that at all. But I think that what was a speedy trial would have influenced a speedy trial right. I do not think our Constitution says it has to be 6 months, but I think our statute does now, and our statute derived from an older statute. And I think that statute, well, I know that statute predated our Constitution, and I think it influenced the writers of the Constitution as a guideline, as a limit. We also know that speedy trial you can go beyond the statutory time frame, and you can stretch that out in different circumstances for different reasons. And our argument is less about that. That's not the argument. The argument is the choice that Mr. Kohberger faced in August of 2023, when he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial on October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty, because Mr. Kohberger had to choose between rights, reinstate speedy, and reset a sooner trial date. That's the remedy. I want to talk about what happened and why Mr. Kohberger had to continue his case. The court's already heard a little bit today about the duties of counsel in a capital case and the kinds of investigations we must launch immediately. It's not just about the facts of the case, but it's also about the facts of the case. But the mitigation phase has to be launched whether or not you ever end up with a conviction. That work has to be done. That's the way it works, and it takes the time to do that. You have to find experts, you have to find records, and it takes time to do those things as well. So, and discovery can be a really big deal, and I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision, and there was a scheduling order from the prior court in this case that told us, you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now, but it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for. We do not have a mitigation investigation completed. We're in process with that still, a year and 2 months after that deadline. So he would not have had that to benefit him either. I think one of the most important things the court should think about when we think about Mr. Koberger having to choose between his constitutional rights is that we're here right now because he couldn't get a fair jury in Latah County. And if we'd gone to trial in October of 2023, he would have maybe held on to his speedy trial rights. Well, he would have held on to his speedy trial rights, but he would have given up his right to effective assistance of counsel and his right to a fair and impartial jury.
What's
That's
wrong
it.
with the idea of speedy evolving on a sort of good cause basis? I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different. And as more contemporary thoughts about that have arisen, it's become the standard that they require more. And so why wouldn't speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate criminal rule that says that. We don't have a separate statute that says that. We would bend the Idaho Constitution until it breaks to make it say that. I'll give you kind of an example. During the time of COVID, when the Supreme Court told the speedy trial rights, it did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remitter was issued and when the case went to trial. And that person asserted their speedy trial rights that whole time. That happened during COVID, when the court had its emergency orders during that whole time. So I think to say, well, it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment. They do. But there's nothing that's been changed in our Constitution, in a court rule, in a statute to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death penalty just doesn't have that right. All of those rights exist. They all exist right now. And Mr. Koberger had to choose between those rights. And I think the court can and should strike the death penalty in this case based on the
Well,
record
that would
here.
result in the death penalty being struck in every case.
Your Honor, if that's the way it is, because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case. I mean, we have been doing
The Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right, and we can expand that right based upon the circumstances, i.e. COVID. Why can't it expand the time that speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that?
I would say that I don't know whether they can or they can't, but they have not. And that's the critical area. I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID. But that hasn't happened. That has not happened.
You think that the Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the more flexible, given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
I don't know if they'd say that or not,
Well, that's what
but
you're asking me to say.
I'm asking you to say that. I'm asking you to
My
do
job as a
what,
district judge, if there's not an issue that has been decided by the court, is determine how that court would decide things.
well, I think you can consider what Judge Boyce did in the Vallow case. And that had to do with discovery that counsel didn't have enough time to review and to prepare for, and it would have disadvantaged the client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not? And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can continue the trial for you to review that. But so you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other. But in this case, the decision to waive speedy was not as a result of, as I understand it, a violation of a court order by the state.
It was as a result of a court order. And when we waived speedy, we advised the court and counsel that this motion this day was coming. We don't think it's appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived speedy trial. And so she had the choice to waive speedy or not face the death penalty. And we think that since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Thank you.
Thank you, Your Honor. So not only can the Idaho Supreme Court do that, it's already done it. The Idaho Supreme Court has said that we interpret Idaho's Constitution for speedy trial the same way that the federal Constitution is interpreted under Barker. There's one exception that has no application here. And so it's an individualized test based on 4 factors, and you're really looking at kind of the overall reasonableness of the delay. I would direct the court specifically to the Langford case that just came out last year. The Idaho Supreme Court walked through the difference between the 2 constitutions, explained how they operate, and then found specifically in that case that they charted out how many delays there were, what the delay was for, who caused the delay, and then was it reasonable or not. And they found, they said, in sum, most of the delays here were precipitated by Langford's own actions. In the case of the last and longest continuance, the delay was reasonably necessary to allow new prosecutors and new defense counsel time to prepare for trial. So they found that's a reasonable, under the Constitution, that is a reasonable delay. So there is no choice here. You don't have to choose between speedy trial or effective assistance of counsel. You can have both. I think what the defense is saying is they've lost their statutory right to 6 months, which they do lose if they take an action to delay the trial at all. But that's not a constitutional problem that they have to give that up if they want to maintain their constitutional right to effective assistance of counsel. Now, in this case.
Well, and that was my point in perhaps not well stated, is that it seems what this defense is trying to do, and perhaps you can comment on whether I'm saying this correctly, is to engraft what was the territorial law, which is that a case had to go to trial within the, at that time, courts were held in sessions, calendar sessions, right? I think there were 2 sessions a year or something like that. That was the speedy right. And then we had the Constitution that doesn't, necessarily give us such a fixed time frame. But the argument is, well, because that was the territorial law at the time, therefore that's the constitutional right. And it is engrafting that statutory construct to mean the constitutional right.
Potentially, Your Honor, though I'm not sure that's exactly, because my understanding of the pre-Constitution statute was that it was based on kind of the circuits and when they came, and And we don't do that anymore. And so that time frame just doesn't make sense today. You wouldn't be able to just engraft that in the Constitution and apply it today because
My point is that's, I think, what this defense is arguing essentially.
yeah. Yes, Your Honor, but the statutory right they're pointing to comes from the new statute that was passed in 1980 that gives the 6-month time period. And regardless of whether they want
Argument that the 6-month is functionally equivalent of the twice a year circuit.
if that is the argument, I don't think that it gets past the Idaho Supreme Court has said, no, it's not. So, under the Idaho Constitution, we use the Barker test. The crux of the matter here is that the defendant didn't have to waive his constitutional right to a speedy trial. He did so under advice. He did so in writing. He did so knowingly, but he didn't have to. The trial could have been continued, even at his own request, without him waiving that right. He waives it statutorily by moving for a continuance or to ask for more time to prepare, but he does not waive it
Now,
constitutionally.
the
If he
Delphi
did,
case, that's
then
not being
most of
live
this Langford
streamed, is it?
analysis would have been completely unnecessary. But instead, at the end of the day, when you do finally get to trial, the reviewing court looks back and breaks out segments of time and says, whose fault was that delay? And as the court said in Langford, many of the delays were because of Langford, and so they don't count against the
Welcome
state.
back, Eddie.
But the court easily could have said, well, he asked for a delay, so his constitutional right was waived. They didn't, because that's not how it operates. So the real problem here, I think that the defense is grasping with, is that they didn't need to waive his constitutional right, but they did. So, there's not much the state can say other than that wasn't required. The Constitution not only can be flexible, the Idaho Supreme Court has held that it is in fact flexible. And one of the reasonable, a proper reason for delay is to prepare for trial. And that means this is not a choice that has to be made by any defendant. It didn't have to be made by this defendant, but he chose to. Unless there are any further questions. Thanks.
Just briefly, Judge, we're not trying to graft in a.
If there's a verdict today, I
We're
need you
looking at the
guys
word
to give me the
guarantee
link.
for a speedy
Okay?
trial and trying to
All right,
figure
I
out
shall
what the word
return.
speedy means. And so
Well, isn't speedy mean the Barker test?
at the time the Constitution was written, I don't think it did.
But isn't that what the Supreme Court has said it means?
I think our Supreme Court does agree that it's the Barker
Again,
test.
I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
I think if I was here saying dismiss the case based on a speedy trial violation, I think that's exactly what the court would do. This is a little bit different. We're asking for the court to set the case back to the point where we had to choose between constitutional rights and to strike the death penalty. In our case, this is the last point I'll make. In our case, we signed a waiver of speedy trial, and it was a form, I believe, that was generated by the court. It was signed on August 23rd, 2023. Mr. Koberger signed it, and I assigned, with the parentheses, attorney for the defendant. And in that form, and remember, our scheduling order said you have to do it by this day, or you don't get a continuance, you're just going to trial. We gave up the right to, under the United States Constitution and the Idaho Constitution. And I have a printed copy, but I know the court probably has the entire court file. That's it.
All right. That, along with the other motions, will be taken under advisement. Let's take a lunch break. It's 5 to 12. Adjourn at 1 o'clock. Thank you.
All right.
Okay, lovelies, I'm here. I's here. So we're in a break. Let's zoom. Okay, we're still in a break. Is your room clean yet, honey boo? Honey boo boo? Wonderful. Well, y'all let me know. Keep me posted. I love this. This is a ES Pro. These are not cheap, and I put my tea in it. I will say I took it out of the tea bag, and that's fine. A lot of times I'll do that. I got this for $2 at Goodwill. Yeah, I sure did. I sure did. Mm-hmm. Y'all, we like our Goodwill sometimes. Sometimes Goodwill's a good place to go. There's some things I will not pay at Goodwill. I will not buy at Goodwill certain things. That said, me likes this a lot. Put the hot water in it. I can take it camping. Hey, Zach, good for fishing, right? Put your coffee, press it, French press. Mm-hmm. Your tea. You guys are so awesome. Do you know that? You know that? Let's
continued with more testimony. In a moment, we'll hear from our WTHR legal analyst, Katie Jackson Lindsay. But first, let's get right to Delphi with our senior investigative reporter, Bob Siegel, and Samantha Johnson. So, Bob and Samantha, today started with a real surprise announcement from the defense.
Absolutely. There were two very memorable statements that came out of court today, one at the very beginning, one at the end. At 9:10 this morning, right after all the jurors had taken their seats, Judge Francis Gall asked defense attorney Brad Rosie. She said, "Mr. Rosie, you may call your first witness." And Mr. Rosie at that point said, he very quickly, 5 words, "Your Honor, the defense rests." And that caught everybody off guard at that point. And then at the very end, again, we had another very memorable comment.
We did. And I told you a few minutes ago, it was a statement that gave me goosebumps.
Yes.
And this one came from Judge Gohl. It was towards the very end of the day, just after 2:15 this afternoon, when she addressed the jury directly. And she said, quote, "Ladies and gentlemen, you've now heard all the evidence in this case." And that felt like such a significant moment that now we're moving on to this next chapter. And between those two statements from the beginning of the day and the very end of the day, hours of information,
Yes.
hours of conversation we heard in between, again, marking the end of a day and kind of this next chapter in this case too.
Absolutely. And like you said, that really was kind of a turning the page, because now we are officially moving toward the end phase of this trial.
Yeah.
So, as Sam mentioned, those two statements bookmarked a lot of information. We did hear from witnesses today. We always like to get you started with who those witnesses were. So let's run those down for you really quickly. There were 3 of them today. 2 witnesses we've heard from before, one who's new. We heard from Brianne Wilbur. She visited the Monon Trails on the day of the murders, and she testified about what she saw. Brian Harshman, he's an Indiana State Police detective. We'll tell you about him in a little bit. And then Dr. John Martin, he is a psychiatrist, and he was the new witness for today, and certainly a witness that was key, brought not by the defense, but by the state. So let's start off by talking about the fact that the defense rested their case today and kind of what happened at that point. It really took everybody by surprise. As soon as Brad Rosie said the defense rests, at that point, there was a sidebar conversation that the prosecutor requested, wanted to speak to the judge and to the defense off on the side. They talked, came back a few minutes later. The judge informed the jury, hey, we were not expecting this to happen quite so quickly. So the judge asked the jury to leave because she didn't want them sitting around in the courtroom, because at that point, really the state was scrambling to bring the witnesses that they wanted to speak to the jury. They weren't expecting that to happen until this afternoon. So we had about an hour and 45-minute delay in the courtroom waiting for the state's witnesses to come. And during that time, the judge wanted to try to make the best use of that time while the jury was out of the courtroom. So she was hoping to be able to talk to both the state and the defense about jury instructions and getting those kind of squared away in preparation for what's going to be happening next. But she said to both sides, I wasn't expecting to have this conversation so early. So she passed out a proposed set of jury instructions to both the state and the defense, gave them a chance to take a look at it. Again, this was a moment the jury looked surprised, the judge looked surprised, the state looked surprised, everyone in the gallery was surprised, not expecting things to wrap up for the defense witnesses quite this soon.
Yeah, and like you said, that was just minutes into this morning, right? It was, what, 9:10 that all of this happened too. And I think the reason this was so important, and maybe the reason the defense felt so confident that they were done with their case, is because of how strong Tuesday was for the defense. Tuesday was such an important day for Richard Allen and his attorneys inside this Carroll County courtroom. In fact, I want to recap. If you weren't with us yesterday, I want to mention quickly 3 important witnesses that the defense called yesterday supporting their arguments in this case. Let me start first with a psychiatrist who told the jurors, who told the court yesterday that Richard Allen was, quote, absolutely showing signs of delirium while he was in prison just a few months ago. We also heard from a forensic scientist who specialized in firearms and crime scene reconstruction. He talked a lot about that cartridge that was found between the bodies of Abby Williams and Libby German at the crime scene when the girls were found. On Tuesday, we also heard from a digital examiner who gave us brand new digital data in this case. And this was perhaps the most talked about information that came out of court Tuesday. This examiner went back through the data that state police had access to in October of 2017, and she says someone used the headphone jack on Libby German's phone to insert a headphone or some kind of audio cord and then took it out 5 hours later. That was the first time we had ever heard that information, brand new information yesterday. So again, a very strong day for the defense Tuesday. Wednesday morning, they come in and say, we're done.
So we had 12 days of testimony presented by the state, 4 days of testimony presented by the defense. So I will send it back to you, Scott, right now, because we're just curious to hear from Katie about her take on this. Everyone was surprised that the defense rested after just 4 days of testimony.
All right, Bob and Sam will be getting to you shortly. Let's go ahead and reintroduce Katie Jackson Lindsay. She is a former deputy prosecutor, currently a criminal defense attorney. She's been with us every day of this case. Were you surprised when you heard this morning from the defense saying, we're done?
No, I wasn't surprised. As a defense attorney, I was not surprised, because what we have to remember is that the defense has no burden. If they are going to put on a case and they don't have to, their case should simply be raising reasonable doubt or highlighting reasonable doubt within the state's case. And so what we saw with their case was that it didn't tell a story. It wasn't necessarily cohesive in the way the state's case was, but they put on the witnesses that they need to put on to hit the points that they needed to hit. And just like Sam said, they had a strong day yesterday. They've hit every major topic, and so there's no reason to prolong their case.
In your opinion, do you feel as though the defense has raised reasonable doubt for this jury to acquit Richard Allen of these murders?
I do think that they have. I mean, the biggest things that the state had would have been first starting with those eyewitnesses. None of those witnesses identified Richard Allen. Not a single one of those witnesses from the bridge pointed to him and said, that's the guy I saw on the bridge. I think that was very impactful without them even having to put on witnesses to refute that fact. And then we heard a lot of testimony about his mental state as it relates to those confessions. Those confessions are a big part of the state's case. I would argue they are the state's case. And we heard from the defense witnesses saying that he made those confessions when he was in a state of delirium. He made those confessions under very trying, challenging conditions that will cause anyone to lose their mind. And so I think they were effective in that regard. And then yesterday, they attacked the bullet, which they sort of, through cross-examination on the state's case, challenged the state's witnesses and their science used to reach those conclusions. But yesterday, they put their own witness on that said, you know, I'm not saying that this person was not qualified to reach these conclusions, but what I'm saying is that her methodology was flawed. She compared apples to oranges instead of apples to apples. And so her conclusions are not something that I think were sufficient. And then finally, their last witness cast doubt on what was going on with that cell phone. And that might not seem like a really big thing, but what that did, I think, was effectively challenge the state's entire timeline of when these crimes were committed, were the girls' bodies moved, and who was dealing with that cell phone. So I think effectively they have raised doubt. They've given the jury some things to think about, and they've really caused some problems for the state's case.
In case you're wondering why Richard Allen wasn't called to be a witness in this particular case, tell our viewers why you think that wouldn't have been a smart move.
Well, we have to always remember, again, they don't have any burden. They don't have to put on any case, right? And so then they have to balance that against Richard Allen's right to remain silent throughout the end of this trial. And so when, as a defense attorney, when you're weighing whether or not to call your client as a witness, what you really have to analyze is, what does he have to add? What could he put into evidence at this point that the jury has not already heard? We've already heard him tell his version of what happened that day when he was on the bridge. We've already heard him admit or allegedly confess to the crime, and we've heard the conditions under which that happened and his mental state at the time. And effectively, we've heard him say, I did not do it. Mm-hmm. And so when they are balancing the cost-benefit analysis of putting him on the stand and subjecting him to cross-examination and having the jury put him under a microscope and judge him, there's really not more that he can add. And so I think they ultimately decided that there was no advantage to doing that.
All right, we're going to hear more from Katie in a moment. Let's get back to Bob and Sam in Carroll County. And guys, let's talk a little bit about the witnesses the jury heard from today.
The first two witnesses, both witnesses that the jury has heard from before, and I'll tell you straight up front, they were not on the stand for very long. Both of them were on the witness stand for less than 5 minutes. Brianne Wilbur, she walked on the trail on the afternoon of the murders. She previously had told the jury that she was there in the early afternoon. And she took some photos, posted them to Instagram. One of those photos was entered into evidence today to show the jury. She was asked by the state if she saw any other girls like Abby or Libby on the trail that day, asked if she saw Bridge Guy. She said she did not. That was essentially the end of testimony that we heard from Brianne Wilbur. And then the state moved on to Indiana State Police Detective Brian Harshman. He previously testified that he has listened to hundreds and hundreds and hundreds of hours of Richard Allen's prison phone calls and seen the videos. Basically, he was positioned as the one person, perhaps other than Richard Allen's family, who has heard his voice more than anyone else, especially over the last 2 years. And he also told the jury when he was asked, do you recognize the voice on the Bridge Guy video taken on the cell phone of Libby German? He said, yeah, I recognize that voice. It's the voice of Richard Allen. So he's really the one witness from the state who, from his testimony, has identified Richard Allen as being at the crime scene. Today, he was asked about something different. He was asked about Richard Allen's time in prison, and he was asked to compare the location and the space, the cells that he was staying in, both at Westville Correctional Facility as well as Wabash Valley Correctional Facility, and most recently at the Cass County Jail. And he said basically the spaces he was in during all that time was the same. It was a small one-person cell in solitary confinement, not having a lot of communication with other inmates. He said he actually had more communication at Westville than he does at the Cass County Jail. To me, it seemed that the state was asking those questions to try and establish the fact, hey, look, you know, the defense has tried to make the argument that when he was at Westville, he was in a state of psychosis and was not in his right mind when he made the confessions. But essentially now in the Cass County Jail, you know, he's been in the same situation and he's not in psychosis there. So I think they're trying to establish the really the framework that just the way in which he's been held and the conditions in which he's been held does not explain the confessions. And I expect that we'll hear more about that tomorrow. The big witness, though, that we heard from today, the most important witness that we heard from today, Dr. John Martin, the psychiatrist, who has spent between 13 and 18 days visiting with Richard Allen over the course of the roughly year and a half that he was at the Westville facility. And I want to start off with some extraordinary testimony. Keep in mind, this was a state witness. Yeah. The state putting him on the stand. And it was fascinating the way that his testimony started. And I want to read a little bit of that. He was asked about the fact that Richard Allen was in solitary confinement and the impact that that has on an inmate's mental state. And Dr. Martin pointed out, he said that there is an insinuation when someone is placed in solitary confinement that it's because they did something wrong in prison. They're put there as an extra form of punishment. And Dr. Martin said, and I'll quote here, he said, Mr. Allen had not done anything wrong, and yet he was being treated as if he had done something wrong. That was not right. An interesting statement from a state witness saying that the way he was being held in solitary confinement for a very long period of time, in his words, not right. Yeah. But he then pointed out that the prison had a responsibility because he was in safekeeper status, which means the reason he was sent to the state prison to begin with is because they felt they couldn't keep him safe in a local county jail, and he needed to be kept away from the general population there. And that's why he was kept in such lockdown, harsh conditions in that individual cell. So, but it started off with interesting testimony from Dr. Martin pointing out that he did not necessarily seem to agree with the conditions that Richard Allen was living in during certainly most of the first year that he was at Westville. Then he went on to talk about his meetings with Richard Allen. He acknowledged that he didn't see him very often, but he first saw him in November of 2022 when Richard Allen first came to Westville. He said at that point, he described him as stable, fine, no problems. He saw him again then in January of 2023. And at that time, he said he was doing well enough that he's only required to see inmates once every 3 months. So he scheduled the next visit with him for late April of 2023, but he had to see him before that because he got a call from the prison saying Richard Allen was not doing well, that he was laying in his cell naked, rolling around in his feces, that he was eating his own feces. So he went to visit him. That was on April 13th. And at that point, he diagnosed Richard Allen as being psychotic. And he and a group of psychologists determined the best way to treat that was to involuntarily give Richard Allen some medication, antipsychotic medication. They said he wasn't in a state at that point to really even be making decisions in his own best interest. So they made a decision to give him that medication. And then Dr. Martin saw him consecutively for 5 days in a row. He said April 18th, after having several days of the medication, Richard Allen was still psychotic. April 25th, still psychotic, but doing better. And then he saw him for about once a week for the next month and a half. And he said on May 2nd, May 8th, May 23rd, May 30th, and June 20th, he said no evidence of psychosis at all.
At all.
At all
right.
that he saw in Richard Allen. And of course, that's really important because during that time frame is when Richard Allen made a lot of his confessions, saying that he killed Abby and Libby. And he told that to the prison guards. He told that to the psychologist that was there.
Yeah.
He even made a confession to Dr. Martin on June 20th. He said, Dr. Martin said that Richard Allen told him, I would like to apologize to the families of his victims. So the testimony from Dr. Martin, pretty powerful today, saying from his standpoint, there was no psychosis throughout May and throughout June, which is very different from the testimony that we've heard over the last few days from defense witnesses saying he absolutely was psychotic. And then we got to the cross-examination, and that's when things really turned a little bit as far as the testimony.
Yeah, so keep in mind that first part supporting the state's arguments that Richard Allen was in the right state of mind when he made these alleged confessions to killing the girls. But again, when the defense crossed and talked to Dr. Martin again, they played a video. They played a video from June 20th, 2023, which Dr. Martin said he met with Richard Allen on that day.
Same day that he got a confession or that he
Same
heard
day.
a confession, right?
Yeah, and keep in mind, this is more than a month after he determined that Richard Allen wasn't showing any signs of psychosis at this point. So they put this video up on the screen. About most of the courtroom, I would say, could see it. Bob and I could see it from where we were seated. And it showed Richard Allen inside the prison getting some sort of medical exam. He was seated in the middle of this room. He was restrained. His chest was restrained to the chair. His hands were cuffed at his waist. And Richard Allen just looked dazed. He looked confused. He was emotionless. He was barely responsive to any of the people who were with him in the room. At one point, he even slumps forward. A guard who's with him kind of lifts him back up into the chair and puts his hand on his shoulder to kind of keep him in place there.
For the first time
No
in Saudi
blinking.
Arabia
He was just
desert.
staring, seemed very out of it, I would say.
Wow.
So at that point, we watch a few minutes of the video. Defense attorney Rosie shares with the courtroom that the video is about 20 minutes long.
Right.
He had intended on playing 8 minutes of that for everyone in the courtroom today, but they only got through a few minutes of it before the judge asked for a sidebar. They came back from the sidebar. We didn't see any more of that video. But this witness, Dr. Martin, was asked really several times from a couple different people after seeing that video, does it make you change your mind? Does it make you reconsider your statement that Richard Allen wasn't psychotic at that point? He never really gave us a good answer.
Well,
Depending on who asked the question, it was kind of back and forth.
we got multiple answers. The
Right.
first time he was asked that question was by Stacey Diener, one of the deputy prosecuting attorneys, and she said, anything in that video that you just saw, does that make you change your mind in a report that you wrote
Right.
on June 20th? That day, you wrote a report and said he was not psychotic and did not show any signs of psychosis. Anything you just saw in that video changed your mind? He said no.
Yeah.
Then on cross-examination, just about 5 minutes later, he was essentially asked the same question
Yeah.
by defense attorney Brad Rosie. And he said, does that video make you want to perhaps change your diagnosis of what you saw that day? And Dr. Martin said,
Yes.
yes. He said, yes, it does. And
Yeah.
then redirect again, going back to Stacey Diener. She said, I want to clarify here. When you look at that video, does he look psychotic there? And he said, no. And she stopped him really quickly and said, okay, that's it. No more questions. And she moved on. So we got back and forth responses from Dr.
Yeah.
Martin. And you have to wonder what the jury made of that.
Yeah, and just like so many other witnesses, again today they asked great questions to some of these witnesses. And one of the jurors asked specifically, do you think it's possible that Richard Allen could have been in and out of psychosis during that 24-hour period where, yes, Dr. Martin met with him. Yes, we heard this confession. Yes, we saw this video of him getting medical treatment. Do you think he could have been in and out? And Dr. Martin said yes.
It is possible. That's what he
Yeah.
said. And just in general, the jury asked, is it possible that a patient who is psychotic can be in and out of psychosis within a general 24-hour period? And he said, yeah, that's possible, which then raises questions about all those other dates that he found Richard Allen, that he said he was not psychotic, because on the morning of June 20th, we know Dr. Martin said that he met with Richard Allen very early that morning. So by the time he was in the chair,
Yeah. So I think all of this to say, I mean, Dr. Martin was our final witness of this case.
Yes,
The
yes.
final moments of testimony. He was called by the state. And this was probably not what the state was hoping for. It was not a home run for the state by any means.
No, it really wasn't.
Yeah.
Scott, we'll send it back to you, and Katie, be interested to hear her take on that testimony today.
All right, Bob and Samantha, thanks so much. We'll get back to you in just a second. Let's bring in Katie, find out what you thought about Dr. Martin's testimony as the way that Bob and Samantha described it.
Well, I would agree with Bob and Samantha that it doesn't seem that it was a home run for the state by any means. It's almost another one of those scenarios where you wonder if they asked questions that they weren't prepared for the answers for. Because certainly with a rebuttal witness, you don't want to call a rebuttal witness that just corroborates the state's evidence. I'm sorry, the defense's evidence. You want to call, as a prosecutor, a rebuttal witness who will poke holes in what the defense just presented. And in some ways, he completely corroborated the defense's position. I think it's a very big deal that he made the statement that the conditions under which Richard Allen were kept were just not right. They weren't right for someone who was simply accused of a crime. And then he goes on to give these opinions that it sounds like the defense was effective in getting him to backtrack on, in terms of whether he actually was sure that Richard Allen was in a state of psychosis. And so the reason this is really important, and even with the back and forth, it's still really effective for the defense, is because remember what we've talked about throughout the trial is that the jury has an instruction that if the evidence lends itself to two reasonable interpretations, they have to choose the one consistent with Richard Allen's innocence. And so now they have evidence in the record from the first set of state's doctors that said he was not in a state of psychosis. Then they have evidence in the record from defense witnesses, qualified defense witnesses who have testified for both sides, saying, no, he was in a state of psychosis. And now they have their final witness from the state saying, I'm just really not sure. And so in reconciling that, the jury has two reasonable possibilities. And if they follow the instructions of the court, they should decide the one that is consistent with his innocence, which is that he was in a state of psychosis, and these are not actual confessions, they're false confessions.
Do you believe, Katie, that this case is going to boil down to Richard Allen's mental health and the confessions and these psychiatrists that we've been hearing? Is that where this jury is probably going to land in terms of whether or not to find him guilty or not?
I think that's a really strong possibility. We've said over and over that it's really hard to convince a jury that your client didn't do something that they are admitting to doing. And so I think there's absolutely reasonable doubt as it relates to the bullet. And before these alleged confessions, that was the only thing that put Richard Allen at this crime scene. There's absolutely reasonable doubt in terms of the identity descriptions that were given from the witnesses who were actually around the scene that day. And so what it really comes down to is his own alleged admissions. And does the jury believe those were true confessions, or does the jury believe they were false confessions as a result of psychosis?
Right. Because as you remember from the very beginning of this trial, those witnesses that the state brought up, they were describing a man that doesn't appear to be Richard Allen.
Exactly.
They were describing a tall, muscular man in his 20s with brown, poofy hair.
Yes.
And that's not Richard Allen. He's 40 and shorter and a little heavier. That was the state's first witnesses. And then this so-called magic bullet that was found, which was a cartridge that was cycled through what the state believed was Richard Allen's gun, discovered later on at his home. You know, there's been some, speculation as to where that bullet came from. And then there was no DNA of Richard Allen's found at the crime scene on these girls, and no DNA of the girls found in Richard Allen's home when they went in and found knives and a gun and that kind of thing.
Exactly. I mean, really, Scott, you just sort of did their closing arguments, right? Did the defense's closing arguments. And when all of those things on balance, the jury has to have doubt as it relates to the state's case and how solid the state's case is. And so they have to be really relying on those confessions.
Right.
And so I think what the defense has been able to put on, and then coincidentally, what the state has put on today has just cast more doubt on the validity of those confessions.
Before we get back to Bob and Sam, I want to ask you one last question about this Indiana State Police detective who listened to hundreds of hours of Richard Allen phone calls. And he was, as I remember, was the only one who was asked in court, can you identify the voice that you heard on the, down the hill video, the one that we've showed lots of times here on Channel 13? And he was the only one who said, yes, I recognize that voice. That voice is Richard Allen. But the other state and defense witnesses were not asked to say, do you recognize the voice on the down the hill cell phone video on Libby's phone? They were not asked. So really it's one person who is connecting Richard Allen to the down the hill video, right?
Exactly. And what is even more curious about that strategy is that he is the only person who only heard Richard Allen's recorded voice. We've heard from a number of people who spoke to Richard Allen in person, face to face, and the state chose not to ask a single one of those people whether or not they recognized his voice as compared to that video. And I think this could really hurt the state because when the video was first played for the jury, we heard a lot of testimony about how that video had been manipulated in a way to isolate the sound or to keep the video from moving. And we didn't hear any testimony about how that would affect the quality of that sound or how it could potentially modify the sound on the video. And I don't know, maybe that's not a thing, but I think strategically, it should have been important for the jury to understand that this is actually how the voice would have sounded. And they didn't do that. And so I think that was a missed opportunity in terms of tying up his voice later. And again, they didn't ask anyone who spoke to him face to face whether or not they could identify his voice on that video.
So this jury will likely get this case at some point on Thursday. I know it's impossible to guess what this jury may be thinking and what they may be deliberating, but what are your thoughts when they get this jury? Is this likely to be a quick verdict? Is there a possibility of a hung jury? What do you think?
Well, they've heard a lot of evidence, right? And so I think considering the seriousness of the case, the respect for these young girls who have lost their life for whatever reason, senselessly, right? I think they will take the time to review the evidence. And so that in itself will take some time. But in terms of the deliberations, it really just depends on where they are right now. If they are all on one accord in terms of deciding that the state has not met its burden of proof beyond a reasonable doubt, we'll get a quick verdict. But on the other hand, based on their questions, we can kind of get an idea that they're not all on the same page. They're sort of all across the board in terms of what they're thinking. And so I think it'll probably take a while.
All right, Katie, thank you again for your insight. Let's get back over to Bob and Sam and find out from you what is next tomorrow, Thursday.
Well, you were just talking about how difficult it's going to be for the jury to kind of sort through all the evidence. And I do think that this jury they've been so inquisitive. They've been so curious. They're kudos to them. They are really taking this weighty responsibility very seriously. We know that they have heard from 64 separate witnesses between the state and the defense. We know that they have almost 400 exhibits that they have been asked to review. They'll have those exhibits at their fingertips. So yes, this is, it may take them, if simply just reviewing all of that is part of their responsibility, we expect that's going to take a while.
Yeah, and to your point too, I mean, there was concern long before we actually got to trial about can we find an impartial jury? Can we find people who are going to take this seriously, who are going to be invested despite the difficult, brutal content being sequestered for more than a month now, right? But talking about how involved they've been and asking the questions. And now we're to this chapter where we are going to hear from both sides, closing arguments, and then it's up to them. This is really their time.
It is. To give you an idea of what's going to happen tomorrow, the judge asked both sides to be ready to go at 9 a.m. to present the closing arguments. We know that the state will go first, and the state will get up to 2.5 hours to present its closing arguments. Then we're told there will be a break. Then it will be the defense's turn. They will get up to 2.5 hours as well. And then the state will get the last word, one more shot at talking to the jury before the jury will then get instructions from the judge. And those will be very detailed instructions that they will get on how to conduct their deliberations. We heard, for example, one of those things that was discussed by both sides today, a reminder to the jury, as Katie was mentioning, Richard Allen is choosing not to take the witness stand. He did not take the witness stand. The jury will be instructed that he's not required to do that. He has the right not to take the witness stand, and that should not be held against him. So that is one of many instructions that the jury will get in this case, and then it's off to deliberations.
So we know that could happen, like Scott mentioned, as early as tomorrow afternoon.
Yeah.
There's still a lot of unknowns. Could the jury deliberate on Sunday, for example, if we get that long? Is there going to be a cutoff time per day to kind of allow them some time off? What does that look like? We still don't know. One thing we do know is that, like we mentioned, it could start as early as tomorrow, jury deliberations. We hear from the state, like you mentioned. We'll take a break. We'll hear from the defense, state one more time. And then from there, we'll be ready. We'll be ready and we'll be here.
Yes, we've been here for the better part of a month so far, and as we are nearing the end of this trial, and especially once we are awaiting a verdict, 13 News will be here. We are lined up every day. We have a media credential to be inside the courtroom for many days. On days we don't, we line up with everyone else to be able to have a seat inside the courtroom. So we are gearing up for the very end phase of this trial.
Yeah, and I think just quickly, Scott, before we end, something else that's important to mention is today I talked to a woman who was outside the courthouse. She was holding a sign, and the sign said, "The world is watching." And the world is watching. There's international media here in Carroll County, Indiana, because of the intensity and the drive behind getting justice at the end of the day for Abby Williams and Libby German, and that we are finally in this final chapter.
And we heard in the very first days of this trial, one of the witnesses say the one thing about these events is it has turned Delphi and everyone in it upside down. So this town is looking for answers, looking for closure. We are expecting here within the next few days, we will hear back from the jury, and we will see if some closure is just around the corner. Scott, we will send it back to you. And again, we will be out here 9 o'clock tomorrow morning to bring you the closing arguments here in the Delphi murders case.
All right, Bob Siegel and Samantha Johnson doing such a remarkable job. There are no cameras allowed in this trial inside the courtroom, but watching Bob and Samantha, and when Emily Longnecker has been there, it is as if we are inside the court. We are hearing remarkable details every night here on the Delphi Debrief. Thank you so much again for your work. We're going to be breaking down the Delphi murders trial every weeknight at 10 o'clock here on WTHR+. You can also find our ongoing coverage, including detailed reports on each day of this trial, by going to WTHR.com/Delphi. You can also scan that QR code. Thanks so much for joining us.
I get that. Hold on. We are still waiting for the court to resume from Brian Kohlberger hearing. I guess the judge is contemplating and thinking, which is fine. I'm having, somebody asked what I was having. I am having my hibiscus tea from Ollie Tea, our new sponsor. And then I am, Sensei, go lay down. Don't beg for food. I have a tomato, some pineapple, and a banana. This here is a spiced salt. It's a roasted applewood spice salt. It is so fabulous. It's more seasoning than salt. From a small company here in Texas. Absolutely love them. I love supporting small town businesses, and I love this company. They are so good. So anyway, let me see what else we can find to enjoy. Let me share this. So we're still waiting for them to return, although it's my understanding it won't be much longer. State recalls witnesses as defense rests. We got a lot going on. There's a lot of cases that are popping right now. And let me know if there's anyone that you're highly interested in. Let's watch this.
Sarah. That's my name. Don't wear it up.
This is a box. This is the box where George Torres was killed.
We, the jury, find the defendant guilty of murder in the second degree.
We respect the jury's decision. I'm sure that Sarah Boone is going to want to appeal.
Oh, she's something else, Sarah Boone, isn't she? We're talking about her allegations of prosecutorial misconduct, allegations of bad rulings, according to her. Should these things tip the scales in her favor in her bid for a new trial? So Sarah Boone, convicted 2 weeks ago of murdering her boyfriend, George Torres, and her defense team made it clear right away that she planned to take an appeal. Well, that team is now gone. So what are her chances of success? Let's dig in on this. I want to welcome in our resident expert on the Sarah Boone case, Court TV digital producer Lauren Silver, and still with us, high-profile criminal defense and civil attorney John Phillips. Okay, Lauren, so you've been digging into this motion. Give us the gist, please, about what she's saying that was done wrong here, and why is she deserving of this new trial?
Well, James Owens, back representing Sarah Boone, don't know that he'll represent her through the appeal, but he at least filed.
Lodson is present as well at this point. The state is present through its attorneys. I think next we started those categories that I identified as the 9th topic. We'll continue with those and then circle back to the 8th. So let's talk about the state's concern about the grand jury not having considered the aggravating factors. Next. Mr. Logson.
Thank you, Your Honor. Apologize for not being able to be here earlier for proceedings, Judge. I overbooked myself today.
Are you sure, Eddie?
You're here.
I can hear it.
Your Honor, as to the argument as to including the
Don't get me lying.
Statutory eligibility requirements for a death case in the grand jury, I think the two major hurdles that we have to get over are, one, the Hurtado case not requiring the grand jury to apply to the states. And then the second is the ruling in Abdullah that essentially said you don't need to provide these to the grand jury. As
Seemed like a good place to start.
it is a good place to start. And as we tend to do in these cases, because they are going to go up on appeal, we are of course asking that those things be overruled. Certainly recognize your honor doesn't have the ability to do that, but we respectfully make the argument that those cases were wrong. We also make the argument that there is another way to get there. So the Fifth Amendment obviously is the grand jury amendment, and I think Abdullah was looking at the Sixth Amendment or notice requirements and what needed to be included there. We furnish an additional argument that the Eighth Amendment in death cases requires additional process. And we see that largely in what occurs at the sentencing hearing, but we also see it in things like requiring counsel before it was required for anything else was required in death cases. We also see it in requiring the state of Alabama to permit a lesser included instruction so that a jury can choose something besides something that would lead to
Let
death.
me ask you a question about that. So on the one hand, as I understand your argument, it is that the grand jury should be required to not only find an aggravating, statutory aggravating factor, but also that the grand jury then weigh it against mitigating evidence. Is that your position?
No. Let me be clear. As we would talk about in the trifurcation motion, I'm only talking about the statutory aggravators, not the non-statutory aggravators or the mitigators. It would simply be.
Your brief says otherwise. So that's why I question that, because as we've learned, that takes a long time for those things to be developed. That's not necessarily evidence in the pocket of the state. What is now gone from a case timeline of several months to now multiple years would seem to me to even drag it out longer.
And I certainly understand that concern. I don't think that that's our position. I certainly do believe that the law would require the state to put on mitigating evidence if it had it, because that's something that they're required to do by law. They're required to put on evidence if known to them would possibly point in the direction that the person is innocent, et cetera. But I don't think what our position is that the state would be required to put on essentially their entire sentencing hearing in front of that grand jury. The grand jury is still only just determining whether or not there is a reason to go forward with the case. Our point is that at the time of the founding, that grand jury would have known that all felonies lead to the gallows. So at that time, grand juries were making decisions about whether or not people were going to face the death penalty. And it wasn't until the Supreme Court after Furman in the 70s that we came up with this entirely new system. But it's one where the grand jury has lost its part of its function, where it's looking at whether or not these people should be facing the death penalty or not. Essentially, they were deprived of that through the transition that was obviously intended to protect people from an arbitrary infliction of the death penalty. But the grand jury itself is supposed to also have a role in that. It's supposed to protect people from arbitrary decisions. And so that's essentially what our argument is that there should be a neutral fact finder placed between the citizen and the state when we're making the decision whether or not the death penalty should be sought. And so that is one of the reasons we're asking the court to strike the death penalty in this case. Does the court have any other questions for me? Thank you, Judge.
Your Honor, sounds like on Abdullah, this is just a issue of issue preservation, so I don't have much to comment on that. In terms of this other argument that they are saying you can look at it differently through the Eighth Amendment, keep in mind the Eighth Amendment is just the prohibition on cruel and unusual punishment. It's quite a stretch to jump from there to requirements on what needs to be presented to a grand jury. The Beck case that they cited suggests that maybe there could be a connection if that diminishes the reliability of the sentencing determination or the guilt determination, but that's not the function the grand jury plays. And so for this court to stretch the Eighth Amendment all the way back to the grand jury would be,
in fact, with respect to failings of a grand jury to pass on a particular element. For example, if there's then been a trial, the general standard on appeal is, well, the matter went to a jury and they made the determination there's proof beyond a reasonable doubt, and therefore any error is moot.
Correct, Your Honor. And I think really that gets to the heart of this claim, which is it's just kind of another way of their argument that it shouldn't be the prosecutor deciding that a notice is filed. And the U.S. Supreme Court has said it's not a problem if the prosecutor has unfettered discretion in who gets the death notice and who doesn't. So that by itself isn't a problem. So unless there are any other questions, thank you, Your Honor.
Thank you. Any rebuttal?
Well, I think it would be best to push back at least a little on the idea that the Eighth Amendment can't go back that far. I mean, recall that it was the Eighth Amendment that required that there be counsel for people that were facing the death penalty. Now, I certainly understand the idea that the Eighth Amendment's concern is that we have a reliable procedure. I certainly understand that. But the grand jury, it does fulfill some of that function as well. And besides, at least if we're speaking in terms of what was understood to have a grand jury and what it did at the time that the nation was founded, it would have been stepping in a case involving a possible death penalty and being able to put a stop to it then and there. And so I do think that the Eighth Amendment has the ability to attach even that early on, at least in cases involving death. And then I recognize that there are these cases from the Supreme Court indicating that prosecutors do not have to have anybody determine whether or not they can file the death penalty and that they can drop it out of a sense of mercy. I think that's a slightly side question to, if they choose to go forward with it, who can stand up and say, before we spend years on one of these cases, that this is not the appropriate case, someone besides the prosecutor, which is what we have with grand juries and preliminary hearings, et cetera. And so we still believe that the argument here is one that can be passed on by this court and that hasn't necessarily been ruled on by these other cases that we also think should be overturned. Thank you, Judge.
Thank you.
I believe I have all the remaining arguments, so whichever the court would like to.
Let's finish up topic 9 with your contention that the death penalty should be struck because it violates international law.
Ronnie.
Thank you,
The
Your Honor.
death penalty got struck.
So that motion is largely premised on the International Convent of, I'm gonna have to pull it up because it's the ICCPR. International Covenant on Civil and Political Rights. And so essentially the argument comes down to this. We have signed and ratified a treaty that would put, we think, additional requirements on what we would do if we're going to have a death penalty in this country, and obviously we have one. One of those is a requirement that we make sure that we're not arbitrarily killing people. And the other one is that people are not being essentially tortured.
My understanding is when the time that convention was ratified with the understanding that to the extent that it is agreeing to anything, it is agreeing to afford the Eighth Amendment protections.
That's correct, Judge. And I think to some extent, what
The
we're
judge
arguing
looks
is
so bored.
the Eighth Amendment and the ICCPR work together, and that we can look at these international obligations and the Eighth Amendment and say that for them, they essentially are the same thing. That's why we talk about.
Well, I think you're looking at it from two different prisms. I think what the state is saying, to the extent that this covenant applies, which, you know, is a question about whether it's self-executing and all the rest. It only governs to the extent that the Eighth Amendment, apart from that, would have protected that situation. Whereas what I think you're arguing is that the Eighth Amendment must be read to be broader as to what international law would dictate.
I think if what we're saying is that the state would argue that we read the Eighth Amendment and that's what the international law must be, we're saying you have to read the international law to decide what the Eighth Amendment.
So you're having the international law dictate what the United States Constitution means.
Correct. And we are doing that on the basis of what the United States has said itself about the fact that they believe that they live up to these things, and the fact that we have, we discussed the charming Betsy canon, which is obviously a very old canon and typically is just about whether or not our statutes are in line with our treaties. But I think particularly in this case, where the United States has essentially said, you know, we signed on to this treaty because we live up by these same standards that everyone else does. We can look at what the international community thinks about those standards that we said we also abide by when we're determining whether or not we're living up to the standards in the Constitution.
But what they said specifically is that we think that we are living up to those, even though we have and will enforce a death penalty.
And I think, which is why we're not saying necessarily that the death penalty would be struck if it was done properly. Our argument is that way that Idaho has its scheme set up, there are far too many statutory aggravators, and some of them are just big enough to drive a Mack truck through. And so just about every murder could be charged and have the death penalty attached to it. And so that doesn't require the narrowing that we've said we're going to provide, and it certainly doesn't live up to what the international community would expect from us.
I understand the argument.
Well,
I'll be frank, it's falling about as flat as you would expect it to fall before our Supreme Court or the Supreme Court of the United States.
Well, Your Honor, it's an argument and it must be made. So
you need to make a record.
Thank you, Judge.
Y'all, that was spicy. Holy
Unless there are any
cow.
questions, I'm okay.
I don't. Thank you. All right, let's talk about the contemporary standards of decency.
Thank you, Your Honor. So I think the main case for this one was Roper v. Simmons. Unless I'm confusing it with Atkins, but essentially the court has said that when deciding what contemporary standards are in terms of what's cruel and unusual, that the court first looks at what the state legislatures are doing and then makes a decision based on its own determination of what it is it's going to be. But when we look at those cases, they also look at other things. They look at international law. They look at what religious organizations are saying. I mean, they're obviously looking for what's the consensus going on.
I think Supreme Court, Idaho Supreme Court said is what we look at is legislative and governmental determinations and actions.
That I think I think that's Abdullah where they had said that. And I think that was partly because the way that it was and in those cases, it seemed like the record that was brought up to them was somewhat sparse. And so hopefully we've provided more information than they had at those times. But in those cases, the number of states that still allowed the death penalty, I think, was around 35. And as the court, as we noted, that number has dropped somewhat precipitously since that time.
And those would be the legislative activities. I think what I was, I guess, taking issue with is the idea that they would look to what religious and other sort of non-governmental advocacy groups would argue or accept.
Well, I can only say that Roper definitely looked at international law. And if it wasn't Roper, then it was Atkins. But the one about children and whether or not they can face the death penalty, they definitely looked to international law. And so I don't think there's anything that says that the court can't look at whether or not organizations have moved against the death penalty. We are becoming somewhat alone in the world in terms of continuing to make use of the practice. The number of states that are still doing it is shrinking. And so when you look at that total fabric, it's our contention that we've reached the point where the death penalty really ought to be abolished. And so that is our contention in this case. Thank you, Judge.
I know I couldn't either.
Thank you, Your Honor. While Roper may have looked at some international law, I think the Idaho Supreme Court has really narrowed that window. First in Abdullah,
I'm trying. I
they
don't know
said,
anything
therefore,
about this
absent
case,
some
y'all.
legislative or executive action, a determination by this court that Idaho's death penalty statute is unconstitutional based on evolving standards of decency and public opinion is unsupported. So they're really looking in at that. And fast forward 5 years,
They're
in
wanting
that,
to take.
Hurston decision.
Okay, they're claiming the defense wants to take the death penalty off the table. The reason why? Because that state cannot access the medication that used to be used in terminating an inmate's life, and thus a lot of cases with that particular verdict have been sitting waiting for the ending of their life. And well, they basically say that's cruel and unusual punishment. So they're trying to get the ending of life penalty, death penalty off the table, and get it for life, life imprisonment.
2020, the Idaho Supreme Court reaffirmed that view and then also said, quote, "We continue to subscribe to the view of legislative bodies as the basis for determining a national consensus." And so, and the reason for that, they explain in Abdullah, is that courts just aren't good at taking a temperature of public opinion and what represents society's views. Now, looking at the states that have capital punishment, according to the resources both sides have cited, there's 27 states that still have it on the books. That's a majority. They've pointed out that there's gubernatorial moratoriums in 6 of those, which is true. But that means worst case scenario, there's 21 states that still have the death penalty on the books and can use it. And what the Idaho Supreme Court said in Hairston is that we're looking for a national consensus. And we're nowhere near a national consensus that the death penalty is somehow immoral or improper or indecent.
I was hoping.
I would also just note, it's not enough if what you're trying to show is a national consensus. It is not enough to just point to the fact that a state doesn't have the death penalty. You would have to show that the state removed the death penalty because that state believed that it was immoral or improper. So for example, if a fiscally conservative legislature just decides they don't want to fund the death penalty, but they have no moral objection to it, that's not evidence that there's some societal standard that would.
What do you take of evidence from a state who is not enforcing the penalty because, for example, an executive of that state is morally opposed to it and has the power to preclude it from being applied? Should that be considered?
So the Idaho Supreme Court did mention executive action, although in Hairston, they seem to say the better picture is painted by legislative bodies. And I think part of the reason for that is because the executive, it can just depend on the administration that's in power at that moment. A perfect example of that is the United States. The death penalty is on the books. It's currently not being applied, but shortly before the current administration, it was. And I think it's safe to assume that it will be again here shortly. The other thing you have to look at is, why is the executive doing this? For example, the defense cites that Tennessee has currently a moratorium. True, but the governor did that because he said we need to take time to fix the execution protocol. That's not evidence of a national standard that the death penalty is wrong.
So in a state like Tennessee, are they still in the sentencing
capital sentences, but just not carrying them out, or have they stopped even trying capital cases?
I can't answer that definitively for Tennessee. My understanding is that they still try them and impose the death sentence, but that it's just not being carried out. I know that to be true, for example, in California, juries are still imposing the death penalty. I know in Ohio, another state that they've pointed to where there's a gubernatorial moratorium, there are 30 scheduled executions in that state. They keep getting pushed back, but the reason they're getting pushed back and the reason for the moratorium is they can't find chemicals to do lethal injection. Again, that's not evidence that there's some standard of decency that's keeping them from doing this. They just can't find the chemicals to do it. So I think,
Well, I mean, you could imply that the standards of decency as applied by the pharmaceutical companies who refuse to take part in it is some measure of that.
potentially yes, but I think again, going back to the Idaho Supreme Court's decisions, we're looking specifically at executive and legislative action. And the fact that the legislature or governor is saying we would do this, but we can't get the chemicals is actually evidence that they still support the death penalty. So I think no matter how you read the numbers, we're not at a place where there is a national consensus that the death penalty is indecent. And so we think the court should continue to follow what the Idaho Supreme Court said in
Oh,
both
yeah.
Sepula and Hairston.
We do still have
reject their motion. Thank you, Your Honor.
And life means life, not 30 years. Some places, after 30 years, you should.
I would. I would caution the court trying to figure out why it is that a particular state either dropped the death penalty or imposed a gubernatorial moratorium. I mean, I think that these things are complicated. That looks an awful lot like trying to figure out from legislative history why something occurred. Half the time, what you see in the questions doesn't necessarily tell you what the legislature had in mind when they finally voted.
I would caution you not to caution the court.
The first step, as the United States Supreme Court has set it out, is just to look at the numbers. And then after that, the courts can consider other things.
Or 2021, if you take into account moratoriums. How, I mean, certainly more than a third of the states, how does that represent a consensus?
I would argue that the consensus can also come from the trajectory. So the fact that so many states dropped the death penalty within the last 10 years, and that appears to be the direction that things are going, is something that the court can take into account. I also note a lot of these states that have death rows and don't have a moratorium still aren't actually executing anyone. And so the actual number of executions in the states that are actually executing anybody is less even than that. I think it's something like 13 jurisdictions that are actually doing executions. So anyway, for those reasons, Your Honor, we are asking that you strike the death penalty.
Thank you. All right. I think that leaves us with your motion to trifurcate the proceedings and to apply the rules of evidence in the penalty phase.
Right. So, Your Honor, I tried a case via the trifurcated method. It went smoothly, and we moved this court to do the same thing. If it's not trifurcated,
which case was that?
That was Renfro.
Which one?
Renfro. If it's not trifurcated, what happens at in the penalty phase is the state would be putting on both statutory aggravators and non-statutory aggravators. I think the states argued that some of those things.
Isn't there a post-conviction proceeding in which it's alleged that that is ineffective assistance to allow the trifurcation because you make the jury decide about whether or not an aggravating factor is there in the absence of any mitigating evidence that might otherwise affect their decision?
I'm sure there is. But I can't say that I agree because from a jury's perspective, I mean, you have to realize that these are people who have been pulled in, they don't have legal training, and now you're asking them to make a bunch of different decisions at the same time. And as we pointed out, I mean, we can go back and forth about, what's the if you don't trifurcate, you're going to put on the victim impact during the penalty phase with everything else, right? And so whether or not there's even a statutory aggravator is now going to be influenced by all of the things that are emotionally really powerful. And so
Okay, do you guys know what trifurcate means? Trifurcate means to divide the trial into 3 sections. That's what it means.
So, I mean, we can go back and forth about, who does that prejudice. At the end of the day, a trifurcated proceeding is just simpler for a jury to do their job. They have to be able to make a decision about statutory aggravators to even have a death penalty in a particular case. Being able to do that with just a standalone, do these things actually exist first before you start to get into the mitigating and aggravating? I mean, you can put on some mitigating depending on what the aggravator is at the aggravating portion of the case. You can talk about future dangerousness and things like that, assuming that the court decides to let it in. But if you don't do it this way, what you risk is that a jury is going to be influenced by non-statutory aggravators, victim impact statements, and on those grounds, say yes to one of the statutory aggravators. And, you also are telling the jury, these things you have to find beyond reasonable doubt, but these things you don't, and do all of that at the same time.
That's not what these.
And the studies have shown that juries really want to get these things right, and they really want to follow the law, but oftentimes the instructions that they get aren't really that clear.
That's not.
And I think adding to their burden
that's
by
the way it works.
cramming it all into one hearing, it's unnecessary. The court has the ability, I think, under Rule of Evidence 106, to let them do the function that they're supposed to do with the statutory aggravators. And then that way they can make that decision. And if they don't find any, you don't even have to do the next part. But if they find one, then you open it up into the state's case in aggravation and the defense case in mitigation. In terms of using the rules of evidence, as we pointed out, a number of courts have said, confrontation clearly needs to be able to apply. You have discovery that needs to go out. Rules of evidence are helpful, and they're certainly helpful when you're talking about the statutory aggravators themselves.
Trifurcate or strifurcate. How do I say this? Sometimes a case is so complex and overwhelmingly so difficult that they can request that the issues be divided up, if I'm correct, and have 3 separate little trials or 3 separate trials, if I'm correct. That's what I learned in my classes. So how he's using this, I'm not sure I'm making a full connection yet.
That's an area where if you're trying to make a accurate determination of whether or not those things exist such that you can have the death penalty, the use of the rules of evidence is, I think, can be detrimental to both sides if you just kind of allow willy-nilly whatever to come in. So for the other reasons we put in the brief, Judge, we are asking the court to consider doing this as a trifurcated trial if it gets there. Thank you.
And Your Honor, just to briefly address the point about the confrontation clause and the rules of evidence. The defendant has fairly acknowledged in his brief that the Idaho appellate courts have issued binding precedent that's contrary to their argument today. The state's not going to belabor that point. I think the case law is clear and the state briefed that. As to trifurcation, the defense has yet to lay out what exactly this process would look like. And what I mean by that is, at what point it appears, although the defense has not explicitly stated this, that they would encourage this court to adopt a procedure where the state puts on all of its aggravating evidence for all of these statutory factors, and the jury then goes to deliberate on these factors without hearing any of the mitigating evidence. Now, this is very concerning, and particularly the state briefed this. You take the propensity aggravator, where the jury is tasked with determining whether or not the defendant's going to pose a continuing risk, to send them back to deliberate without allowing them to hear evidence in mitigation. That's very concerning to the state about what that might do to, for example, the appellate record. And I think that that post-conviction proceeding in the Renfro case really highlights the concerns with this procedure that they're asking the court to adopt. As to the assertion that this is simply too confusing to the jurors, the court will instruct the jury on what the law is. And as we've argued on these other motions, the court can't just start with the assumption that jurors aren't going to follow the law, that it's simply too concerning or too confusing for the jurors. The jurors will receive instructions. They are presumed to follow those instructions as a matter of law, and the court should assume that these jurors will do as they're instructed. And unless the court has any questions for me, that's all I have. Thank you, Your Honor.
Well, for the record, it really wasn't that confusing. We had the propensity aggravator in that case. We put on evidence that pushed back against that at that point in the case. It's cleaner from the jury's perspective. It was cleaner from our perspective. I don't think we even argued about it. I think the state just went along with it. And I thought it went pretty well. And I definitely want to push back on the idea that, we have a tendency to have these tautologies in the law where we say, well, the jury is great and they'll figure it all out. And so long as we tell them what to do, then they've done what they were told. And there are studies that show that's just not accurate. I mean, there's the jury project. You can read what it's like for people to go through these things. And when we're talking about whether or not somebody's going to be put to death, I think it's important that we really think hard about how these people are going to make these decisions. If we're going to do a normal, just a penalty session, I definitely think it's something that's going to require some additional instructions. I know the Supreme Court just recently updated a lot of the ICGs, which is great, something that I've been advocating for. But there are additional things that I think are going to have to be told to a jury so that they can understand how that would function. And if you trifurcate it, it's going to make it simpler for them to understand, okay, you've now found this person guilty. Now you're going to be determining whether or not one of these statutory factors exists. This is what they are. This is how they're defined. You have to find this beyond a reasonable doubt. The state's going to do an opening statement and a closing. They'll put on evidence as to whether or not these things exist. This defense is going to come in, question those things, put on their case why those statutory aggravators don't exist. And you're going to make that determination. If you make that determination, then we get to a sentencing proceeding where the state's going to be able to put on any additional aggravators that it wants to put on, and the defense can then put on any other information that they have that's going to be in mitigation. It works, and it worked, regardless of whether or not the SAPD doesn't agree with me. I'd ask the court to consider it. Certainly, if the court decides not to do it, we'll have lots more conversations about how best to do that.
It's an intriguing idea. The concern, of course, is the desire to do this case once and not twice. And there's a protocol that has been approved by the appellate bodies versus the one that you're proposing now. And so that's always in a trial judges who tend to be fairly risk averse difficulty.
Yes, sir. Well, thank you.
Thank you, sir. My dance sheet indicates that we have covered all the topics. Did I miss anything from either of your perspectives?
Not from the state, Your Honor. No motions, Your Honor, but I think Ms. Massa has one thing.
One
Okay.
housekeeping.
Sure.
Judge, we submitted Professor Cover's PowerPoint and her data. We filed it this morning under seal. We had a conversation that you thought that that should probably not be under seal, definitely with the PowerPoint. We have no issues there. It was filed with one thumb drive. We discussed letting us look to see if there is victim information that needs to be redacted. So what I'd like your permission to do is file an amended Exhibit A, and if we'll get things redacted. The one that's filed and you are inclined not to seal, I just don't want it to get out there before we've had an opportunity to review that and redact names.
I'm assuming the state doesn't have an objection to that.
No objection, Your Honor. Thank you.
All right, and that's fine, counsel. Let me address, that brings up a good point in terms of just process for filing matters that need to be sealed in some way or the other. Because as we know, the rules for filing require them to be physically filed if you're seeking to have them filed under seal, which causes some difficulty for most of you who are not in the Treasure Valley area. I think perhaps the best way to deal with this is if you're going to file something and there's some portion that needs to be under seal, if you would provide a redacted and an unredacted copy. So for example, I think the defense filed a recent request for discovery and had an exhibit attached that they felt should be sealed. I'm assuming that's why they requested it to be sealed, was because of the exhibit. So you would file that one with, the exhibit just being a blank page saying redacted, and then provide the court and opposing counsel a courtesy copy of the unredacted, and then you can file the unredacted when you are here to get it filed under seal. And then we can let the public have the redacted version so that we, as much information as we can make public, we can.
Do it that way. Thank you.
That works for everybody.
Thank you, Your Honor.
Else for today?
Nothing else for today. There was a motion filed that got placed under seal that the court was going to schedule.
Is that about your jury voir dire procedure? Yeah, I think that's probably more appropriate to take up as we get closer to the pretrial than anything, because it really deals with essentially what is and isn't allowed in voir dire and in questioning. So I think it's just a little early in the game yet to get to that, from my perspective at least.
Your Honor, the only thought I have about that is perhaps talking about that may cause the court to think we should begin voir dire maybe a tiny bit earlier than is currently scheduled.
Well, we can, I think our pretrial is in May, correct?
I don't recall.
I think it's
I
in
would trust the
May.
court on that.
And our voir dire is set to begin in August or late July. I can't remember. So I think we have some flexibility there, and perhaps we'll address it at another hearing before the pretrial. I just thought with the number of motions we had today that it was probably something we could save for a later day.
Fair enough. Thank you.
All right. Anything else?
No, thank you, Your Honor.
So that I'm clear on the record with respect to why I sealed that, I don't think you submitted that intending it to be sealed originally. The reason I did is because it had in there specific questions that can and can't be asked of folks who are being questioned for voir dire. And because of the extensive publicity here, I don't want to unnecessarily limit our available groups of Veneermen because they've read something about what questions to specifically expect to be asked. And so that was
That's reasonable.
my reason for sealing that. Okay. All right. Well, thank you, everybody. Have safe travels back. I will take the matters under advisement and issue written opinions forthwith. Thank you.
All rise.
Okay. That's all she wrote, y'all. I haven't followed this case. I did this because a lot of y'all have followed it. Do we have anything on the Delphi? Are they still out? Oh, Giuliani or Giuliani, thank you, appears in court over failing to turn over his assets to the bankruptcy fight. He got a tongue lashing in federal court after missing a deadline to turn over valuables to 2 election workers he defamed. Guess what? He drove one of those assets to go vote, including one asset, a vintage Mercedes. Oh, there it is, which he took for a drive to go vote in Florida. He owes the woman, someone stated, the U.S. District Judge Louis Lyman, upon being informed that Giuliani is the only person listed on the document who has knowledge of his assets and that he wants his name removed. Okay. So he's not being obedient, and he's going to get contempt of court if he doesn't get his act together. I mean, you're going to go vote driving an asset that belongs to somebody else now by court order. I'm like, dude, seriously? Anyway, I don't know what's going to happen tomorrow. Tomorrow is Friday, y'all. This week has gone by too quick. Too quick. I have an interpreting job tonight, and then tomorrow's Friday. I don't know what we'll do. I may just take the day off. We'll see. We'll see what pops up on YouTube. I'll do some research, see if there's anything to do. I'm trying to save as much as I can concerning Sarah Boone till, in a blink. I'm trying to save up Sarah Boone's information because I got a bunch for Sunday Night Live. And we're going to have the alternate juror, or AJ, on as a special guest. I'm excited. I look forward to having guests on. So what we'll do is we'll do that. Okay, guys, with that, I'm going to bid you a farewell. Have an awesome day. I look forward to seeing you sometime tomorrow. Bye. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.